Good morning. Good morning. Good morning, my friends, and welcome. And thank you so much for choosing to spend your Thursday, July 25th with me, 2024. I know you have lots of options, places to watch your trial coverage, and I'm so proud and happy that you choose to spend it with me. Welcome to day 3 of the Ashley Benefield trial. There has been so much testimony and so much information packed into only 2 days of trial that I just can't even believe it. Has anybody ever seen a trial move so quickly with so much information to absorb than this trial out of Manatee County, Florida? The courthouse is in Bradenton, and Jules, our court watcher, is going to call in at lunchtime. So if you have any questions for Jules about her observations in the courtroom, save them for lunchtime because I sent her the StreamYard link and she's going to call in. For those of you who don't know who Jules is, she was nicknamed the Notorious Jules during the Maya Kowalski trial because she does live in Florida and she loves to go to court. She's a court watcher. She's a fierce advocate for a lot of women and girls. And we love her because she's just another strong woman on this channel that hangs out. So look forward to that. I want to show you something that I saw that kind of disturbed me a little. So, I always come to you guys to see if you think I'm overreacting. So let's see if you think I'm overreacting. This was something that was posted yesterday. So I don't know if this actually aired yesterday on Court TV. Let's take a look at this together and ask ourselves, are we actually in 2024, or have we taken a step backward? I want to know what you think. So let's watch this together and let me know what you think.
The scales, defendant Ashley Benefield in the Black Swan murder trial looked a little different. Take a look at her in 2023 in the box on the right there for a motions hearing. That's how we saw her in all those hearings, very formally dressed in suits and blouses, her hair all done and blown out and styled. And then on the left side was her yesterday for the start of her trial. Her hair in braids. She had on a more casual look, wearing a sweater. Is this by design? Did a jury consultant tell her to do this to perhaps tip the scales in her favor? Let's bring in now a jury consultant and
Okay, I just want to say that the picture of her on the right side is very similar to the outfits that Karen Reed wore to court and took so much heat over. Do you remember? Do you remember Karen Reed's outfits? Karen Reed is very well dressed. She's very successful. She makes a lot of money, or at least she did. I don't know if she's been able to work since she's been dealing with this pretrial stuff for over 2 years. But listen to what they say about Ashley Benefield now, because now they're going to take the opposite position. So listen.
Tell her to do this to perhaps tip the scales in her favor. Let's bring in now a jury consultant and a body language expert as well, Susan Constantine, back on the show. We've missed you, Susan. Welcome back. It's great to see you this morning.
Nice to see you too.
What do you think? Is this by design?
Yeah, I think it is by design, and I think it was a poor design. So I like the before, then I like the better than the after. So
I would love it if anybody knows if this body language expert, and I usually like her, I usually think she's pretty fair. If she did any critique of Karen Reed's look and clothing, I would love to know that. Yes, exactly. Why are men never subjected to this? Kev, I would love to know that. But let's listen, because it gets better or worse, depending on your outlook.
We're looking at her appearance as she's going into the courtroom today. She looks like a PTA mom. I think that was intentional. The problem is that
a PTA mom, as if that's disparaging, right?
She looks very tired, dark circles, hair pulled back, lots of skin. We've got the icy blue, which tends to look more serene. And I do take it.
Is it possible that she's really tired? Is it possible that she shot her allegedly abusive husband almost 4 years ago and that she just might be really tired being a single mom of a young girl? I don't know. Is it possible, or is it intentional? Did she put black eyeshadow underneath her eyes to make her look Like she's got bags under her eyes to what? To garner sympathy? This is so outrageous to me, but let me know if you think I'm overreacting.
Into account color psychology and what it does emulate. But on the other hand, the other way really is more about her. She's a, former, she's a dancer, right? So she's a ballerina. I don't think that this does her any justice. I think she looks very pretty. Don't get me wrong. It's kind of like, tomato, tomato. I prefer the before than I do the after. That's what I would recommend. She looks so much nicer. And and her appearance looked great. So why did you change it?
Right, Susan. That's really the $1,000,000 question. Why change it? I mean,
Is it the $1,000,000 question, Julie? Because Julie, you've done nothing but trash Karen Reed during the entirety of her pretrial. But now you're saying Ashley should look prettier in court? Yeah, is this a fashion show or a courtroom? I can't even believe that is this turning into, I can't even say the Today Show, because I think the Today Show is a little bit more classy than this. But oh, look, we have 1,111 people in the chat right now. Those are angel numbers. If you know, you know. Everybody make a wish at 1111. And everyone hit the like button, because if we had 1,111 likes, that would be really cool.
she looked lovely. She looked very polished, very professional. Nothing that would distract either. I remember seeing she would have on lovely looking blouses and suit jackets and just look very put together, showing a lot of respect for the court system. The braids could be potentially even seen as a little bit disrespectful to the decorum that needs to be maintained in our justice system.
What?
I have
Did she just say that the braids could be disrespectful to the decorum of our trial system? Oh, wait a second. She did not either just say the braids could be disrespectful. How are we supposed to dress in court, Julie Grant? Wow.
Blouses and suit jackets, and she looked lovely. She looked very polished, very professional. Nothing that would distract either. I remember seeing she would have on lovely looking blouses and suit jackets and just look very put together, showing a lot of respect for the court system. The braids could be potentially even seen as a little bit disrespectful to the decorum that needs to be maintained in our justice system. I have a video, Susan. I'd love to have you analyze her body.
How are braids disrespectful to the decorum of our court system? You know what's disrespectful to the decorum of our defendants who are supposed to be innocent until proven guilty? This kind of trashy coverage that belongs on TMZ. And I'm not even trashing TMZ because I like TMZ every now and then. This is just catty, mean girl talk. I can't even believe this.
Body language, if you would, please. This was at a point where Doug Benefield's cousin Tommy was sworn in, first witness up. And if we look closely, we see what we noticed is kind of jittery eyes initially. And then she starts kind of looking down and scratching her face. Let's take a look here, see if anything kind of comes to.
Because creepy cousin Tommy was hitting on her, according to his text messages. Creepy cousin Tommy was all over her, telling her she married the wrong Benefield, trying to get with her. And he was on her side, by the way, after she filed protective orders against his cousin, Doug Benefield.
Remind it what may be going on in Ashley Benefield's head.
Maybe she's scared to death of her abuser, her late abuser's husband. Is that a possibility?
Here.
Sure. So when you're looking down, that's in kinesthetic. That's the emotion part of us, right? So she's doing a lot of reflection. She's thinking internally. That's where our emotions are. When you see the blinking, that's what we call, that's anxiety. So it's not cognitive load. It's just that there's something that she's thinking about that is creating some sort of stimulus. So that in itself is telling me that there's something that's bothering her, but she's not really verbalizing it. Head down, not making.
Could it be that she's on trial for second-degree murder? Could that be what's bothering her?
Making eye contact. Is she's kind of internalizing, she's separating herself, she's not making eye contact, which is probably not a good thing. I think that.
Really? It's called disassociation. Have you heard of it?
For her, again, her image beforehand was so much better. So I'm going to share with you that if you're watching me out there, defense team, you need to shake it up a little bit. That's not really her best look. I'd change it up, go back to what was working. This other expression is not working for her. So you're
telling the defense team they should change it up because this look isn't working for her. Okay. Right, exactly. Cam, exactly. You're educated on law. This is what you're saying.
In deep dialogue. internally processing, lots of emotion going on, and it's being seen through that rapid eye blinking.
Definitely. I'd be watching you and listening to every word you're saying, Susan, if I was on that defense team. I've got another clip for you, please. This is where we've got Eva Benefield. This was so sad. Doug's daughter from his first marriage, his first wife passed away.
Bye-bye to them. We're going back to court.
Of matters before we get started.
Day 3, my friends. This is Judge Whyte.
Yesterday, I had brought up that an anonymous reporter had come up to the 9th floor and spoken with the deputy who's there at the desk with some sort of information. This morning, 5 minutes ago, I was provided a letter from a law firm in West Palm Beach dated yesterday. It says that it was sent to the state and the defense. Did you each get a copy, State?
Yes.
I did, and I responded late last evening, Your Honor, and a copy of Your Honor's chambers as well as Suzanne.
Yes.
Oh, I don't have those responses.
He just said, thank you for sending it. I said I didn't get an attachment and realized I was looking at the wrong email.
I thanked them. I told them it was worthy. of
They
all
did
the
say that,
court's
Sinbad.
attention, and that I was confident Your Honor would probably conduct a hearing as a result.
That's what I'm doing. Do you want to be heard on this, State?
No.
Mr. Taylor,
Defense? Do you want to be heard on this?
Yes, I'd like the court to question the jurors individually. I don't know, like the lawyer said, whether or not the potential juror heard it. I have every confidence the court can do it delicately and first find out if which juror, if any, was exposed to that, and then find out if they heard anything that had any impact at all upon the perception of the case, and that was extrajudicial in the sense that it was a reference to something that had not been introduced in the court.
All jurors or just male jurors?
Judge, I would suggest respectfully all the jurors, and I think.
Even though the letter says it was a male juror?
Yes, because that's what this anonymous source said. But I think to be safe, to the extent there was some jurors in this location, there's limited places to go for lunch around here, Judge, so I potential that there could have been other jurors there as well. And rather than run the risk of not knowing, I think a simple inquiry by Your Honor would put that to rest.
State?
And Judge, I would just recommend that maybe we ask the group these general questions, and if anybody says that they've heard anything or seen any news or heard you talking, then we can talk to them individually, because these people may not have had any information. And then we spend time doing an individual on that.
The concern with that is, in my experience, respectfully, any juror that was exposed to that may be very anxious about acknowledging it.
All right, thank you. I'll bring them in individually to ask about that.
we don't know what the letter
Of course,
said.
we've already discussed Dr. Quintel when we came back from a recess. He was approached by a reporter in the hallway while he was in the middle of testifying, but on a recess, asked if he could be, the reporter asked if he could ask questions of Dr. Quintel. Dr. Quintel said no, and the reporter gave him a card. That's my understanding.
He didn't take the card, though, he said.
Anybody want to be heard on that?
Did not take it. The card.
Do you want to be heard on that?
I'm sorry, I just wanted to add that Dr.
All right.
Patel did
Do you want to be heard on it, though?
No.
After hours yesterday, I was contacted by judicial security and notified that a witness who testified and had not been released from subpoena, and again, this is second or third hand, and it's my understanding both parties have been made aware of this, was being interviewed by a news channel reporter in the hallway outside of the courtroom. When deputies were locking up, someone told them that this was going on. I don't think the deputies actually saw it, but it was reported to them.
And Judge, I spoke to the witness and there was a discussion with the media, but nothing was talked about what was going on in the trial or testimony or anything like that.
So we're just going to take your word for it?
Not to do that anymore before the trial's over.
This is the first I've heard of that, Your Honor. I wanted to know who the witness was.
The reason I didn't speak in specifics is this is all hearsay within hearsay within hearsay.
I understand.
It was reported that it was Eva Benefield gave an interview to a reporter from News Channel 8.
Give me a moment, Your Honor, please.
Well, that's interesting. We were talking about that yesterday when we were wondering if Tommy was still under subpoena, and he went on court TV.
I believe she's under state subpoena.
Yes.
And did the state request that she remain available under the subpoena?
Yes.
Okay. I think perhaps a hearing may be
All right.
And
This is Doug's daughter, right?
the state would not be opposed to a hearing. I
There's
can
Jules.
represent that this particular witness did not speak about anything that was prohibited by the rule of sequestration. No one said to this witness, you're not allowed to talk to anybody about the case, just your testimony and the witnesses in this trial going on right now.
I disagree.
All right. Go ahead.
So, not to compound it, but to the extent we're doing housekeeping things now, we also have an issue, Your Honor, with an impeachment witness to Stephanie Murphy, specifically Faith Brown, who is representing Ms. Benefield during the same proceedings. She was not on our witness list, but given the testimony of Ms. Murphy, we are going to have her outside this afternoon, and the court may want to conduct a Richardson hearing as to that. So just for planning purposes.
All right. Do you understand that Faith Brown may be called as a witness?
Yes.
All right. I wasn't going to get too involved in the Richardson hearing yet. It needs to be done, obviously, and I've got a note for that. All right. So on the Eva Benefield potential interview with someone at News Channel 8, you're not asking for any relief.
No.
I don't know what relief you're going to ask for, but if you're asking for some relief, I'll let you get started.
Well, the relief I would ask for initially is that she obviously be barred from being called as a rebuttal witness, potentially. Secondarily, to the extent the court admonished her about doing exactly that which she did, I've observed thus far the court's general admonishment that it gives to witnesses. I'm assuming Ms. Benefield received it as well. Is she in the courtroom, by the way? Ms. Benefield?
Here she is, yes.
Yeah, I'd like to have her step out.
She's
All right,
sitting
ma'am, if you
there.
please remove yourself from the courtroom.
Eva Benefield is sitting there while they're talking about her. So if you're tuning in late, the court received a letter from a lawyer. I don't know if this is the same issue, but apparently this is something else they heard through hearsay. I don't know what the lawyer letter said. Is this the same issue? We might have to go back and rewind later. But Eva Benefield gave an interview yesterday in the hallway of the courthouse to a reporter from News Channel 8. And it was brought to the court's attention And now the defense attorney is saying that's in violation of her being under sequestration because the state actually was the one who said they wanted to keep her under subpoena. And so now the defense is asking that she be banned from the courtroom for the rest of the testimony, which we discussed she's allowed to stay in the courtroom under Marcy's law, which is a law that protects the family members of victims in criminal cases. And now the judge is going to decide what to do about it. But during their conversation about this issue, Eva was sitting in the gallery and the judge just asked her to leave. So that's where we are right now. And I was saying this yesterday, Gina. Oh, she posted it on TikTok, Mindful BG. Oh, that's not good. Oh, that's not good.
This is a young girl who lost a father. I'm not looking to hurt her, but given her disregard of the court's admonition, I think precluding her from being called as a rebuttal witness at a minimum would be appropriate. Whether or not the court feels any further sanctions are appropriate as a result of her disregard of the court's warning, I defer to you on.
Did you want to be heard at all?
Judge, I would just dispute that she violated exactly the court's order. And if she does testify, she will testify consistently with what she has already testified to in a deposition. So counsel will know if that changes, but we know what she's going to say because she said things already in the deposition. So I don't think any potential harm has come from this.
Rebuttal? All right. Whenever we talk about having a hearing,
Okay, before the judge starts to speak, that is Jules, our courtroom watcher, sitting right there on the right side of your screen, sort of behind Ashley. So the defense has asked that she be precluded from being called as a rebuttal witness for the state. And the state says, no, we don't think that you should do that, Judge, because that's not in violation of your instructions to her Eva Benefield giving an interview to a reporter in the hallway yesterday after court. And then somebody said she posted it on TikTok. If anybody has that TikTok, you could email it to me at fanbase@mlittlaw.com. One of my amazing mods could post my email in the, oh, you sent me screenshots. Kate, look at you. So the defense attorney said, listen, she lost her dad. I don't want to make her life miserable. I don't think she should be allowed to sit in the courtroom. Well, he said in lieu of her not being allowed to sit in the courtroom, I'm asking that you ban her for being called as a rebuttal witness. Now we're going to hear the judge's ruling on this.
my assumption at the beginning of that was that it was going to be evidentiary and people were going to call witnesses and present evidence. Here's what the court knows. Someone told a court deputy that they observed Eva Benefield giving an interview to News Channel 8 reporter in the hallway outside of courtroom A after court had concluded for the day. At this point, I have no facts or evidence before me. I've got hearsay within hearsay as to something that happened.
You're gonna have to call Eva in then and question her, or someone can pull up her TikTok.
Yeah, so I don't.
I'll call it.
Well, I gave you that opportunity. That's what I'm saying is that if everybody wanted a hearing, then
Let's do it.
Right. Well, I took it for granted that the court would.
I'm not going to assume this is true.
Yeah. So court likes, I'll be happy to call her and we'll have a brief hearing.
It's up to you. All right. Can you call Miss Benefield back in?
They're gonna have to. I love this, Stephanie. Be the woman who fixes another woman's crown without telling the world it was crooked. That is
Just looking at the list, you have 3 witnesses left?
Yes.
All right. Do we expect to finish today with the state's case?
State's gonna rest today, you guys. This is one of the quickest murder
Come on in,
trials I've ever seen. How about you? That quote is attributed to Leslie Littlejohn. Oh boy, she's looking
Do we know
like.
which deputy reported the matter? No. Or any of the deputies in the courtroom that saw the conversation late yesterday afternoon? Do we know which deputy it was?
As I said, it was reported to me that some unidentified person told the deputy. So,
Give me just one moment.
are you the one that they told? Okay, right here,
We got him. We got the other
Mr.
witness.
Taylor. Apparently, it was reported to Deputy Racky.
Can I have a moment with the deputy?
Of course, State, you want to be present?
Just have to step into our office.
Oh, poor Eva. If you are just joining,
Ms. Benefield, I'll remind you that you are under oath. You can scoot a little bit closer to that microphone and just answer the questions in a loud, clear voice.
if you're just joining, Eva Benefield, the daughter of the decedent Doug Benefield the court has been alerted that after she left court yesterday, or at some point during the day, while she was still under subpoena, she gave an interview to News Channel 8 in the hallway of the courtroom. They're now holding a hearing to find out if that's true, because whoever notified the judge said he heard it from a person who heard it from a person. So it was hearsay. Now they're calling Eva Benefield to the stand to question her about giving that interview while she was under subpoena. It's called a Richardson hearing. Here we go.
Good morning.
You appeared yesterday and testified before Judge Whyte in this case, did you not?
I appeared on Tuesday and testified.
Tuesday. Time flies. At the end of your testimony, do you recall Judge Whyte instructing you about having contact with anyone because you were to remain under subpoena? Do you recall that?
I recall.
Okay. And you were here today because the state requested that you remain as a potential rebuttal witness.
Correct.
Now, what did you think Judge Whyte's directions to you meant?
Well, I was told I wasn't allowed to speak on any of the witnesses in my testimony while in the courtroom.
So, I'm sorry, did you finish?
I'm finished.
Did you realize that when you decided to have a conversation with the reporter?
Yes, sir.
All right. Tell us, if you would. I'm just trying to get an explanation. Tell us, if you would, what you were thinking that.
Objection.
Overruled.
Ask her what she said.
What you were thinking that you felt allowed you to do exactly that which Judge Whyte cautioned you not to.
I was caught off guard in the hallway when I was under extreme emotional distress after being here, hearing different testimonies about my father's murder. And when I spoke to the reporter, I made sure not to talk about any of the testimonies or anything that happened in the courtroom or my testimony.
What did you discuss with the reporter?
Just how I felt about the situation and who my dad's character was as I saw him.
When you say about the situation, you mean about the case, the trial?
Not about the trial.
What situation were you referring to?
My emotional state.
Okay. You post on social media,
I do.
TikTok,
Yes.
any others?
No.
Following your testimony here last Tuesday, did you make any posts?
I did.
Tell us how many?
3.
3. And tell us one at a time. Were all three of them on Tuesday afternoon, Tuesday evening?
One was on Tuesday,
And when were the other two?
yesterday.
Okay. And tell us, as to the first post, what was it about?
I said that I testified.
Okay. And did you have anything to say about your testifying?
I talked about it being on live television,
Mhm. What else?
that somebody back home was watching.
I assume you have copies on your phone?
I do.
You have your phone with you here today?
I do not. Not on me.
Where is it?
It's over in the benches.
In the bushes?
In the benches.
In the benches here in the courtroom?
Yes, sir.
With the court's permission, may she retrieve it so we can see exactly what it was that she posted?
Judge, I'm going to object. If he knows, clearly they have the post. So
Well, I don't know.
it's an invasion of her privacy to dig into it.
He doesn't know
I don't
what
if
they
it's on
said.
social media, but we started off talking about just speaking with some reporter, and now we're talking about a social media post. If you've seen it, and if she's violating the rules, let's just get it out.
Okay. I'm trying to find that out.
So so now it's a fishing expedition.
Oh, come on.
If you know a violation, let's talk about it. If not, let's just get moving. We got jury waiting.
Okay.
I understand
This is
that,
important, Judge.
How do I know? She's told us she posted 3 things. How do I know what it's about? What if one of them involved discussions that were inappropriate? How am I to know that? I've been a little preoccupied, and I don't do social media.
Sir, if you have specific evidence, let's talk about it. If not, you have a team. You've got 1, 2, 3 people in court right behind you. I don't know. Maybe they can look it up. But let's focus on what we know about as opposed to digging into speculation.
Then you're going to have to give him 5 minutes to go look at the TikTok. Come on, Judge. This could be a
Ms.
violation.
Benefield, when you had this conversation with the reporter in the hallway, were there any other witnesses around?
Yes. I'm sorry. Let me re-answer that question. None that testified.
Okay, so you're saying there were people standing
There
around,
were people
but
around.
none of the witnesses in this case?
No, sir. Not that I remember.
Did you talk specifically about the questions that were asked of you or the testimony you've given?
No, sir.
All right. Do you have any follow-up questions to my questions?
No, sir.
Do you have any follow-up questions to my questions? All right, Ms. Benefield, you can step back out. Did you want to call any other witnesses?
No, sir.
State?
No.
All right. All right, Ms. Benefield's out to the courtroom. Go ahead, sir. Do you have any argument? Do you want to seek any relief? You want to argue in support of any relief?
Yeah, I think she violated the court's admonition that the court routinely gives to the witnesses. And as a result, again, I have no personal interest in seeing the young woman suffer, but I do think violation of the court's admonition is sufficient to strike her as a potential rebuttal witness.
Judge, I think you asked her the relevant questions. I think the questions that you asked her are the admonitions that you gave her as a witness, and she did not break any of those.
Final thoughts? I'm certainly distressed that, let me say first, the media policy for the 12th Circuit prohibits the media from conducting interviews inside of the courthouse. It is my understanding that our media and public relations person met this morning or was going to meet this morning with the media to go over the
Basic rules.
administrative order again, because certainly I think the media is and should be aware of that administrative order and comply with it. The specific incident that we're talking about after hours yesterday, the facts that are in front of me are not that Ms. Benefield spoke about her testimony or the questions asked. But I also have not heard from the reporter, and I have not seen any tape or footage. At this point, I'm going to reserve on the request, and I'll make a decision. If and when she's called again, I'll make a decision at that point. You just have to remind me if we get there.
I'm satisfied, Your Honor.
Oh, they will remind you.
All right, next. Deputy, if you just start, I don't care about the order, just start bringing in the jurors one at a time, please.
Judges, Ms. Benefield, allowed back and forth.
Yes. Yes, but I'm going to give her an admonition.
Okay.
Just, if you tell him to just hold up for a second, she can come back in. At this point, I'm reserving on whether she can be recalled or not, but I think an admonition at this point is appropriate. Yes, Ms. Benefield could come in.
This court going to allow her to sit in for her testimony, knowing that she may be recalled. And the rule has been invoked.
Yes, under Marcy's.
He's going to allow her to stay in under Marcy's law. If you want to look that up, it's MARSY, Marcy's law.
All right, Ms. Benefield, you can stop right there. Ma'am, the court has ruled at this point that I'm reserving ruling on whether you're going to be allowed to be recalled as a witness or not in this case. I don't know if that's going to happen or not. I'll make that ruling down the road. But I want to admonish you about the instructions that I've given and the importance of those. They matter and they need to be followed. Do you understand? Yes, sir. All right, ma'am, you can retake your seat.
Wow. They're...
All right.
Okay. While we wait for the jury to come back up, let's look at the TikToks, shall we? We're here. I'm here. I've got it for you. So here's the, this is the day before.
Bitch, I've been hot since flip phone. Running this game for 5 years. Guess that's why my feet hurt.
Says, hey everyone, I testify in a murder trial tomorrow. Justice for Doug. And this is, wait. Hold on. This is from after her first day of testimony.
I just testified, and y'all don't know what it's like to have to testify in your dad's murder trial and know that your crush is watching you back home on TV. That's nerve-wracking. I just testified, and y'all don't know what it's like to have to testify in your dad's murder trial and know that your crush is watching you back home on TV.
This is yesterday.
It's day 3. Feeling good. Got our coffee. Fit check.
It says fit check. Day 3 fit check from the trial from this AM.
Fit check. Fit check. Catch me. Catch me. Yeah. Yeah. We're walking to the courthouse. And I don't know what's going to happen, but here we are. Yeah. Keep you posted. Love you. Bye. And action.
This is also from yesterday.
I told y'all that I was nervous about my crush watching me on live TV. Well, I literally told y'all, no, but in all seriousness, I cannot talk a lot about the trial right now. I will when I am allowed to. But a lot of people have been asking me about my jewelry, especially specifically this necklace. I think I wear it a lot because it's my favorite necklace of all time. But it's D. Ruel on. I'll tag her in the caption on Instagram, TikTok. She's a jewel. Oh my gosh, brain is actually fried from today and yesterday and the day before. I'm exhausted. But she's a jeweler based out of Charleston. All of her jewelry is amazing and beautiful and gorgeous, and I love it. And this is one of a kind, custom made, so she cannot make another one. She made the choker and all of the charms except for this one this one is from a different jeweler in Charleston. But yeah, if you go on her website and you go on her Instagram and her TikTok, you can see all the other jewelry she makes. She made this pearl chain earring for me, and I have a few other pieces of jewelry from her. I'm constantly getting jewelry from her because my art studio is in the back of her shop in Charleston. So if you're in Charleston, go check her out. But yeah, and then my other jewelry, this is my Oura ring, some bangles, and some permanent bracelets, and then I have this. It's like a Cuban link, but
She's
it's
23.
a hand
People are
holding
asking how
that,
old
and
she
then
is.
these two rings, this whole hand is from Goldbug in Charleston as well. But yeah, I can't really talk about the trial, even though I am dying to talk about it with y'all. Every time I leave the courtroom, I turn my phone on and I scroll on TikTok and I see everybody's comments, and it just makes me so happy. But yeah, now it's time to go figure out me and Margaret what we're going to wear into the courtroom, because that has been the most exciting part of our morning, every single morning this week. Remember how I told y'all that I was nervous
Okay,
about my
this
crush watching
is from 14 hours ago, and it says these are the trial shirts we made. By the way, go shop Ghost Cowboy. And her t-shirt says, "My dad was murdered, and all I got was this loose t-shirt brand," or something like that. But let's see what this one's about.
My gun don't make me beat it. I'm coolin' with my young niggas. A lot of cushion, lot of guns, nigga. You see us, you better run now. One is hot. My gun don't make me beat it. I'm cool.
Okay, so those are the TikToks. She actually posted 4 since the trial started, and I think she told the judge 3. So that might be an issue.
Good morning. The trial has started. It's jury selection now. As y'all can see, it's live on Court TV. You probably saw us sitting back there. Now I'm walking to my car to get something because I desperately need it. And we are vlogging today. They're starting jury selection. The court just ruled against a continuance, which is sick. I mean, I wasn't really worried, but I don't know. Sometimes there's always that question of whether or not they're going to or not. But yeah, he just kind of was like, yeah, no continuance. The trial starts now. And now they're doing it. Good morning. The trial has started. It's jury.
Yeah, so there's that. I don't know that the judge is going to look at the TikToks, but I think somebody should have. But this is something that they just found out as they walked into court. So for those of you who are just joining, we've already had a hearing with Eva Benefield, because apparently she gave an interview yesterday in the hallway to a news channel 8. Is that WFLA? And she was still under subpoena by the state, subject to recall. So she did get on the stand and admit that she made some TikToks. And you can let me know. I know that I don't want to trash the daughter. She's been through a lot. Everyone obviously handles grief differently, but I just don't think, in my motherly opinion, that was a good look. And I'm a little bit disappointed. She's 23, and it sort of made light of her father's murder, and I don't like that. So I don't like it. But now she's put that out there. She could potentially be cross-examined on it, so that's so sad. But let's not trash her. She's young. All right, now he's calling the jurors in one by one, because there's been a lawyer sent a letter to the courtroom saying that there was an issue with some of the jurors, that they may have overheard something or they may have been talking about something, and we don't really know what it is. But the judge said he was going to call in each juror individually and talk to them to decide if there's an issue here. So this begins the jury questioning. It was not 8 years ago. It was less than 4 years ago, Terry.
just grab that first chair. And could you please remind me which juror number you were?
15.
15. All right, ma'am. The reason I'm bringing about jurors individually is that this morning I was provided a letter from a law firm in West Palm Beach that claims to represent a news reporter. And the news reporter anonymously has stated that during the lunch break yesterday, the reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, 2 individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So I'm bringing everybody out to talk about, have you seen any news coverage? Have you heard people discussing the case? Received anything outside of this room?
No, sir. I go home at lunch.
State, do you have any questions?
No, sir.
Defense?
No, sir.
Thank you, ma'am. Good morning. Just have a seat right there. And could you do me a favor and remind me of your juror number?
20.
Ma'am, the reason I'm calling out the jurors individually is because this morning I received an email, a letter from a law firm in West Palm Beach who claims to represent a reporter. And the reporter has anonymously stated that during the lunch break yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, 2 individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So I'm asking everybody, are you familiar with that? Has that happened to you? Have you received any information outside of these 4 walls?
No, I have not.
State, any questions? Defense?
No, sir.
Thank you, ma'am. All right, good morning. Have a seat right there. That's just fine. Could you remind me of your juror number?
I agree. Why are the jurors not brought lunch in to the building? Like in every other trial that we watch, they order lunch, lunch comes in, they eat lunch. Why are they going out to lunch?
42.
42. Thank you. All right, ma'am. The reason I'm calling out the jurors individually is because this morning I was given a letter from a law firm in West Palm Beach who claims to represent an anonymous reporter. And the letter says, during the lunch break yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, 2 individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So the reason I bring everybody out is just to say, are you familiar with this? Have you heard of this? Have you been approached by anybody? Have you watched anything on TV? Anything at all?
No, Judge. Yesterday, a couple of us chose to just not go to the restaurant area, and simply because we saw some people out and about, and we just figured it would be best to just stay clear of all of that. And no, I have not watched or viewed anything on media.
Thank you. State?
No questions, Judge.
Defense?
None.
Thank you, ma'am.
The letter did say, or the information did say that it was a male juror. And we know there are only 2 male jurors in the panel of 9, 7 women, 2 men.
Just have a seat right there. That'll be just fine. And ma'am, could you remind me of your juror number for Monday?
35.
Thank you very much. Ma'am, the reason I'm calling the jurors out individually is because this morning I was provided a letter from a law firm in West Palm Beach. And they claim to represent an anonymous reporter. And here's what the letter says, essentially. During the lunch break yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, 2 individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So I'm bringing everybody out to say, are you familiar with this? Did you see any of this? Have you done anything to look at or hear anything outside of this courtroom?
I have not.
All right. State?
No questions.
No question.
All right. Thank you, ma'am. All right, ma'am.
Phoenix Rising says, I witnessed the vitriol toward Letitia's daughter Harley, saying she was trying to benefit from her situation when the kid made a few $100 to support herself. Harley had no one. Totally agree. I don't think those TikToks violated the court order of sequestration. She didn't talk about the testimony. She didn't talk about the trial. You know, she's 23. That's what this generation does, is post everything on TikTok. I'm more curious about what she said during that news interview. I'm going to see if I can find it. But if there's a violation of the sequestration order, there should be ramifications for that.
Have a seat. And could you please remind me of your juror number?
Just from the day when I was here on Monday.
Yes.
Number 21, I believe.
All right. Thank you so much. All right, ma'am. The reason I'm talking to each of the jurors individually is because I received a letter this morning from a law firm in West Palm Beach. And they claim to represent an anonymous reporter. And what the letter says is, during the lunch break yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, 2 individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So I'm bringing everybody out to say, are you familiar with that? Do you know anything about it? Or have you looked at anything outside of these 4 walls during this trial?
No, I'm not aware. The only situation I do know, one of the jurors, Ted, I believe mentioned he was out to lunch. And he mentioned that he did get it. He got up and left a restaurant.
Uh-huh.
But that's all he mentioned. He said he felt uncomfortable and left.
Thank you, ma'am.
Mhm.
State.
No
Oh,
question.
hold on.
Oh, I'm sorry.
No, you're fine. They just like in trial, they get a chance to ask their questions
Yes,
too.
no
State.
questions, Judge.
No question.
All right. Thank you, ma'am. All right. Good morning, ma'am.
Good morning.
Could you please remind me of your juror number
My original one or here?
originally?
29.
All right. Thank you. Ma'am, the reason I'm bringing everybody in individually from the jury is because this morning I received a letter from a law firm in West Palm Beach, and they claim to represent an anonymous reporter. And here's what the letter says. During lunch on yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, 2 individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So the reason I bring everybody out is to say, do you know anything about this? Have you heard anything about this? And also, have you viewed or seen anything outside of this courtroom?
No, I haven't. And I brought my lunch yesterday and ate downstairs on the table.
She brought her lunch.
State?
No questions.
No question.
All right, thank you, ma'am.
Interesting, though, how the reporter asked to talk to the judge directly yesterday and then instead went and got a lawyer and had a lawyer write a letter. That's interesting. This is what the reporter wanted to tell the judge yesterday, that at lunch, the reporter was in a restaurant and saw a juror there and heard some people talking about a witness's testimony, and a big screen TV was on, and thinks that the juror might have overheard it. But instead, the reporter got a Palm Beach lawyer to write a letter to the court. So that's interesting too. We're a little behind, so if you're head on another stream, please no
Hello,
spoilers.
sir. Can you please remind me of your juror number from Monday?
43.
Thank you, sir. The reason I'm bringing all the jurors out individually is because I received a letter this morning from a law firm in West Palm Beach, and they claim to represent an anonymous reporter. And here's what the letter essentially says. During the lunch break yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, 2 individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So I'm calling everybody out individually to say, do you know anything about this? Are you aware of this situation? And also, have you been following the court's admonitions? Have you been influenced? Have you seen anything outside of these 4 walls?
Yes, Your Honor, that was me at the restaurant.
Oh, it was him. He's admitting it.
I was getting my lunch to go, and I was keeping everything out of my view and wasn't looking at anything on the news. And I left immediately because I felt uncomfortable, and I haven't gone back to the restaurant. That's what I did. I ate my lunch in the park right out in front of the courthouse.
All right, sir.
He's being candid. He said it was him. I don't know if you could hear what he was saying because I don't know that he was in front of a microphone or found it, but he went to get his lunch at takeout someplace and he felt uncomfortable and he left and he went and ate his lunch in the park. So maybe no harm, no foul. Let's see what the attorneys, if the attorneys question him.
So when you said you weren't paying attention, was that to the television?
That's correct. I was not in view of the television at all, and I asked the business owner to pack my lunch to go so I could leave.
And did you overhear 2 individuals in that restaurant discussing a witness's testimony?
I did not.
State.
No question.
No questions.
Thank you, sir.
Well, that was the right thing to do. So I guess they're going to let him stay.
All right. Hello, ma'am. Can you please remind me of your juror number from Monday?
38.
38. Thank you.
What was the number, Judge?
38.
Thank you.
Ma'am, here's why I'm calling everybody out individually. This morning, I received a letter from a law firm in West Palm Beach, and I want to talk to everybody individually. And they claim to represent an anonymous reporter. And the letter says, essentially, during the lunch break yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, 2 individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So the reason I'm calling everybody out individually is just to say, do you know anything about this? Have you heard anything about this? And have you seen any news or anything outside of these 4 walls about this case? State? No?
No question.
Defense?
No question.
All right, thank you, ma'am. All right, the jury's out. State, do you want to be heard on this issue? Defense?
No.
All right, the letter that I received from the law firm is going to be filed in the court file.
Had some knowledge confirming his story.
Oh, we can hear what he's saying.
Okay.
He requested the TV be turned off.
That he requested it.
Yes, sir.
Okay. The deputy has informed me that somebody in the audience was at the same restaurant.
Oh, Jules, was it you?
And again, this is hearsay within hearsay. Would confirm that the juror asked for the television to be turned off.
Yes, sir.
Does anybody want me to find out who that is and have them brought forward? State?
Give me just a moment.
All right. So is there anything else we need to take up before we get started with today's case?
Hot mic, yeah. Hot mic. I could hear him saying, there's somebody in the courtroom who told me they were there and they saw that he left and asked them to turn off the TV. Probably Jules.
Okay. All right, let's go ahead and bring the jury in.
All right. We were a little bit behind, so we have a chance to catch up. Wow. Well, that's already been an interesting morning, and it's only 9:48 here on the East Coast.
No one's talked with anybody else.
And here's, I mean, just let's listen to what he says to the jury.
Confirm that, kind of talked about this individually just a moment ago, but that no one has talked amongst yourselves about the case or began your deliberations. No one's talked with anybody outside of the jury about this case, and no one has done any research on the people, places, things, or legal topics we've heard anything about. All right, everybody says no.
When we left off yesterday, the state was still presenting its case. State, call your next witness.
State called Sergeant BRIIAN QUILES.
Okay. Usually I pass through those, I fast forward FF through those instructions or those questions that he asks the jury every time, but I thought we'd listen to it this time since it became relevant today. The state is expected to rest their case today. So here they have 3 more witnesses, they said. Here's the first of 3.
He said, just make yourself comfortable in that chair, get about 12 to 15 inches from the microphone. It does adjust up, down, left, right. There you go. And if you just speak in a loud, clear voice right into it, it should be just fine. If we hear you breathing, you're too close.
Okay.
Good morning.
Good morning.
Please state your name and spell your first and last name.
BRIIAN QUILES, BRIANQUILES.
Where do you work?
Manatee County Sheriff's Office.
How long have you worked there?
About 19 and a half years.
Another Brian.
What is your current position with them?
I'm the supervisor of the Technical Services Unit.
And you're, I don't know if I said this, you're a sergeant?
Yes.
Okay. And what is the Technical Services Unit?
It's a unit that gets involved in the technical aspects of criminal investigations. One of the responsibilities is downloading data from cell phones and analyzing that data.
And prior to your current position, what positions did you have at the Sheriff's Office?
Several. I started on the road, moved over to a cops unit, eventually moved over to the Special Investigations Division as an undercover detective for a couple of years. After that, there was a position involved in, again, technical aspects of investigations. It just wasn't called the Technical Services Unit at the time. And that's until I did that position for a number of years until I was promoted, and eventually the Technical Services Unit started, and that's when I started supervising that unit.
And what training and education do you have to do your current position?
I've had probably over around 800 hours of various technical training, some related to cell phones, some related to technical surveillance, but roughly 800 hours of total training.
Okay. And I want to talk about specifically cell phones and how you deal with those. So how much training would you say you've had in cell phones and analyzing cell phones?
It's probably a third of that 800. So around 250, 260, something like that.
Okay. When you do what I call a forensic examination of a phone, what do you do? Just briefly.
It's really a case-by-case basis. There's each phone, it's somewhat of a research project. There's so many variables, but ultimately that phone will get plugged into a forensic workstation. Software would be used to be able to download or extract that data from that cell phone. And that same forensic workstation will use software to be able to decode or parse that data to be able to review it.
When you download, I call it dump, a cell phone, when you dump the information from a cell phone, is it voluminous?
Yeah, it can be. Yes, it's quite a bit.
Okay. And is it easy to interpret without help?
No, you definitely need a certain expertise to be able to look at it. You need software to make it a little bit more of a convenience to be able to look at it, but definitely need some assistance to be able to do it.
And do you have programs, software that helps you with that?
Yes.
what are the names of the ones you use?
Our main state program is Cellbrite. It helps us extract the data. If it needs to bypass encryption and bypass locks, it'll help us do that as well. There's other programs that we use, Gray Shift, excuse me, as well, to be able to unlock the data and extract it. We have toolkits that I like to refer to of data or of software to be able to use.
And
Celebrate has entered the chat. Celebrate has entered the chat. Is there fighting going on in the chat? What is going on? I'm not watching the chat because I'm actually watching the testimony. So let's all be nice, huh? Let's be kind to each other. If we can't be kind to each other, let's go find another channel to watch. Yeah, did he have more training than Trooper Paul? I can't remember how many hours Trooper Paul had in the Karen Reed case, but he's at about 800 hours.
give me a general idea of how many phones you've done this with.
Me personally, hundreds. I want to say the unit as a whole has steadily done 200 to 300 leading up to about 2002. And that has increased probably closer to about 500 devices for this year alone, I'm pretty sure.
Okay. So the unit 500 devices for this year.
Yes.
And when you use software like Cellbrite or Gray
Shift,
does it allow you to put whatever data you want, for instance, pick out what you want and put it in an easily readable form?
You can filter the reports that the software displays. And if you only want it to include messages, you can create a report with just those messages. Sure.
So for instance, on just your average cell phone, if you did a cell phone dump, you would get messages like text messages.
Yes.
And emails.
Yes.
Internet searches.
Yes.
And all different things that would be on your phone.
If those data transactions exist on the phone, you will typically get those. Yes.
Okay. So this software allows you to pare that down to what you want.
Yes.
In the instant case where you asked to do extractions on 2 phones.
Yes.
And I'm going to show you what's been previously entered into evidence as States Exhibit 11 and 12. You can take a look at both of those. Can you tell me what those are?
These are the 2 cell phones that I had done examinations on. One of them belonging to Doug Benefield, the other one belonging to Ashley Benefield.
All right, now the chat is distracting me. Who's causing trouble in the chat? I didn't dox her by showing her TikTok. That was the subject of the hearing, were the TikToks. So they're perfectly acceptable to show. They're public. She's 23 years old. Nobody's trashing her. We were trying to figure out why, if she violated the court order by what she posted in the TikToks. I don't think she did. So we're not afraid to use the block button here. If someone's annoying you, block them till the mods can get to it. Thanks.
And is that the evidence tag that's on there? Do you recognize that?
Yes.
And does it have your information on it?
Yes, it does.
Okay. So did you go through the process that you just explained with both of these phones?
There were differences in the process, but ultimately we were able to get a path to data and produce a report for that data.
Okay. And which one were you able to extract first?
Doug's phone, we were able to extract first.
Okay. And then were you able to extract data from Ashley's phone?
We were able to eventually. It did take quite some time.
Okay. Why did it take quite some time?
That phone, it was passcoded, or it had a PIN code. I want to say it was a 6-digit PIN code, and the software, it took a long time to actually bypass that encryption or that PIN.
Okay. So if you don't have the passcode or a way to get into the phone, your system can do that?
Yes, It varies in length of how long it could take to bypass, but yes, the system allows for that.
Okay. And you called one of those, Doug's phone and one of those Ashley's phone. When you do extractions of the data, do you get information about identifying who owns the phone?
Yes.
And can you just explain what that is?
Yeah, a lot of the times, especially with iPhones, you'll have an Apple ID that could be associated with the person that owns a phone. In the contact information, it'll have the owner's information, so it's pretty easily identify who that phone belongs to, especially with iPhones.
Okay. And the one phone, I'm not sure if it's 11 or 12 that you said was Doug's phone.
12.
12. Did that have identifying information on it?
Yes.
That identified it as Doug's phone?
Correct.
And then for Ashley's phone, same question?
Yes.
Did you prepare a spreadsheet for this case?
I did.
And what is on the spreadsheet?
It was communication between Ashley and Doug extracted from Ashley's phone from September 20th of 2020 until September 27th of 2020.
And when you say communication, what do you mean?
In that particular report, it was mainly text messaging back and forth. There were a few phone calls and I want to say at least one email, but mostly text messages.
Okay. And you said you prepared.
So this is the week leading up to the shooting, 9/20 to 9/27, 2020. The shooting was 9/27, 2020. And thank you, Melissa Roberts, for the compliment. I appreciate it.
Prepared the spreadsheet from Ashley's phone. Did you also look at the information from Doug's phone to compare that information was on his phone as well?
Yes.
Okay. And was it?
Yes.
I'm going to show you what's been marked as State's Exhibit 98. You can tell me if you recognize that.
Here's the voice of reason from Elle.
This is the CD containing the.
Elle says, people were just being a little aggressive towards Eva. It's unacceptable. She spoke to a reporter. Agreed. Regarding the TikTok, she deals with grief, with humor, and she's lost both parents. Her maturity has been affected. Yes, let's not attack Eva. We're going to talk about the behavior, not the person.
The Excel spreadsheet that we just talked about.
Okay. And when you said there's communications between the two, if there were any attachments to those communications, would they also be in your spreadsheet?
Yes, they would. Yes.
Okay. And you looked at this
Yes.
disk, and is it accurate based on the spreadsheet that you created?
Yes.
State would enter into evidence States 98.
Any objection to State's Exhibit 98?
No.
Received.
So I'm going to publish the spreadsheet now. If we could turn down the lights and potentially, it's a little difficult to read, potentially shut the blinds. Okay, so I know this is very small, at least from where I'm sitting. I don't know if I have handed you an exact copy, a hard copy. So I don't know what is easier for you to read. I know that print is very small as well.
Sorry, Mr. Dunn. Can we approach for just-
Sure.
Okay, we're going to look at some text messages now, maybe up on the big screen. They're having a little sidebar. People, if you don't know why Ashley's wearing headphones, is so that she can hear the conversations that are sidebar instead of having to walk up there every time. Yeah, let's move on from Eva, please. Thank you.
Are you going to read from the one in front of you or the one behind you?
I'm going to attempt to read the one in front.
Okay, because I can try and make this a little bigger once we get through what we're looking at. So I have a laser pointer for you. So the red button is yours. And I have one as well. I do want to talk a little bit about these attachments that are on the phone or on this spreadsheet. Are you able to tell when you look at one of these attachments where that image or picture or video came from?
It depends on each attachment. There could be metadata there that the attachment could have been from a screenshot. It could have been from the actual phone, taken with the actual phone. So it just, again, case by case basis.
Okay. So there is a video on this phone that, and I just want to draw your attention to it, that shows some people at a restaurant. Do you know
Say
what I'm
goodbye,
talking
Dan.
about?
Bye, Dan.
No.
Everyone say goodbye to Dan.
Let me hold on one moment and I'll let you know which one it is. It's line number 25 on your spreadsheet.
And just for the record, people are here because they like my opinions. They like that I'm not a neutral channel. They like that I have the experience of being a mother of 5 and a trial lawyer with 30 years experience representing victims and survivors of all kinds of horrific things, including clergy sex abuse against the Catholic Church, which was the most noteworthy cases that I handled, and victims of all kinds of things and survivors. We have many, many survivors in this chat. And so for you to come in here, Dan, and say that I have no business giving my opinion, you can go watch other channels with, robot voices, or you can watch somebody who just puts their face on the screen and plays the coverage and does nothing other than rebroadcast someone else's coverage. And maybe that's where you belong. Okay. Okay. Bye. Ta-ta. Not tolerating it.
Can you tell from what you're looking at where that video came from? Or do you recall from your investigation before where that video came from?
Based on what I'm looking at, it's an attachment from a text message from Doug Benefield to Miss Benefield.
Okay. And when you looked at Doug Benefield's phone, could you tell whether this movie was taken on his phone or sent to his phone?
I don't have a recollection of the actual metadata of the video itself on either phone. This is just looking at it from the attachment perspective, not the specific video itself.
Okay. If we could approach Judge.
Let's see the video. It's too early to have this kind of like ridiculousness in the morning.
Let's talk about what we're looking at first, and then I can try and make this a little bigger so people can see it. All right, so the first column just has the number of the entry, correct?
Correct.
Okay, and the second column is what?
It's just the type of entry it is.
And give me a couple of examples of the type of entry that it is into the phone.
In this timeline, it's labeled as an instant message. If it was a phone call, you would see phone call. If it was an email, you would see email.
Okay. And what does instant message mean? Is that a text?
It's a text.
Okay. And then the third column is what?
It's the direction of that transaction. It's specifically dealing with messages, whether it's incoming or outgoing.
Okay. So that would be incoming or outgoing from Ashley Benefield's phone.
Correct.
All right. And then the next column?
It's whether or not that data transaction has an attachment.
Okay. And then the next column?
It's the date.
And the next?
And it says time, but it also has the date and the time in the correct time code and time zone.
Okay. You said correct time zone. Can you explain that real quick?
So if you see UTC -4, UTC is what's considered standard time for world clocks. The time where the prime meridian is in the world, you subtract from that and you come up with a time code or the time zone that you're in. We are currently in -4. We're technically -5, but because daylight savings times, we actually subtract -4.
Okay. So does your software do that automatically?
Yes.
Okay. So when it says at the first line, it says 8:20.02, and that says UTC -4. That is the current Florida Bradenton time.
Correct.
Okay. And then the next column. And I made it bigger on the screen if it's easier for you to see.
I can see it
Okay.
fine here. The party is
Mhm.
the people that are a part of the actual message.
Okay. And are these the labels, the names that are entered into Ashley Benefield's phone?
Correct.
Okay. And the next column?
The description, well, in this case, the first one is blank, but ultimately we'll have the body of a text message. Sometimes it'll be empty depending on the nature of it, but that's where the body of the text messages would be.
Okay. So the next column.
The source is just the software's way of saying if it was a native message or if it was taken with a third-party application.
Okay. And the next column.
The attachment is the actual file itself and the file name.
And then the last column.
I wish they would show us the columns while he's describing them so that we can have a visual of this.
Source file information has a lot of metadata where that file actually exists and file paths and size. And if you look at the table, all this information comes from databases, and it explains where or what table the database that this message or this data lies.
Okay. So let me move it back over. So after we get through this explanation, we'll move much faster. But the first message is what? If you could just explain to us what that is.
Item number 1 is listed as a message. It's an incoming message with an attachment, and appears there's no body to it. In other words, there's no actually text string. It's just the actual attachment itself.
And who is it from and who is it to?
It's from Doug to, I'm just going to say the name that's on the actual.
That's fine.
It says Ashley Christina.
Okay. And is this the attachment?
Yes.
Okay. And if you could just read for the record what that says.
It says, am I now trying to win the favor and approval of men or of God? Or am I seeking to please someone? If I were still trying to be popular with men, I would not be a bondservant of Christ.
Okay, wait. So this is a screenshot. I was distracted by the chat. This is a screenshot that Doug sent to Ashley. It looks like a biblical quote. Doug sent this to Ashley. Just correct me if I'm wrong. Am I now trying to win the favor and approval of men or of God? Or am I seeking to please someone? If I were still trying to be popular with men, I would not be a bond servant of Christ. We learned in the pretrial summary that I did that they were both, God was one of the things that they had in common when they met, God and the Second Amendment, according to the Vanity Fair article. And so they would frequently, I think, send biblical verses to each other. These are Doug's screenshots that he sent to Ashley. Thank you, thank you, thank you. Thank you, thank you, thank you. Okay. So it's not uncommon. They did this, I think, according to our pretrial summary, often. Moving on.
Men, I would not be a bondservant of Christ.
Okay. And then the next message is what?
Number 2 appears to be an outgoing message. It's from Ashley Christina to Doug Benefield.
And how much later than the first message is that?
About 2 hours, it appears.
Okay. And so from Ashley to Doug, and what is it?
The description says loved an image.
Okay. So she loved the image from before.
Correct. That's more of an action than actual writing something out.
Okay.
Yes.
She didn't
Yeah.
type loved image.
No.
The phone is saying that she hit some button.
Correct.
She hit a button, a heart. It's called a heart. Yuri's math teacher says, man, it's Celebrite's world and we're just living in it. Right. And here's another example. Celebrite is the gold standard of cell phone extraction. So as in the Karen Reed case, if all of a sudden Celebrate is going to be disregarded. It's going to affect a lot of criminal trials and a lot of defendants that are currently sitting incarcerated based on Celebrate data. So that was a kind of a dangerous door to open in the Karen Reed trial, but can't use it as a shield and a sword, I always say. For example, using Karen Reed as an example, you can't say the Celebrate data is wrong when it comes to Jen McCabe's phone allegedly searching Hostlong to die in cold at 2:27 a.m., but then say that all of Karen's text messages were accurate or her Google searches. Can't use it as a shield and a sword. Either it's accurate or it's not. Yeah, KDK. Celebrate's actually credible in this courtroom.
I love the image. All right. And then the next message is from right about the same time. And that says what?
Same time, that says good morning. There's another little icon after it, but it just didn't come out on here.
Okay. And then if you could just continue to read.
The next message, number
Right,
4?
the next
Okay.
message. Who, if you can just say what time,
Okay.
To and from, and then what the message is.
So the next message sent around the same time, 10:36 a.m. It's from Doug to Ashley Christina. It says good morning with a few emojis. Then the next message after that, there's appears to be an attachment.
It's too small to read, but this is September 20th. This is 1 week before the shooting. He's texting her good morning.
And that's at 11:43 from Doug to Ashley Christina.
And what is the message right after that? Oh, I just went too far. Right after the attachment, I'm sorry.
Right after the attachment?
Yes.
It would be number 6. It's a message at 9:20, 11:43 from Doug to Ashley, and it says "Run, baby, run" with a few emojis.
Okay. And so now I'll just play the attachment.
It's a video of their child. That's why they're not showing it, I assume.
Okay. So Doug says, "Run, baby, run" to Ashley. And then what does she do?
That would be number 7. It's a instant message right after. It's at 12:16, and it just says "laughed at a movie."
Okay. And if you can just keep reading.
Number 8 would be an outgoing message. It's from Ashley to Doug. It's on the same date at 12:16 p.m. It's just a few emojis. They appear to be laughing emojis.
And you don't have to mention the times right now until it switches a large
Okay.
time span. So go ahead.
The next would be an incoming message from Doug to Ashley asking "ready to rock and roll." The next is from Ashley to Doug, "Give me a few LOL, trying to round up the cats. It's like trying to teach a ballet to squirrels." The next is an incoming message from Doug to Ashley, says "ha" with exclamation points. The next is
And we've established that it's all either from Doug to Ashley or Ashley to Doug.
Correct.
So if you can just say who's speaking and then the message from this point.
number 12 from Doug. He says, "That's funny." After that, it's from Doug. It says he's liked "give me a few." It's basically liking a previous text message, and it just repeats.
Okay.
The next is an outgoing from Ashley. It says, "OMG, I'm exhausted, LOL." The next is also from Ashley, "You can come over now."
Now, I didn't ask you about the color coding on this, but what do the colors mean?
It was just to make it easier to read which one was outgoing, and on all the outgoings, which is Ashley's phone, are Ashley's phone, and the incoming is the other color.
And so the outgoings are what color?
The outgoings are the blue gray.
Okay. Or
I'm sorry, blue gray. The outgoing is the orange.
the orange. Okay. So if Ashley's speaking, it's orange. If Doug's speaking, it's gray.
Correct.
Okay. So I believe we ended at OMG, I'm exhausted, LOL. Go ahead.
I believe I had stated the outgoing message, "You can come over now." Number 16 from Doug, ha, need to video the rodeo. Okay, headed that way. From Ashley, she responds, she liked what he had said earlier and just repeats. Incoming from Doug, I'm walking around to back. The response, I could let you in the front, or which, and then adds to that, whichever. He responds, okay, front good. She responds with a thumbs up. He responds, me and XS boxes arrived. She responds, LOL. He responds with a message that includes an attachment without a body. Then there's a call log, which is number 26. It's an outgoing call log to Doug for, I believe, 11 seconds.
Okay. And then let me scroll down on here. After the phone call, what happens? Oh, let me back up just a second. What time was that phone call?
Same date, 9/27/24 in the evening.
For those of you asking, that is not Larry, the DUI guy behind Ashley. It is not. Did someone say was he going to court? I didn't hear anything about that.
And then at 8:58 in the evening, that next entry, what is it?
It is a message from Doug. It says, good night, sweetie, theta waves with a couple emojis. I'll be done by 1 tomorrow and plan on joining the party. And then there's an outgoing, and then again, another action of just loving that, that previous text message. And then there was a response at 9:23 that says, good night with a couple emojis. Ha, you sure you want to come hang out with the slum, ? And 9:23, he responds, yep, be smeshin' at the slummin'.
Be smeshin' at the slummin'?
9:24, there was again an action of laughed at the previous message.
Okay, so that was at 9:24 p.m. and it looks like the next entry is at 7:36 a.m.
Correct.
And what is that?
That is believes to be an attachment without a body. It's a long string of characters, JPEG image.
And that came from Doug or to Doug?
That was from Doug.
And I'm going to display the attachment. You don't have to read all of this, but what is this?
Well,
just
I'm
another
going to read
Bible.
it. It's another Bible verse. There is no fear in love. Dread does not exist. But perfect, complete, full-grown love drives out fear because fear involves the expectation of divine punishment. So the one who is afraid of God's judgment is not perfected in love, has not grown into a sufficient understanding of God's love.
Verse.
So after the Bible verse, what is the next thing that happens?
She appears that she loves the image and then responds with good morning. He responds back with good morning with several emojis, and hours later responds with or says headed that way in about 30 minutes.
So that's approximately 3 hours later. He says headed that way in about 30 minutes.
Correct.
Okay, go ahead.
There's a response from Ashley that says, oh, hey, wow, you done for the day? Don't rush because of us. We're out for a walk now. Not in a rush to get started today, LOL. We'll have to round up the cats when we get home anyway. There's a response from Doug, oh, nice, a little breezy, which helps. Getting early start so can finish up early to come over and be with y'all and play W Emerson, typically shorthand for with Emerson, free y'all up some, just ping when good to head over. And Ashley responds with a like of that previous message and then responds with will do and also adds in a new text message, want to grab a can opener at Publix on your way over, ? LOL. I of course packed the one we had. He responds, ha, too funny. Yep, we'll get one. She responds, thank you, trying to get the cats, LOL. And after that, there's an incoming message, appears to be an attachment as well. And that was it.
Go ahead. Some of these attachments don't open on this computer. Can you explain kind of why that is?
I think that one of the previous videos that you had, sometimes it's a codec issue. The files are actually not necessarily embedded in the actual spreadsheet itself, but I can take this same file and bring it over to another computer and it might open. It just depends. It depends on the computer how it's set up to open that particular file.
Okay. So after the attachment, I'm trying to slide this back over. Let's see. Let me try to open this. Okay, so this is one that will not open. So I slid it back over. If you could tell us again, starting at 46, I believe it is.
Well, after that attachment, it's 45.
Or 45. Sorry.
And it's an incoming, says from Doug in the crazy loop at Gay, G-A-Y-E. And it's probably a misspelling because he corrected himself and put gate in the next message. There is a call log that has 0 seconds to it at 3:17, and then an incoming message walking around back, and then
So the walking around back is approximately what time?
3 o'clock in the afternoon, or
And then
3:21.
The next message is approximately what time?
9 o'clock at night.
And that message is?
Good night. And she responds at 9:22 with good night and looks like a sleeping emoji.
And the next communication?
The next would be an incoming message from Doug to Ashley. Appears to be an attachment, some type of JPEG image.
All right,
And you
another
don't have to
Bible
read
verse.
this, but what is it?
It's another Bible verse.
I'm going to read it. Stop. What do you mean you're not going to have him read it? We're reading it. Hang on. Let me get myself off of there. Let's get this off of there. For this reason, I am telling you, whatever things you ask for in prayer in accordance with God's will, believe with confident trust that you will have received them and they will be given to you.
And you don't have to read this, but what is it?
It's another Bible verse. I believe we're on, after that attachment, we're on 52.
Yes.
It is an incoming message from Doug. It says, good morning with some emojis. Hope you slept okay. She responded at 9:28. Loved the image, or loved an image, and also an additional good morning. Doug then emphasized the good morning, just another action that he took on a previous message. And the next communication was at 11 o'clock a.m. with a wave emoji, looks like. And at 11:22, he responds again with how's morning. She responds with also a wave emoji at 11:26, then says, good, the scramble to get all the loose ends tied up, LOL. He responds, no kidding, I'm done. Around 1, we'll head that way. Been going since like 3 a.m., LOL. She responds, OMG, 3, why is that? He responds, just to get work done so can pack. Love mornings, all quiet. She responds, ha, okay then. He responds, Spark is best friend, LOL. She laughed, another action for that message. And another response from Doug, finished up here, yay, headed that way.
And what time was that?
That was at 1 o'clock in the afternoon, 1:17.
And then after that?
At 1:19, she says, oh, take your time, no rush in not in a rush today. And at 1:20, a response, LOL, with an emoji. Think we all are getting pooped from the efforts. She responds with liked a previous message, and it just repeats. There's also a laughed at LOL, again, laughing at a previous message. Then another message at 1:36 says, can you think of anything we need at Lowe's or anywhere? Then there's actual call log at 1:42 that lasts about 49 seconds. And that was from Doug too, actually. And then at 3:30.
Hi, Mal W. I was just going to break to say this anyway. What are these texts meant to prove? I think that they're trying to show the prosecution that Ashley and Doug were getting along great a week before the shooting, and that Ashley was loving his messages and liking his messages and LOLing him and talking about the move. And so therefore she couldn't have been afraid of him. And therefore it couldn't have been self-defense. And then somebody else says, Kel says, these texts, in my opinion, help Ashley. He comes across extremely manipulative. And I highlighted a bunch of quotes from Craig, for example, who says, people who often recite Bible verses in conversations give me an uneasy feeling about their intention. So I think that's what the prosecution is trying to prove. I think it can be interpreted in the opposite way. So you tell me what you think in the comments or in the chat.
There's a message from Doug headed that way in a few minutes. I'd nothing need. And a message from Ashley. Alrighty, we are just out for a walk. Still can't think of anything needed at the moment. There's an action liked already, and the message repeats from a previous message. Doing front gate, I'm assuming circle, but CIRCL, and a call log from Doug to Ashley with 0 seconds.
I believe they lived, or her mom lived. She was living with her mom at the time in Bradenton. I believe they lived in a gated community. So I think that's what he's referring to. If anybody can confirm that for me, that'd be great.
Incoming from Doug, I'm here. And it looks like another call log for about 20 seconds.
And that's about, I'm sorry to interrupt. That's about what time?
That was at 3:56 in the afternoon.
And the next message is at about what time?
9:26 p.m. It's a message from Ashley Christina to Doug. It says good night with an emoji. And then after that, Doug responds, good night, precious girls. And after that, Ashley, again, an action of loving that previous response. And the next several messages appear to be related to attachments.
Okay. So the next attachment I'll put up.
Kate says, is there something I'm missing? Lack of arguing, so she's guilty?
These were from Doug to Ashley Christina.
And then in the middle of this, so it would be, I'm not getting the lines correct, but I think it's line 87 maybe, at 9:29:35.
9:29:35 is line 86.
Okay.
And that's another action of loving an image.
And there's one more attachment, I believe. Possibly one more after that. Two. So all of these attachments were sent from Doug's phone to Ashley's phone.
Correct.
Okay. And then there's a series of responses from Ashley. Can you tell me what those are?
It's the previous action that we've referenced where she physically takes it's not word that she's typing. It's just physically within the operating system of iOS, it allows you to take an action on an image. In this case, she loved 1, 2, 3, 4, 5, 6.
Okay.
6 images.
Okay. Let me get it back centered again. So after she loved the images, there's an entry where she types a message. What is
Yes.
that?
That's at 9:31 at night. She responds, "All these are sweet, thank you." And he responds with an action that he loved the previous message, and then responds with y'all rock my world with a heart emoji. And she responds again with an action of loving that previous message, and with it's a very small emoji, hard to tell what it is after the action.
And then what's the next entry?
The next is an instant, is a message with an attachment, and that's from Doug to Ashley at 6:47 in the morning.
I'm going to pull up the attachment. And again, what is that?
Appears to be another Bible verse.
And if you can continue.
So after, there's a message from Doug, says good morning with emojis. And then also an additional message at 9:28 that says, got an email from Stephanie after she talked to Faith. Since order to mediate will meet for 1 hour tomorrow. To stop court next week, you dismissed injunction. We sign joint stipulation to dismiss dissolutions and hold until Moreland signs. Order for report.
Okay, this is the first interesting I've heard in this text chain. All right. So Stephanie is Doug's lawyer. Faith is Ashley's lawyer. We're going to rewind this and hear the totality of this message.
With emojis.
And I wish we could know the date because I don't know if they're jumping around.
Doug to Ashley at 6:47 in the morning.
I'm going to pull up the attachment.
All right,
And again, what is that?
6:47 in the
Another
morning.
Bible verse.
Oh, now they're not going to show us the next Bible verse?
And if you can continue.
So after, there's a message from Doug, says good morning with emojis. And then also an additional message at 9:28 that says, got an email from Stephanie after she talked to Faith. Since order to mediate.
Okay. So Doug is telling her, I got a letter from my lawyer who spoke to your lawyer, who says we're going to mediation. We're going to meet for an hour tomorrow. Did anybody catch the date on this? If you did, just put it in the chat so I don't have to rewind. 9:28 a.m.
We'll meet for 1 hour tomorrow. To stop court next week, you dismissed injunction. We sign joint stipulation to dismiss dissolutions and hold until Moreland signs. Order.
Yeah, okay, so he wants her to dismiss the restraining order that she has against him. He's telling her, we'll go to mediation tomorrow. You'll dismiss the injunction, which is another word for restraining order.
For report. As soon as she signs order, we file dismissal and we're done. Looks like praying hands emoji and a heart.
And we're done. You dismiss your dissolution, meaning your petition for divorce. Did anybody get the date on this? Yeah, Doug wants her to stop court and dismiss.
Injunction. We sign joint stipulation to dismiss dissolutions and hold until Moreland signs. Order for report. As soon as she signs order, we file dismissal and we're done. Looks like praying hands emoji and a heart. And then there's
Who's manipulating who? Someone said. So he's telling her, we're going to go to mediation tomorrow. You're going to dismiss your restraining order. We are going to discontinue our petitions for divorce. Then everything will be great with prayer hands emojis.
an additional message after that. And we have joint session with Dr. Q Friday to wrap up our adventure in Florida, FL, and leave with understanding of double knots, and red-blue inversion.
Leave with our understanding of double knots and red-blue inversion. Does anybody know what that means? Is that a religious reference? He's trying to get her to Maryland, away from there. Dr. Q was the doctor who testified yesterday. He was, or the, I can't remember. I'm sorry if he was a doctor or a social worker that they were meeting with who sighed during his testimony. And then Mr. Taylor said, "Oh, you have no idea," and then got yelled at by the judge. He was that very nice man that spoke at the end. Just going to take that back a notch. If anybody knows what double knots and red-blue inversion means, help us interpret that.
And we're done. Looks like praying hands emoji and a heart. And then there's an additional message after that. And we have joint session with Dr. Q Friday to wrap up our adventure in Florida, FL, and leave with understanding of double knots and red-blue inversion. After that, there's an action by Ashley Christina that said, "Loved an image." And it continues with a good morning. And there's an emphasis by Doug of good morning. Ashley Christina responds, "Oh, okay, I'll reach out to Faith to follow up on all the above with a thumbs up." Doug takes an action about and liking that previous image, and then says, "And we're done." Again, praying hands emoji, and also responds, "And all in first 10 days of Jewish New Year, LOL." It continues with an action of laughed at the previous message. And then at 9:57, Doug responds, "You gotta laugh. September 18th was first day of Jewish New Year, 3 years to date of your Odyssey starting day of ballet launch, Rosh Hashanah, the first of the Jewish days of awe. We can call our Odyssey the days of all, LOL."
Okay, so this is the 23rd of September of 2020. And this was in the morning. So was this the morning of the mediation? And those texts we talked about just a minute ago were on the 22nd of September? This is the 23rd of September?
At 10:13, there's an incoming message, says from Doug, "So perfect outside." Looks like a sun emoji. Ashley responds with an action for those previous messages, which just repeats. And then writes, "Oh, yay, we should do Selby today." He responds, "Oh, yes," with multiple M's and yum. She responds with a few emojis. He emphasized the emojis and then adds, "Stephanie just sent Faith joint dismissal of everything except injunction, which Faith has to do, just one pager," and also responds, "What time thinking Selby?" Ashley Christina responds with the action of liking it, and then says, "Maybe 1:30-ish. I'll text you when we're headed that way," with a thumbs up.
So she's, oh, and then it says mediation tomorrow by Zoom, 10:30, and be quick. So this is on the 23rd. The 24th is supposed to be the mediation. And they're trying to indicate, I guess, that Ashley was going to discontinue everything against Doug because he liked his messages and or loved his messages.
He responds, or Doug responds, "Okay, I can come pick you up too." Then adds, "More time with my baby." Then adds, "Mediation tomorrow by Zoom, 10:30, and be quick."
When he says more time with my baby, do you think he's referring to the daughter or do you think he's referring to Ashley?
She responds with the action of liking that. Then added, "Sorry, just looking at my phone. You don't need to drive all the back to LWR to get us if you are already downtown. But if you want to, that's fine. Just let me know either way." Doug responds, I'm at apartment. Adds, so pretty, enjoying pool area, finally to work, LOL. The next message is an attachment with no body.
From Doug,
That is from Doug to Ashley Christina.
and I'll pull up the attachment. I don't know why I just closed that. Let me open it again.
Maybe that's
What
what it
number were we
means.
on?
That's what he said.
132,
We're
that
going
was
to
the
end
attachment.
yeah, this is a great comment. Lex Subtle says, is red, blue inversion referencing Florida being a red state and Maryland being a blue state? Yeah, because he did say something like, we're going to leave our adventure in Florida, LOL. I think you might have hit the nail on the head. Ding, 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 ding. Yes, Danielle, second degree murder.
Thank you. Okay. So after the attachment, what's the next communication?
It's a message from Doug to Ashley Christina. I'll just head your way at 1:30. Ashley Christina responds, hot, nice, okay, just getting our things together now. Maybe head over in like 10 minutes. 10 MIN. Doug responds, okay. And then after that is appears to be an email from Doug to Ashley.
And after that?
After that is incoming message from Doug. Do you want to get together tonight or in morning before mediation and unify the instructions for Faith and Stephanie? Think we are going to need to keep involved until this is done or will drag out. She responds, ha, okay, thumbs up. He responds, thumbs up. Prefer tonight, maybe run over Pandera or in AM, question mark. And she responds, sure, can do Panera tonight.
Okay, so I want to back up a little bit. We were talking about the entry that was the email before that. Does it have the content of the email in this spreadsheet?
Appears there's quite a bit of metadata involved, but the actual content from what I'm looking at is not actually in there.
Okay, does it say any names associated with the metadata?
There's an email address of Stephanie Murphy. It's at murphylawsarasota.com. There's an email address related to Doug Benefield. And there's, I believe those are the two names that I see that are associated with.
So we left off at sure can do Panera tonight.
Yes. And adds 8 question mark. She responds with a thumbs up. And that was at 7:27 p.m. And she responds with at 9:55 p.m. with a good night and a sleeping emoji. And he responds also with a good night with another emoji. He adds sweet dreams and then also sends an attachment. Correction, the sweet dreams was the last one at 9:56 p.m. The attachment I just referenced was actually 7 o'clock in the morning the next day.
Okay, so the next day I'm clicking on that attachment. And what is that?
Looks up here a Bible verse.
And what are the messages after that?
All right, so attachment. After that, there's a good morning with a few emojis. If you want, you can come over here for Zoom.
Oh, now he wants her to be in the room with him while they do the mediation on Zoom. That, I mean, in my opinion, that's a little controlling. James Billington chimes in with excessive texting from a 50-plus-year-old man. In my opinion, he's desperately trying to stay in her headspace. Just my perspective as a man.
and adds, we can grab bagel in CHI. It's 10 a.m. BT, by the way, BTW is for short. And then there's a phone call at 9 o'clock, 9:07 with no seconds. There's a 151. It says there's an incoming message with no body. And then after that, there's an incoming message with an attachment that appears to be related to connection to a Zoom meeting, possibly. And then
I'm going to click on that attachment to see if it will come up. It's one of those that will not come up. So go ahead.
the next after that appears to be an ID number and a password typically associated with Zoom meetings, and then a phone call with no seconds. And then 9:38, it continues where Ashley Christina loved an image, then liked the message. It's 10 a.m. by the way, and then added, "Ha, oh man, okay, thanks for the heads up." He responded by liking that, and then added, "Set up here if easier for you." And she responded, "That's okay. I guess I should brush my hair and change out my PJs. LOL, I think I can just do it from my phone." He responds, "LOL, you can." She liked LOL, you can, and then added quick and easy LOL.
And what was the time difference between the like of LOL you can and the quick and easy? Approximately.
About 15, 20 minutes.
Okay. And then what was the next entry after the quick and easy?
So it was another action by Doug for that quick and easy, and then added, "So nice to experience quick and easy. Finally, LOL." Then adds, "Smeshing good." Then adds, "PS, you looked great for just rolling out of couch. LOL," and added an emoji.
Okay, so I'm gathering that she did not go to his place to do the mediation by Zoom in the same room with him, because he said you looked great for just rolling out of the couch, as if he was seeing her on Zoom. What does smeshing mean? He said that a couple of times. SMESHING. Smeshing. I don't know. Is that some sort of lingo that I don't know about? Anybody knows what smesh is? He talks about smesh a lot. I think that's like the third time I've seen it in his messages.
He added, "I'm working on brief, head over soon as get to stopping point like 1." She responds with the action of loving the previous message, or one of the previous messages. "So nice to experience quick and easy." Laughed at also the PS, "Looking great" comment. And then added, "Ha, thanks. Figured I should put a clean shirt on even if I had PJs on the bottom half. LOL."
Remember earlier in the testimony, it might have even been the first day, it might have even been during Tommy Benefield's testimony. There was some testimony elicited where Doug would get mad at Ashley if she didn't emoji him properly in text messages. Do you guys remember that? And she was having a conversation over text with, I think it was Tommy Benefield, where it was mentioned that, he thinks I don't love him enough if I don't use the right emojis or something like that. So now they're trying to use her loving his comments to mean that she agrees with them, which I don't know if that's the proper interpretation. Two Doors Down says texting is a way of knowing where he is, knowing where she is, right? And mood, since Florida wouldn't respect the restraining order. Oh, of her knowing where he is. Yeah. Yeah, I can see that. Sydney Collins says the prosecutor doesn't seem to comprehend the dynamics of DV. And Fires says she's barely speaking to him. Lori Scott, he's very controlling. Mind games. Cajon Zone. I have so many memories that make me feel psychic in these circumstances. Elle says maybe she changed her mind and that's why she had the gun as protection in case he flipped out. I always wondered why gun wasn't packed. I think they said there were a couple of them. I think when the crime scene techs came in, they said there were, I think, 3. I think they found 3 guns.
She adds, and okay, just let me know as you're finishing up. He adds, just to ponder while I finish up, thinking about getting all the cars up here, and I thought was to ship the Cherokee up there by transport, which is 900, and either tow my truck or tow to your Jetta. The U-Haul plus the car trailer is about 1,000. That's for the biggest truck, which gives us plenty of room. The option is another pod and tow one of the cars behind my truck. Overall price about the same. U-Haul, more flexibility, like taking things straight to storage. She responds, okay, things to think about. Maybe best to have you drive the U-Haul and tow your truck behind. Mom and Cats will go in the Jeep and I'll drive with Emerson in my car. She added, LOL, the Beverly Hill. He added, LOL, the Beverly Hillbillies coming from them slums. Forget about cat courier requirements, LOL. She laughed at the Beverly Hillbillies comment, added LOL, then added, I believe, several cat emojis. He laughed at the emojis, then added, headed over shortly, brain approaching short circuit. She added, okay, well, give me a bit longer, finishing up mom's closets now so I can get the cats locked up. He added, he liked the previous message. And then there was a outgoing phone call to Doug for 38 seconds. Outgoing message from Christina says, headed that way. He responds, or he took the action of liking it. Added, we done good, LOL. We have Dr. Q at 10:30. Good night with an emoji.
Okay. So the light headed that way was at what time?
That was at 2:00 in the afternoon.
And then the good night was at what time?
It's 8:27.
Okay.
At night.
So he's notifying her that he's coming over. Remember, he has visitation rights, or what they call time sharing in Florida, as we learned from Stephanie Murphy, his attorney. So, I mean, are they going to try and paint it like, well, she let him come over?
Saw 2 of them. Apologize.
And then after the good night.
After good night, there's an outgoing, indeed, LOL, good night, from Ashley. And then after that, there's an attachment at 5:45 in the morning from Doug.
Okay. And I'll click on the attachment. What is that?
Another Bible verse.
And the next entry.
Appears to be another attachment roughly 15 minutes later.
Okay. And if you could read what this says.
I'll read it. Live a life filled with love. And then there's a heart in the background. And at the bottom, it says the chapter of the Bible, which I cannot read.
Live a life filled with love. Another Bible verse, Ephesians 5:2. At 9:26, there's a message from Doug. It says, good morning. Minute later, there's an action of loving an image. Second, loving a minute image. And he responds with, Dr. Q's at 10:30. Do you want a CHI? Question mark.
I think that's chai.
No, chai is CHAI. Chi is a yoga term, I believe, right? Chi, CHI. CHAI is chai. But okay. Maybe he was going to pick her up some tea. Chai is tea.
At 9:27, there's a response from Christina, says, good morning. There's a repeated response, previous message. Dr. Q is at 10:30. Do you want a chai? And then bagel, he added to it. She responds, that's okay. Thank you. If I do that this early in the day, I'll be done for the day, LOL. But thank you. He added, he liked that message. And then the next appears to be an attachment from Doug related to possibly a YouTube video. And that was at 9:56 a.m.
And it's another one that won't open.
Smeshing. Michelle says smeshing is that Yiddish,
And then
like
the next
Jewish for
entry.
smashing? Or Yiddish?
It's at 9:25.
Thank you.
Correction, 10:40, 35 a.m. From Doug, are you able to make it? Are you able to make Dr. Q okay? She responds, yes, LOL. Be in a minute. He responds, no rush. He's still not out, LOL. She responds, I know, LOL, waiting for mom to come out so we can swap. There's a message without just a rectangular square there. And then after that, there's 10:42:35. There's an LOL from Doug. There's a phone call. It's
Now the LOL was at 10:42 a.m. and then what's the next entry?
correct. 10:42 a.m. was the LOL. And then the next is at 5:39 p.m., which is a phone call from Doug, and with 0 seconds. Then adds after the phone call, I be here. And then another phone call for 15 seconds at 5:40 p.m. Then,
Your Honor, not to attack Sergeant Kibas because he's been reading for a while, but it's a little tough to follow. I wonder if he could give us the number of the message, so it would be much easier to follow.
Mr. Taylor said it's a little hard to see where he's going because he's reading so much. It would be much easier if he could give us the number of the text message so we can follow along. Gabby for Justice, thanks for the super chat. We need to take a little break from all this reading for a second. Says he hasn't asked about the child in these texts. That's a great point, Gabby. Thanks on top for your super sticker, always being on top of it so early in the morning before we even started court. Kate, thanks for the super chat. Melanie, how can I send you screenshots of transcripts unverified of Ashley's bond hearing? They are wild. Kate, if one of the mods could put the email in the chat, that'd be awesome. You can email them to me. Thanks, Kate. Susan, this is unfortunately how most women are with other women. Going back to the court TV piece that we watched at the top, talking about Ashley's choice of clothing, makeup, and hairstyle. Unfortunately, Susan, I agree with you. Thank you so much for the super chat. Deborah, thank you for the 5. So kind and generous, all of you. Susan says, I wonder what these women would look like if it was them. Really? I know it is so disappointing to watch coverage like that, Susan, isn't it? Like, I mean, it's 2024. Can we give it a rest? Stephanie, thanks so much for the 5. It seems to me that the judge is not fair to the defense on anything. He's been okay. I mean, I didn't watch all the pretrial stuff, so can't speak to that, but I find him to be a little bit more measured than the judge in the last trial that we watched together, which was the Karen Reed trial. So I'll reserve judgment on that. Tanny Simmons, thanks for the 5. Trauma tends to stunt a person. It's distasteful, but going back to Eva, but both her parents died unexpectedly. Arrested development is real, and she's in a me age. Thank you, Tanny Simmons, for coming in with some insight. Thank you. Jenna L913, you tell them, Mel, we love you. Thank you. Love you right back, Jenna. Thanks for the 5. Bianca, thanks for the super sticker. This was very interesting, Disabled Rebel. Thank you for chiming in on the Bible scriptures. My abuser used to force scripture on me to guilt or shame me into complicity. Thanks for sharing. Laura, thanks for the 5. Bond servant per Google is a person who is owned by another and is bound to serve them without pay. Who said that in the text? Doug? Yep, it was Doug. Oh, yikes. This is Laura. Thank you, Laura, for the super chat. Tanny, thanks again for another 5. These are the types of messages you send to someone you aren't interested in. 0 warmth and no I love yous. And you're responding, I assume, to Ashley's text messages back to Doug. Agreed. Thunder Road Queen, hello, good morning. Thanks for the 5. Watching this brings back so many uncomfortable memories. These texts are so manipulative. I wonder, because when you go to other chats and you watch this trial, so many people don't get it. that I'm wondering. I know so many of you do get it, but is the jury going to see it that way? Kimmy says, hi, hello to Canada, Kimmy. I interpreted he said that you dismissed. Yeah, that's what the closed captioning says. So try not to follow the closed captioning. But I think when he read it, he said that you will dismiss the restraining order. That's the way I heard it. Christine, thanks so much for the 5. Her brief responses are so indicative of trying to keep the peace and not engage fully. More work could be so much misconstrued by the abuser. More words, I think you meant to say, could be so much misconstrued by the abuser. Yeah, short and sweet, right? Isn't that what they tell you to do? The Gray Rock method. Thanks, Kimmy, for becoming a member, and Kay for becoming a member. And Joanne Cody thanks for the 10. Says, thanks for all you do, Melanie. Joe from Norfolk County. Yes, that toxic environment. Thanks, Joe, for tuning in from Norfolk County, Massachusetts. We're going to be back there soon on August 9th for another hearing in the Karen Reed case. Gabby for Justice. He hasn't asked about the child. You're correct. Disabled Rebel, thanks for the 5. Has anybody ever heard commentary on men's physical appearance while on trial in court, like ever? I don't think so. Terry says, thanks for the 5. What's the context of Smesh? He was into martial arts, right? Because it's also an MMA fighting technique. That's interesting. I think he was MMA. That's interesting. The way he's been using it, I think, was like great. But yeah, that's interesting. Thanks, Terry. Well, I'll go back and watch that later. Nancy Rolfe, thank you for the 10. Says, thank you, Melanie and Mods. Love this channel. We love having you here, Nancy Rolfe. And thank you so much for your generous contribution to this channel. All right, let's go back to court and listen to some more text messages. We're a bit behind, so if you're ahead on another stream, please do not give us any spoilers.
And I don't know why, but I think your numbers may be off.
All different from this.
They might be. Can you look?
Ivy here is, well, we're not using the numbers that are built into Excel. I want to say
Okay.
the numbers are an actual column. So technically Ivy
Hang on, I'll
here.
move this over. That's what you're looking at.
Correct. Ivy here would be 212.
If he gives you that number, are you okay with that?
Can you show him?
Like on yours, 214. 215, correct?
New Sergeant, if you could just call.
So we left off of 215, which is at 9 o'clock. It's a good night with an emoji. 216 is an attachment, a JPEG. And that was at 6:43 a.m.
And that is on the next day, correct?
Correct.
9/26.
Correct.
And I pulled up the attachment. What is that?
That's like a Bible verse.
For all have sinned and fall short of the glory of God. Romans 3:23. Every morning, it's like at 6:45 in the morning, he's waking her up. He's got to be in contact with her from the second she wakes up. Has he been sending her Bible verses every morning at 6:45? Because I notice he's sending those messages kind of early. He wants to be the first thing on her mind as soon as she wakes up and looks at her phone.
And then you can continue from there.
All right. So moving forward, 217 is from Doug with a good morning. 218, she loves the image. And 219, she responds also with a good morning. 220, Doug sends ready to start with a thumbs up. 221 is a call log from Doug with 0 seconds. 222, there's a message from Ashley Christina. Okay, I'll text you in a bit with an emoji. I can't tell what it is. Pretty small. Next record is 223. Just one of those action messages, liked a previous message. and then it repeats. 224, want to come pick me up and we can go get the truck.
And that's from Ashley.
And that's
correct?
from Ashley. And Doug responds, sure, with 225, sure, headed that way. 226, I be here. And that's at 12:41 p.m. And then 227 is all the way at 9 o'clock in the evening. And it's from Doug, and it's a good night, sweet dreams.
Okay, well, that indicates to me he's saying good night, sweet dreams at 9 p.m. and she's not having him sleep over. They're not sleeping in the same house. They're trying to make it look like she's manipulative by asking him to come over and do things for her. And she was using him. And I saw this, I think, on Vinny's show on Court TV that they were talking about that, using him to move, that kind of stuff. What say you?
Then at 228, 923, Ashley responds with the action of loving the previous message and also responds with a good night. 230, there's another attachment at 642.
Again, 6:42 in the morning, every morning.
Pull up the attachment. What is that?
And wait, has it been like 6:42, 6:43 every morning? I wonder if there's any like significance to that number 6. Oh, well, this is Romans 6:23. For the wages of sin is death, but the gift of God is eternal life in Christ Jesus our Lord. Romans 6:23.
Bible verse. After the attachment at 231, Doug sends good morning. 232, she responds, loved an image. And 233 with a good morning. 234, he responds with looks like a strong fist up emoji. And 235, there's also an incoming from Doug with just a little rectangle. 236, she responds with LOL. 237, he responds, what y'all working on? And that's at 1 o'clock in the afternoon. 238, about 15 minutes later, she responds, last cram, LOL.
Okay, now they're confusing me because now they're saying the number of the text message, and I thought that was the time, 2:23, and I was like, uh-oh, she didn't respond to his biblical verse until 2 in the afternoon. He must be going nuts. But no, because this message was at 10 a.m. Let's see.
What y'all working on? And that's at 1 o'clock in the afternoon. 238, about 15 minutes later, she responds, last cram, LOL, using big boxes and getting the last loose stuff packed up and ready. And also responds on 239, how's it going over there? Making progress? He responds at 240, number 240 at 1:18 in the afternoon. Loose stuff should be a chapter in our book, LOL. Got everything out and in garage ready to throw on truck except couch, aka bed. Pretty much emptied. Taking solely to get his shots, then to doggy spa to get groomed and stay until ready to go. 241, he adds, I'll come there after drop him off at 3. .242, she responds with the action of laughing at a previous message, and it just repeats. Another action of liking a previous message, then adds 244 adds, great, could you run by Lowe's before you come over, grab a few large and mediums. 245, he responds, sure, I need a few too, which is at 1 o'clock in the afternoon. At 2:35, number 246, which is at 2:35 in the afternoon, it's just a like by her, sure, I need a few, which just repeated from earlier, and then adds, just to be safe, let's do 10 of each just for the last bits here. 248 from Doug, he likes the previous message and adds, and 249, okay, let me know anything else if think of. 250, she responds, tape. 251, and also adds LOL. 2:52, he responds, ha, K. 2:53, just finished vet, headed to spa, LOL. 2:54, she laughed at that previous message. 2:55, he says, headed there. 2:56, she responds, okay. The next line, 2:57, I'm here out front. She responds, okay, 1 minute.
Now, when he says, I'm here out front, and she responds, okay, 1 minute, about what time is that during the day?
That's about 3:54 in the afternoon.
Okay.
Okay, so this is the day of the shooting. I'm here out front, 9/27/2020 at 3:54 p.m. I just want to go back and see if there was anything else from that morning. He was finished at the vet. So this is all the morning. I'm just going to take it back because it's the morning of the shooting.
One, and also adds LOL. 2:52, he responds, ha, K. 2:53, just finished vet, headed to spa, LOL. 2:54, she laughed at that previous message. 2:55, he says, headed there. 2:56, she responds, okay. The next line, 2:57, I'm here out front. She responds, okay, 1 minute.
Now, when he says, I'm here out front, and she responds, okay, 1 minute, about what time is that during the day?
That's about 3:54 in the afternoon.
Okay, and the next message is at about what time?
3:55 in the afternoon.
And the next after that?
After that, it's 5 o'clock in the afternoon.
So there's an hour and several minutes in between these two.
Correct.
Okay, so after okay 1 minute, what is said?
Right, because they were together during that time.
Then 2:59, about to head back
Wait,
from
2:50
Doug. And then
What time is that?
the message after that appears to be an attachment at 5:11 in the afternoon.
So he went somewhere and then he was coming back.
On the attachment for the record.
Yeah, appears to be
Go ahead, I'm sorry.
it appears to be maybe the U-Haul truck that they're loading up.
And that was sent from Doug.
That was
They're not showing us the time.
5:11. Yeah, that was incoming. Yes, from Doug to Ashley.
Okay, and then the next message?
The next is from Doug, and this is number 261. Everything in except couch and 10 medium boxes and tutu cab, LOL. 262, she laughed at the image. 263, she responds, ha, OMG. 264, he responds with trucker on the way, and that's at 5:32 p.m.
At 5:32 p.m., was that the last communication between these two?
I believe so, yes.
Thank you. Judge, can we approach just a moment?
Yes.
Before.
Okay. Can anybody refresh my recollection about what time the shooting was? I know many of you have been invested in this and following all the pretrial. If you guys know what time the shooting was, let me know because their last text exchange was 5:32.
So I'm going to excuse you in the back. It should take about 10 minutes.
On the way.
My best guess. So please don't begin deliberations amongst yourself. You can communicate outside, send and receive texts, emails, telephone calls, but just don't talk about the case. But don't do any research on the people, places, things. I don't know to what extent we're going to be talking about the testimony you may have. So I'm going to go ahead and excuse you for right now, just to be cautious. This video is out of the room.
Okay, they're going to look at a video now.
Okay, the detective
outside
is
the
out
presence of the
room.
jury, and they have sent the witness out. So let's see the video.
We can have argument on this video.
Thank you, Judge. And thank you for rehearing the issue. I had a chance to research it. We obviously weren't.
If you've got case law,
contrary
to what people may think, I want to make the right decision. So if you've got case law, I want to hear it.
Thank you, sir. I actually just sent one to the printer because I didn't know if you'd rather have it, but it's called Lumarque. I don't know, LUMARQUE. It's 44 Southern 2nd. I'm sorry, Southern 3rd 171.
Say that again.
Sure, 44 Southern 3rd, 171. There's a yellow flag, but it's for a different reason. This case was,
Judge, are you looking it up electronically or would you like a hard copy?
No,
okay,
I'll take a copy if you have one.
Oh,
give me 1 second. Sorry.
Oh, that's all right.
It would only
Is that the only one you've got?
It
No,
would
you can
only
have
take
it.
one at a time. I can do it, Judge.
I printed this for you, but then realized we needed 2 copies, so here's the paper copy.
Sorry. It's not off the print.
Judge, they revoked my copy in favor of the court.
Favor of the court.
We're not gonna do anything until you get a copy.
It should come any second. The part that I'm referring to is on the second page. It's a short case, luckily, where my reading of it is there were text messages and photographs, which I think videos and photographs are treated the same in most case law. That's my understanding and my feeling, but that there were images and text messages that could not be authenticated by an ex-wife on the defendant's phone. And the trial court did not allow them into evidence. The third DCA here said the court erred. The images and text messages were found on the defendant's cellular phone.
Can you slow down just a little bit for the court reporter?
I apologize. The images and text messages were found on the defendant's cellular phone, seized pursuant to a search of the defendant's home through a warrant shortly after the alleged incident. This fact was testified by the state's forensic expert and is sufficient to authenticate the exhibits. Here, those phones have been in evidence since the day before. The contents of them were admitted with a trial exhibit today and not objected to. The only thing is this one video was objected to, this attachment. And the state would argue based on this case that we have established this phone was properly searched, properly downloaded, and the material was found on the defendant's phone, the video found on the defendant's phone, and therefore the state would argue it should be admitted.
All right. Mr. Taylor?
Just 1 second, Your Honor. Okay, I distinguish it on 2 bases, Your Honor. They quote U.S. versus Caldwell 11th Circuit decision, holding that authentication of evidence merely requires a finding that the evidence is what it purports to be. Well, that's the exact issue. Sergeant Quiles cannot do that. He can only say this is a video, it was on the phone. He can't say it's a true and accurate reproduction of what took place on that morning. He doesn't know, for example, who was there that might not have appeared in the video, what the motivation was that brought them there. He wouldn't be able to say whether it was under coercive circumstances. I don't think he qualifies to be able to lay that predicate. And the second reason why I don't think this case is applicable is in this case, they held that it was admissible because it constitutes evidence of motive. Judge, this is a second-degree murder case. As the court knows, motive in second-degree murder is not an element. There is no obligation that murder be proven. I don't think they can lay the necessary predicate for it.
State rebuttal.
Just that I think defense counsel's arguments go to the weight, not the admissibility. I think this case stands for the fact that we've entered, without objection, cell phones that contain this video, and then now without objection, the trial exhibit with the attachments and the CD. The objection was just to one after which I think is also an issue, but I think we don't have to get there. But I think this case stands for the fact that once we've laid the predicate that this was a properly searched phone and that the data on it was properly removed and the detective testified that everything was in order, then we've laid the predicate for the contents of the attachments to also be admissible based on this case that I can't say the first name of.
What was the date and time of this particular message?
The message was, I don't know that you can read the small print on that, but there's a copy, but it is, if you're wondering if it was before the Panera conversation or after.
I want to know the day and time that this attachment
Panera
was sent.
conversation.
It was sent 9/20 of 2020 at 6:40 p.m.
So it's a week before.
Oh, 25.
I don't know what the video is about, Julie. Hopefully we'll find out. Defense wants to keep it out.
And the Excel spreadsheet, which is the data dump from the defendant's cell phone, shows it's in blue. So it's
The
from,
defendant's phone. So it's from the defendant's phone to, I'm sorry, from.
Correct.
the
It's
victim's
from-
phone to the defendant's phone.
right, it's from Doug Benefield's phone
Yes.
to Ashley Benefield's phone.
Yes.
All right. Any further argument? Because I wanted to ask that question, to know specifically when. Anything else?
No judge.
All right. No objection or no judge?
I thought you said, do I have any further
Anything
argument?
else? And you
Yeah,
said no?
And I don't, no
Okay.
judge, sorry. Yeah,
Okay, well, as I said, if there's case law out there that is contrary to a prior ruling, I think it needs to be brought to my attention. And what State versus Lumarque, Lumarque, 44 Southern 3rd, 171, at 172 to 173, Florida 3rd DCA 2010, states pretty unequivocally the images and text messages found on the defendant's cell phone seized pursuant to a search of the defendant's home through a warrant, which it wasn't here. It's my understanding, the testimony that I heard was that they were provided to law enforcement. Shortly after the alleged incident, this fact, testified by the state's forensic expert, is sufficient to authenticate these exhibits. So the issue is authentication, and that's where I had initially sustained, because obviously there was going to be no witness, this Quails? Keyless, sorry.
he says keyless entry as how to remember it. It helps me.
Keyless certainly could not authenticate the video. And just to be clear, I'm not sure, I think it's on the record that it's going to be a video of the defendant and her mother that's taken by a third party. I outlined it pretty in depth in my order denying the stand your ground. And like I said, certainly the technical services unit couldn't authenticate it, saying that it's the traditional way, that it's a fair and accurate depiction of the events of that day. So then I had mentioned that the bench, perhaps the state could lay the silent witness predicate. However, I don't find that the silent witness predicate was sufficiently laid by the detective Keyless. However, apparently, according to this case, it is authenticated by the fact that it was found on the defendant's cell phone that was seized shortly after the incident. And at this point, it's been sufficiently testified to by the state's witnesses and the forensics expert that he did find this video on there. In fact, in addressing the defense arguments, the 3rd DCA goes on to say, regardless of how these images and text messages might have found their way onto the defendant's cell phone, the state has presented sufficient evidence at this stage. Certainly, they met the admissibility that these exhibits constitute evidence of motive. As we've discussed, motive is not an element. But the state has made the argument in the past and makes today that the entry of these items is not for the truth of the matter asserted, but to show the relationship and interactions between the parties in the days leading up to the homicide and the normal texts and banter and communication of a married couple that is in the middle of a divorce. So for those reasons, I will reverse my prior decision, and the video would be admissible under this case. So we did that specifically so you could finish with your direct, and the ruling is made so then it's available on cross. I know we talked about different options, but I'm glad we did it that way because I think it makes a lot more sense.
So we can recall him and play it, and then we'll tend to the witness.
Correct. So when the jury left, he was on the stand.
Oh, I'm sorry.
Right. So I'm just going to put him back on the stand. The jury won't know any different. All right. So if we can bring.
Can we take a quick restroom break?
All right. 5 minutes.
He doesn't want to break.
Okay.
Thank you, Judge.
All right, the video is coming in. I mean, because it was on the defendant's phone. However, unless they have metadata, how are they going to be able to show when this video of, I guess it's of Ashley and her mother, when it was recorded? But apparently it's a video that Doug sent to Ashley a week before the shooting. And we'll get into that in a second because we can just FF through the break. SC Shan is falling asleep at work. So sorry that you're falling asleep. We'll try and wake you up a little bit. Do you want me to shout? Would that help? Thanks for your super chat. Thank you to M. Thompson for your 10, who says, thanks, Melanie, for keeping it classy, civil, and clean. That's why I'm here, and not so many places that are not. Thanks, M. Thompson. We try really hard here. My moderator's the best on YouTube. And there's a little tips. There were some tips this morning, but hopefully people were being respectful to each other. Thanks, Angie, so much for the 5. The LOL and nice responses are to keep the peace. I LOL a lot that I'm not even laughing at. As a survivor, it's a nervous response. Totally see that. Thanks, Angie. Jeff Litweiler coming in. Hey, Jeff, how are you? Thanks for telling me I have great coverage. Appreciate you and your deuce. Aline, thanks for the 5. Hi, Mel. You and your discussions on everything. Do you know if any DV organizations have publicly come out in support of Ashley? I do not. They do. She does have a website, or somebody has a website on her behalf. That is, I think it's westandwithashley.com. So I don't know if that would be on there, but that's a excellent point, Helene. Thank you. Catherine says Doug is initiating everything. He's a controlling man. Thank you, Catherine Frazier, for being a member for a month. Cat's Pajamas, thanks for watching from Canada and for your super chat. In a jury of your peers, I often find peer is a misnomer. For example, unless there's at least one on this particular jury that understands the subtleties of mental and emotional abuse, in my opinion, that is not a jury of your peers. That is why, Cat's Pajamas, in my opinion, jury selection is so important. So important. And questioning about things like that is so important as well. Kathleen, thanks so much for your 5. No mention of the 9:30 hearing. No fear expressed about the psychological report. Right. And the state is trying to show that that was Ashley's motive for killing Doug, is that report of Dr. Broder was going to be released on September 30th. And there's no mention of that in any of the text messages that we just heard. You're correct. Thank you, Ann Ruby, for your super sticker. I appreciate you so much. All right, let's go back to court and see the video.
Ready to bring the jury back in? Everybody, or do any research on the case?
One thing before I turn witness over, there was an attachment of video that was sent by Doug. It's line 25. So sent by Doug to Ashley, correct?
Yeah, hold on.
Oh, you don't have the sheet in front of you.
No. Thank you. Line 25 is an attachment from Doug to Ashley Christina.
Okay, I'm going to play that attachment at this time.
Blew my ears out.
I don't even know what it's doing. I think it's giving you clues that I gotta guess.
Okay, we're going to start that again. If you're wearing earbuds like I am, the beginning of this was so loud it blew my eardrums out. So just be aware of that. Okay, it's a video that Doug sent to Ashley, and it says on the lower left corner, "Heads up, Real Housewives," and then it's got a 50-second timer or something, and then it's got Ashley and her mom. Looks like they're sitting in a restaurant. And it sounds like he's narrating. I'm going to move these closed captions up. Just beware if you're wearing earbuds or turn your sound down. Okay, so this is something like Rosalind Franklin's birthday is at the beginning of this video. Okay.
I don't even know what it's doing. I think it's giving you clues that I gotta guess. Get real? Real?
Working mother, not a working mother.
Working mother, not a working mother?
Not a working mother.
So it seems like he's taking this video of Ashley and her mother in the restaurant. So he must be there with them and he's doing some sort of quiz and he's videotaping it because you hear him narrating in the background.
I live in a
Slum. Oh no, it's running out of time.
I live in a
House.
and
Real house. White.
So put together.
Housewives of. Oh, real house. Oh.
Oh, he's there. He's with them because he just turned it around to himself.
Okay. Thank you.
Oh, Ellen used to play it on her show. Okay. Thanks.
Cross. And Mr. Taylor, do you want the screen or do you want the lights back up?
Heads up.
I'm gonna use the screen.
Yes, sir. We'll leave it as is.
Thank you. Heads up is a charades type game. Thank you. Trying to show that a week before they were playing games and laughing. I think they're supposed to guess Real Housewives with these clues, yeah.
I want to make sure that we can establish the contours of your testimony. From the technical services unit, you're capable and authorized to extract this information from the cell phones of both Doug Benefield and Ashley Benefield.
Yes.
You don't know the context about the messages. You just are able to read what's printed.
I can read what's printed from the extraction, yes.
Right. But for example, there were quite a few Bible verses. You wouldn't be able to necessarily tell us that Doug Benefield's a very religious guy. You just can tell us, here's the Bible verses that he posted.
Yes, I can tell you that he sent a Bible verse.
Okay. And you can't tell us the reason that either party may have had for sending a particular text. You can only tell us this is what the text says.
Correct.
You can't tell us whether the text is true or false. You can only tell us what the text says.
Correct.
You can't tell us if the text is genuine or motivated by fear. You can only tell us what it says.
Correct.
I'd like to pass to you what we've marked as Defendant's Exhibit 3 and ask you if you can identify it.
I would object to be on the scope.
Okay, I don't know.
Come here, Brett.
She's objecting to be on the scope. Judge is like, I don't know what he's about to say. Yep, classic Clippy, I agree. So it just shows that she was not planning it. Highs and lows.
Defendant's Exhibit 3. BRIIAN QUILES, what I've marked now as Defendant's Exhibit 3. Those would they not, text messages that you also extracted?
I believe these were the text messages that you may highlighted during a deposition, and
Yeah,
we
and
confirmed that these came from, I believe, Doug's phone.
Correct.
Yes.
And that we requested.
I apologize, Judge. I do think we need to approach it.
Well, these are text messages from Doug's phone. Well, that's interesting. Wouldn't the same rules apply? Why wouldn't they be admissible if they're from Doug's phone? There's 4,003 of you here. If you would be so kind as to hit the like button while we're FFing towards the next part, that'll be so
I'm going to
sweet
let
of
you go
you.
to an early lunch. So what I'm going to do at this point is, it's about 11:30. I'm going to let you go to an early lunch. So if you could be back downstairs in the jury assembly room at 12:45. That gives you a little bit extra time. That'll give us time to take care of what we need to take care
All
of.
right, let's hear what they're going to talk about now. Jury's coming back at 12:45.
Sure.
Sending the witness out. All right, so what does that mean? Does that mean we're coming back at 11:30, at 12:30? All right, I gave Jules, our court watcher, a link to the StreamYard. She said she wanted to come on because she had some questions about what she saw in court. So we'll hang out for a bit, take some questions, check in with all of you and see how you're doing. You know, this case is triggering for so many of you in the chat, and I hear you. Some questions that I highlighted from earlier when we were talking about the Bible verses out of scope. Said the verses are relevant. They appeal to authority fallacies, indicating that while they seem innocuous at first blush, he's debating her psychology with her. Thought that was a really interesting take, a really interesting point. And therefore, I highlighted it for you. Talk amongst yourselves. Phoebe Bird says, with regard to the red and blue, in his book, I Am a Strange Loop, Douglas Hofstadter argues that the inverted spectrum argument entails a form of solipsism in which people can have no idea about what goes on in the mind of others. Shay. I think she finally got the courage to tell him he wasn't going to move in with them, or wasn't going to move with them, and he flipped out on her. I saw that comment a couple of times in the chat. And so I highlighted this one because many of you were saying that in the chat, that there must have been a trigger that happened while he was in the house. And that's what you guys think happened. She finally got the courage to tell him, or tell him that she wasn't going to be discontinuing her restraining order or the divorce. And maybe, just maybe, he flipped out on her. Mr. Man Created God said, is someone Jewish? A UFC fan, as a UFC fan, Smesh is how popular Dagestani fighters pronounce smash. Notably, Khamzat and Khabib. I'll bet you a steroid-induced DV who abuses animals and shoots his house up knows that. Interesting. Midnight Mike, all this shows is normal text before the shooting just makes it more believable that he blew up at the house and he corners her. In the same vein as the other comments, Alpha says face to face, she must have said, this ain't gonna work. He didn't like it, got crazy, and it escalated in minutes. And bang, 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 bang. Thank you, Kat B, for your super chat. Says, thank you for always advocating for victims and survivors. Thank you, Kat. The Wanda Life. Thanks for the 10. Merry Christmas in July. Merry Christmas. Thank you for all you do and fostering a safe environment to watch trials in. I appreciate you. Oh, thank you so much. Oh, it's July 25th. It's Christmas in July. I guess that's what that means. Norman Corey, thank you. And says, and 2 hours before the Titanic was not sitting on the bottom of the ocean. So true. With regard to those text messages that were sent 2 hours before the shooting. Kim says they still can't believe the behavior of this man regarding abusing animals and shooting a hole in the ceiling. Thanks, Amanda. I emailed you an interview Ashley did yesterday. Actually, if that's the one that you're talking about, that was on Good Morning America. She didn't do it yesterday. I think she did it before the trial, but it was broadcast yesterday. I can't play it because Good Morning America will probably strike my content, and then I'll have to go back and cut it out of this final live stream. If that's the one that you're talking about, Amanda, there's certain things I can play, certain things I can't. But it was not done yesterday. Definitely was not done during the trial. It was done sometime pre-trial. Oh, here's Jules, everyone. Jules, I can't see you, but you're back there.
See me?
Oh, hi, Jules. Can everyone hear Jules? I can't see you, but I can hear you. So that's okay if that's okay with you.
I don't know why you can't see me, but I apologize. I've never done this from my phone before, so I apologize.
That's okay. How are you? We saw you in the courtroom yesterday. It looked very cold in there. You're all snuggled up in your sweatshirt.
It's freezing. I thought it was cold and in the Maya trial. Well, I got to tell you, this is 10 times colder.
Really?
Just in the gallery. Yeah, just in the gallery alone, there's 8 air conditioning vents. And then in the part of the courtroom, you know, where the judge and the attorneys and the jury are, there's 12 there. It's freezing.
Wow.
Freezing. Yeah.
Moon Goddess says, press the cam button. Do you see a cam button on there? Anywhere like on the screen of the StreamYard?
I don't
Yeah,
know.
video off is better.
Cam. No, see. I don't know. I did it. When I press cam, that comes up.
Oh, all right. That's all right. So how you doing? How's it going in there? Tell us what's going on. That was some wild stuff this morning with the reporter having his lawyer or her lawyer send a letter about the juror at lunch.
Okay.
Tell us what you're seeing. Tell us what you're hearing.
Full disclosure. I am now sitting outside of the deli where I had lunch yesterday. And this is the location where the incident took place. Now, I was not here when the incident took place. I was here with 3 other networks that are covering the trial. We came here, it was after the fact. However, I mean, immediately after the fact. The owner and the employee was speaking with us and told us exactly what happened because the juror made a fuss. Okay, juror went in. Again, this is hearsay, and you know, I'm sure you heard the judge speak on this about the hearsay.
Oh, the chat says turn the phone around. I don't know if that's going to help you, but
Can you see me now?
no, I don't know.
Okay, I don't know. So what happened is when we were in here, the owner and the employee were like, "Oh, you're covering that child now." Oh, and speaking of the devil, here's the reporter. Here is the reporter right now. Just came in. I mean, is going into the deli right now. Hi, how are you? I'm good. You got called out. I'm not the one. I'm not the one. It was you. Yeah, well, I know. I saw you trying to get the judge's attention, but they did tell you to sit down. I saw that. All right. That was the guilty party.
Okay, don't dox them. Don't dox them. But okay, so one of the reporters.
That was the guilty party that interviewed Eva Benefield in the
Oh,
hallway.
Eva Benefield.
Yeah, Benefield. I'm sorry.
Did they broadcast that?
I don't know if they broadcast it. It was WFLA. It is the news channel. I have no idea, but that is the guilty party who you just overheard me speaking with. But back to the juror. So the employee and the owner of this deli were like, this is what I was told, that he came in, he wanted to make his order. They do have a big screen TV up on the wall, and apparently they had the trial playing. And he said to them, "You need to turn that off. I'm a juror on that case, and I'm not allowed to see or hear anything." And the girl admitted to me she was a little off put by his request, but she did.
The girl who worked in the deli?
Yes, the girl who worked in the deli. So she did turn it off. And I was like, okay. So Melanie, listen, I don't know if I did the right thing or not, but when this all came up this morning, I bounced back and forth. Do I or don't I say anything? You know what happened. You know how I got the name Notorious because of the Kowalski case, and I'm trying to keep a very low profile here, but everybody knows me.
Except you're on camera. You're on camera every time they focus on Ashley. You're sitting right behind her. Really low profile, Jules.
I can't, Melody, I can't see what you guys see.
Well, I'm telling you, every time they focus on her, you're right there. So that's funny. But anyway, put on some big sunglasses and a hat.
Yeah. So I did, in the end, I went to the bailiff. When I found out that they were going to be interviewing each individual juror, I knew exactly which juror it was because the girl described him to me. So I went to the bailiff and I said, "Can I speak to you outside privately?" I said, "It's about what's going on now." And he said, "Yeah." In the meantime, Judge Whyte had already started interviewing the jurors. So I told the bailiff, I said, "Listen, I don't know if it's relevant or if this is just petty." He said, "No, it is. Thank you for coming forward. I'm going to tell the judge." Well, by the time we got back in there, the judge had already spoken to the juror. And so I don't know if you saw the bailiff, the deputy leaning up against the bench whispering.
Yes, we did. We could hear him too because he was speaking. It was a hot mic moment.
Oh, it was? Okay.
Yeah.
Well, that was about me. And so when the judge addressed,
we knew it. We knew it. I said, I'm sure they're talking about Jules. They were like, do you want to call the person up and have them get on the stand? And everybody's like, no. And you were probably like,
I'm doing an interview. No,
you
you're
had a
good.
feeling it was you.
Yeah. So I did. So did I do the right thing?
Yeah, you did the right thing. Of course, you don't ever want to be accused of not saying something if you knew something. So yeah.
Okay.
Right. We want a fair. jury. We want
I was
Ashley to have a fair
conflicted.
trial. We, you know, and
I
so
was,
yeah.
yeah, but I was conflicted because of what happened at the last
But Jules, they
trial.
already knew about it. So all you did was reinforce it. They got a letter from a lawyer, from the reporter's lawyer, that said it was a male juror. It was the reporter who actually was the one who reported it.
And long crime just showed up, and WFLA. Hi, ladies. I'm doing fine.
Did you grant your phone permission to use the camera? Maybe that's what it was. Yeah. Everyone's like, Jules, see something, say something. Jules is a court watcher. She lives in Florida. She was the eyes and ears in the courtroom for the Maya Kowalski trial. And now she's here for Ashley Benefield.
Yeah.
So tell us just observations. I don't want you doxing anybody or giving us any information, but can you give us like your observations of the jury? Are they taking lots of notes? Are they
No.
paying attention?
Yeah.
What are you noticing? What are you noticing?
This jury, it's 7 women and 2 men.
Mm-hmm.
I've never, Melanie, seen a jury behave this way, but they seem to be extremely indifferent. They are not animated at all. This is a jury that is very difficult for me to read. Very little note taking, which also surprised me. Now, it's like they're watching a tennis match. They're focusing on the attorney, the witness, the attorney, the witness. It is kind of funny to watch their heads bopping back and forth. I did not, let me rephrase that. I did not see them look at Ashley at all. No one had.
So they're not watching. They're not watching her facial expressions and
no,
and dissecting every look.
It changed yesterday afternoon with Stephanie Murphy.
How so?
Well, in the morning when Stephanie Murphy was testifying, there was no reaction from them, no note taking. They were just, bouncing their heads back and forth, listening. When we came back in the afternoon, everything changed. Well, first off, during the HACAM, during the sidebar, if you remember, there was a sidebar, and she was looking at the jury, and I'm not kidding you. I don't know if the camera was focused on her. I don't know what you people see. Okay.
Right.
But she was smirking at the jury, and that kind of was off-putting for me. And I
saw it.
You did see it? Okay.
Yeah, we saw it. We mentioned it.
Okay. I thought it would be off-putting to them.
Yeah.
Well, when we came back from lunch, after all those breaks and stuff, and she got back on the stand, the jury's attitude took a change. And I wish I had my notebook out here with me. 2 women in particular that sit in the front row started nodding their heads up and down, not back and forth, but up and down. And then started to look over at Ashley. And I'm like, oh, crap. What's going on here? So when she finally got off the stand, and then as each witness came on, especially Gillum, I did not think that they were going to like Detective Gillum, but they did.
Really, that's not good. We did not like him. As a chat, we found him to be completely like, he should not even work in the DV section of any. He shouldn't be investigating DV complaints anywhere. That guy.
Well, you could tell they liked him because that's when note taking started with about 4 of the jurors, and they were nodding their heads in agreement, especially when he made the statement that Ashley wanted him to arrest Doug in court in front of the judge. And the one woman was like really nodding her head up and down. I'm like, oh crap, Taylor just lost the jury. I mean, that's what popped into my mind.
Unless they're thinking, yeah, he should arrest them in court. That would be a good place because nobody knew where he was until, I don't know. I mean, you're just telling us your gut, which is good. But you're saying that it appeared to you that they were smiling back at Stephanie Murphy, like as if they liked her.
Yeah. And I was, listen, this is my opinion only.
Yeah, totally.
So, I was put off by her. I did not like her. And I have a legal question, only you can answer. I did send that in an email yesterday, but I understand you're busy and that you can't answer. But I remember when I interviewed Matt Luca a year and a half ago, there was a hearing in the civil case for Petito versus Laundrie, and I interviewed both Petito's lawyer and Laundrie's lawyer, and Laundrie's lawyer was Matt Luca at the time, and he was also representing Steve Bertolino, who was Brian Laundrie's attorney. And after the hearing, I asked, well, Brian Laundrie is deceased, so why can't Stephen Bertolino, why are you fighting this about Stephen Bertolino testifying about his, whatever Brian told him? And he said, just because the client is deceased doesn't mean client privilege stopped existing. So I took that as, okay, I get it, and I accepted it. So my question to you, Melanie, if that was a correct statement, how does Stephanie Murphy get on the stand and discuss her relationship, her attorney-client relationship between her and Doug, who is deceased?
Well, they're not allowed to discuss confidential information, but somebody pointed out to me some random rule in Florida that may allow the estate or the next of kin to waive attorney-client privilege on behalf of the deceased. So I saw you, because I was watching Peter last night also, and I saw you ask that in his chat, but I was only in there briefly, so I was wondering if he ever responded to you.
No.
Since he practices in Florida. That would have been a great question for him. And so that's my thought, that perhaps the estate waived privilege, or perhaps she didn't talk about communications. She was talking about public court documents and filings and dates and things like that, but not any private conversations. So it's the conversations between the attorney and the client that are privileged, not the work, you know what I mean? Or like her observations.
So how did you take her observation on the first visitation swap with Emerson when she said that Ashley yelled and said, what, are you sleeping with her? And you know what I'm saying?
Are you dating? Yeah, we thought her reactions were very odd. That she seemed very jealous. I was like, why is she even going with him to the exchange at the sheriff's office? Why is she even? And then as she said, Ashley was nasty. I forget her exact words. I'd have to go back to my notes. And then it was almost like she said, oh, Ashley, like the words that she was using to describe Ashley really turned us off as a group, I think. And then she was like, she seemed jealous. A lot of people like, was she like wanting to be with Doug? Like it was just weird. And then the way that she said, she's like, Ashley just asked us really nastily, like, are you two dating? And I was like, no, like, no. She seemed like way too personally invested.
Thank you.
A lot of the comments that we were getting, and way too, like she was taking it way too personally. Thank you. Stephanie Sweedler says, Stephanie Murphy can testify because she has been given a waiver by the estate. Yeah. Okay. Thank you, Stephanie. So I don't know if you're a practicing attorney in Florida, but that was what my research also revealed that. So thank you, Stephanie Sweedler, for that. Yeah, we found it to be really like she was too personally invested in it. Like, why did she have such a vendetta against Ashley still in her testimony even?
Yes. Now,
So how did she come across to you?
Exactly like that. I found it odd, and off-putting,
Mhm.
um, and
Yeah, she used the word
borderline.
we a lot, and she referred
Yes,
to him
and
as Doug, by his first name. It was just weird.
yes, and so my mind, I was on the border on this, but my mind went to, I wonder if there was something going on.
It just seemed a little too personal to her. Like,
Yes.
why was she taking everything so personally almost still? And there was a lot of like peacocking to the jury, and trying to like smile at them. And just, I mean, to us, yeah, right.
Not only in the courtroom, if you wanted to see a show, you're not allowed to tape. Otherwise, if I could, I would have recorded it. She was strutting up and down the halls like a peacock, and then in the restroom, everything happens in the restroom. I met her in the restroom.
Oh, really?
Yeah. Now she does not know who I am. She might after today, though, or after last night. I don't know. But she was very cordial, a completely different person to me in the restroom, talking about how cold it is. I should have worn a blazer. That type of thing. You know, but then once we got out of the restroom, and then she started seeing people she knew again, that peacock persona came out. And I was
Yes.
like, I don't know. And
She's been doing a lot of pretrial interviews too on Court TV with Tommy, cousin Tommy.
Well, I got a thing or two to say about that man, but I'm going to reserve till after the trial's over.
He's a creep.
Mm-hmm.
He's the creep. I mean, listen,
He's
I
not
think that
not a
Taylor
nice
was,
person.
he's not a nice, well, don't say anything because, he's in court every day and we don't want him to come for you. So,
Yeah, and he
joke.
will.
Ha
Yeah, I was just kidding. I like you, cousin Tommy. I'm so glad that you spent so much time with your cousin Doug in his personal life. It really tells me, you had a really close family.
Right. Twice a
Anyway.
year.
And so yeah, so that's when I saw the shift in the jury yesterday, and as the afternoon went on, it just, in my opinion, I there was a shift, and they started paying way more attention. And then today, they're not. They're back to the way they were before yesterday afternoon. They're not. Again, indifferent. Although I did see during the sidebar, one of the female jurors, look over at Ashley. That was the one and only time that I saw that.
It's really weird that they're not looking at her at all. I don't know what to make of that.
Oh, can I address something in case
Of course.
you don't not yesterday, but the day before yesterday? Do you remember when they introduced his shorts and his shirt into evidence, and how she made a big deal about, well, what size are they? 30-inch men's.
Right.
The shirt was a small men's.
Mm-hmm.
Well, I just want to tell you guys something. On when you're on camera, the looks can be very, very deceiving. All right. I have gotten close. I don't mean personally. I'm talking about close in vicinity to Ashley Benefield.
Mm-hmm.
Yes, she's tall. I'm 5'3". I'm guessing she's 3 to 4 inches taller than me. But let me tell you something. She is very thin.
Mm-hmm.
She's her bone structure is she's small boned. She's very slender. I don't mean in a sick way.
Mm-hmm.
She's, you know what I'm saying? This is her body structure. And
Lith.
to me, the state was trying to imply that Doug was a small, slight man, and oh, how could she fear him? Melanie,
Uh-huh.
did you come away with that?
Oh, girl, we pulled up his Facebook the other night. We see how big he is.
Okay.
He's
He's five
huge.
nine. Now, I just want to say this. He's 5'9", and yeah, he's 180 pounds, but not overweight pounds. That man, he doesn't have a six pack. He has an 8-pack.
I
He
know.
is ripped. He's ripped. Don't try and pull that he was a slight man and she should not have been physically afraid of him and blah, 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 blah. You saw my pictures, Melanie. I
Mm-hmm.
sent my pictures to you. Well, my ex was also between 5'8" and 5'9", and he weighed 180 pounds. You saw what he did to me. Okay.
Mm-hmm. I just pulled up his Facebook picture for people to see. I mean, this was posted by him. His Facebook is still up. He's jacked.
Jacked. Is there one showing his chest and his abs? He's got an 8-pack, ladies, not a 6-pack, but an 8-pack.
He doesn't. Surprisingly, he does not have a shirtless selfie on his Facebook. But this
well, I saw it.
This is from July of 2018. They showed it in court, right?
Yes. Mm-hmm. And so my thought was, not too many 58-year-old men have bodies like that, unless they're in the gym every single day, or you know what I'm talking about.
I know what you're talking about. We talked about it the other night.
Okay, so
maybe there were some substances involved. We're not saying that he was on steroids or HGH or something else, but we also know that if a person is on such substances, they can make them volatile, violent,
correct,
angry.
right,
Roid rage has a name for a reason.
Yes.
Right?
And so, yes.
Can't
And so
confirm
was
or
it
deny.
toxicology? Well, the Emmy will be on today, and I'm curious to find out if there was a toxicology. I'm sure
Me
there
too.
was, but I want to know what was in that toxicology report. I am on the fence right now. I don't know. I don't know where I stand. I'm not going to say names because I promised that I would not. But I met individuals that are extremely close to Ashley. One of which who's known her for 9 years. And they tell stories about what this woman has been through. That
Really?
And I'm going to hopefully after the trial and after the verdict to see about securing some actual on camera interviews. They know who I am, they know what I do. But I gave them my word that I would not.
So these are friends of Ashley.
Yes. And
are they going to be called to testify?
No.
I wonder why not.
I don't know, but
if they can back up her story, or her position, or her fear.
And, yeah, and so I don't know. No, they're not going to be called to testify. I know one would love to. This woman.
Maybe they've been precluded from testifying for whatever reason. I don't know.
I don't know. But She does have, it may not appear, okay, on camera, because again, I don't know what you guys see. She does have a good support system. She has several different pastors of different faiths that are in there every day. 3 different ones.
Really?
Yes, I don't know if you could see them or not. There's a very, very good looking uh, fella with dark hair. He's got a goatee. He wears his hair in a ponytail. He is a pastor.
Mm-hmm.
He's in there with the Bible. Then there's an older gentleman. The one I just described to you is much younger. I would say he's probably in his 30s, maybe.
Uh-huh.
Then there's an older gentleman that's in a suit. That's also a pastor from another church. And then there's the other one goes by brother, and I won't say his name.
Okay. Yeah.
But
Don't.
he is from another church, and uh, like a royal blue windbreaker because it's cold in there. And
Yeah, pastor.
yesterday he had a mask on. Today he didn't have a face mask on. So there's 3 different churches that are, showing their support for her. What do you call it? Yeah, that's it. But like I said, several people and a family member I met this morning before court and had a brief conversation with her. No, we did not talk about the trial, testimony, or anything like that. Just how you doing? How you holding up?
Mm-hmm.
Sorry that you're going through this. That was the gist of the conversation. And you know, I
Somebody,
don't want to
Lindsay's.
reveal my. Go ahead.
Yeah, don't. Lindsay's asking, was that the one with the man bun that hugged her in the hallway? I don't know what that
Yes,
means, but maybe
yes,
Lindsay's there
yes,
also.
yes. That's he's a
That's one of the pastors. Well, it
yeah.
looks like she's got some, some support there, which is good. I don't know. Everyone's worried that you're not getting a chance to eat your lunch. So,
No, I ate it. I ate it while I was talking to you.
okay.
Yeah, this deli is cool. No jurors here today, but
A deli in
everybody.
Florida?
Yeah, it's good. It's called it Sweet Deli Cafe and Catering, and it's a small little place. That they've got a sign outside. They might want to rethink taking the sign down. Jurors, media, and court employees get 15% on all sandwiches.
Oh.
Yeah, so.
So they know who the jurors are because they say, I want my discount.
Well, you know what the weird thing is, too? I'm going to tell you. I've watched I've attended an awful lot of trials.
Mm-hmm.
I have never seen jurors leave the courthouse with their juror button on.
Interesting.
Right?
So everyone knows they're a juror.
Yeah, right?
Interesting.
Isn't that calling attention to yourself?
Kinda.
Yeah.
But it's kind of like, yeah, that's interesting. So you're in the courtroom, so you know what they look like because you've been looking at them. At what point do they select the alternates? Do you know? Do you know if they've...
I was not there for jury selection, so I do not know. I have no idea. This judge does not allow juror questions. So, that's kind of disappointing, but because I would have been curious, number one, if they would even ask any questions, and if they did, what would the questions be?
Right. But did they do that in criminal trials as well? Because I know they did it in Maya, but that was a civil case.
Yeah, no, they do.
Really?
In Florida versus Curtis Reeves, the popcorn toss.
Right.
They allowed that judge that judge allowed questions. Yeah.
Wow.
And I believe only 2 jurors. I think there was only like 2 questions, but for the most part it was silent. But yeah, that judge did allow. Um, so I don't know, but there's a total of 9, and only 6 will deliberate. And I know a
Yeah.
lot of people are asking, why is there only 6? There's only 6 because it's not a death penalty case.
Right. So in Florida, that's the rule,
Yeah.
which is weird to me because I'm in New York and it's always a 12-person jury in criminal cases. But yeah, in Florida, the rule is only 6 unless it's a death penalty case, and then they have 12.
Right. So Ashley is the way she is in the courtroom. For all intents and purposes, she's like that outside of the courtroom.
Mm-hmm.
There is no personality change. You know how sometimes you behave in court, but when you get out of court, then you're more relaxed and no, not with her. She appears timid.
Genuine.
Yeah, I guess I would use the word genuine, but what really comes to mind is timid.
Timid. So what we see, so I guess when I say genuine, I mean what we see on TV as we're looking at her is not an act. She's not changing her demeanor when she leaves the courtroom and all of a sudden being loud and bombastic. She looks
The same.
timid sitting there. She looks scared. She looks
Now she
like
did,
she's disassociating,
yeah,
like as oftentimes as my chat will tell you, survivors of DV will behave in a dissociative way.
right. Like for me, I knew how to behave in front of my ex-husband. I knew what the signs were. So I knew. And I didn't come out publicly with my story until 13 months ago was the first time, and the second time was only last night. Because there's a lot of shame that goes into it, because you hear people say, why did you stay so long? Well, you don't know
Right.
my situation. You didn't live in my household. You didn't walk my walk. I do feel that she was abused. I don't doubt it. And what is upsetting to me is that this judge will not allow the testimony in about the bang bang that he did into the ceiling, the tossing of the cat, like a football across the room, and knocking a dog unconscious. Now, he admits to it. There's recordings and there's text messages. Okay.
Yep.
He admits to doing this. That is part of her claim. When things like that take place, there's fear, because you don't know what they're going to do next. If you're going to do that to a defenseless animal, what are you going to do to a child and or your wife? So I am on. I do not believe that she woke up that morning and said to herself, I'm going to kill him today. I don't believe that. Something happened. Did it happen to the extent that she had to take the action she took? I don't know. I wasn't there. She did not testify in her stand your ground hearing. I personally think that if she does not take the stand today or tomorrow, the defense should start this afternoon or late this afternoon, because the state's going to rest. They only have 2 witnesses to go, and then they're going to rest. If she doesn't take the stand, she's done for. In my opinion, she's done for.
I think she has to.
Me too. And at least she has a 50-50 shot of not being found guilty. Like, look at what happened to Marsha Thompson. She took the stand and she was found not guilty on Monday.
I know. We played that verdict reading. That was so emotional.
It was. And this is, you know, this has not been an easy thing for me to cover because it is very triggering, and I'm trying to disassociate myself from certain things.
Right.
But I I I see signs. Seeing her in person. Now, yesterday afternoon was the only time I saw her react like with anger. It was clear. And that was when the faux pas happened with the witness who said, you know, he shot the gun and the judge threw the jurors out and reamed Taylor's butt
Mm-hmm.
over that. And because of where I sit, I don't know if you saw it on camera or not. Like I said, I don't know what you guys see, but she turned around to O'Keefe, who is the paralegal, the big guy that sits behind her, and
Mm-hmm.
the look on her face, she was so, you can tell she was angry. Her cheekbones flushed up, and she was ferociously writing him a note and handing it to him. So that whole thing, that exchange that happened yesterday, you can tell was upsetting to her.
Are you talking about when the psychologist was on the stand and he sighed because he wanted to say something, and then Taylor said, "Oh, you have no idea." And then the
Yes.
judge threw the jury out and threw
Yes.
it was almost like we got the impression that the psychologist really wanted to say some stuff and really wanted to talk about it, and he was shut down. And it seemed like, yeah, it seemed we didn't really see her face, I don't think, but she did turn around right away, and she was upset that he was not allowed to say what he wanted to say. It
Yeah.
seemed to
That
us,
was the
right?
only time I have ever seen her react. Now, and you know, a lot of people, I see what people are saying on the internet all over the place that, you know, how she just sits there and she, you know, she's not, and no, she does not look at the jury. Um, for the most part, she stares ahead, or she is looking at the witness, but she's having very little eye contact with the jury. But you're an attorney. I'm
Mm-hmm.
not. But even I know an attorney is gonna, no, regardless of what you're charged with,
Mm-hmm.
your attorney is going to instruct you not to show emotion, not to do anything that you know, a jury, you know, may take the
Yeah.
wrong way or what have you. So this girl, this young woman, is damned if she does and damned if she doesn't. But I
Yep.
do believe that she is listening to what her attorney is instructing her to do, as she should. Um, and you know,
Yeah, I mean, look, you're right. She's damned if she smiles too much, she's smiling too much. If she frowns too much, she's frowning. If she's smirking, she's smirking. We watched before we came on today. I don't know if you saw the Julie Grant piece with that woman, you know, jury consultant expert talking about her outfits and how, you know, they liked her before outfits better than her trial outfits, and she's not looking pretty enough, and she's so pretty. And it's like Karen Reed, they picked apart what she wore because they thought her skirts were too short and they were inappropriate for court. This person actually said her braids were inappropriate for court. And we were just like, what? It was so, you know, it doesn't, no matter what she does, it's going to be picked apart. But
yeah,
I will say that from watching her and her behavior on camera, because the camera's on her a lot, she has not done anything that I would consider to be working against her. She seems very
yeah,
traumatized sitting
I
there. Like, I can sometimes it's almost palpable. Like, I'm watching her and I just want to give her a hug. I can feel what's going on inside her. And to me, it doesn't ring hollow. It doesn't scream that she's acting and faking it. To me, it seems like a genuine survivor of trauma. And that's just, I'm not in the room with her. You are.
yeah.
So
And like I said, outside, you know, during breaks and what have you, the only ones that she speaks to are uh, uh, the church representatives, you know, that are there in her in support of her. Her other supporters that are there, uh, they'll be talking to her, and she'll have like a half smile on her face and just a very slight nod, like acknowledging what people are saying to her. So, I don't know. I don't know where I stand. I have to wait until I want to hear the medical examiner's report, because I do have to say one thing that was concerning to
Mm-hmm.
me the day before yesterday with the one deputy detective, whoever he was, on the stand when he made the statement that Doug Benefield was cool to the touch. That concerned me, because
Mm-hmm.
we know that it takes a while for that.
He was
Uh,
still alive.
I'll see you back in court. Um, so
I
I
can't
want.
wait to hear from the medical examiner, but he was still alive when they came to the house.
I'll see you over in court. Yeah. You better behave. No more interviews. That is the woman. I'm not going to say what. No, well, I
Mm-hmm.
already did. I already did. It's WFLA. It was the
Right.
local. It was the
That's who
local.
did the interview with Eva.
Yes,
Yeah, we knew that.
yes.
I was trying to find a copy of it. Somebody said they sent it to me through Instagram, but I didn't get it. So if
Um,
somebody wants to email it to me.
and when Eva was in court today, and she went on the stand the first time, and then the judge had her leave the courtroom, where I'm sitting, I get a really good view of people exiting. As she
Mm-hmm.
was about halfway down the aisle, her face was beet red. I don't know if it was because she was mad or embarrassed. I
Uh-huh.
don't,
Both
but
probably.
but her face was beet red, and she looked at. There's two deputies that stand at the door, and she gave them both an eye roll. I found that interesting.
Hmm. We feel so bad for Eva, though. I mean, she's been through so much trauma, but I mean, somebody should have, maybe just told her that. Maybe you should just lay off the TikTok during the trial. I
Yeah,
don't know.
exactly. But it is what it is. I mean, the damage is done now. Uh, yeah, somebody should have told her, or I don't know. I don't know, but yeah, she was not a happy camper at all. Um, uh, on that. Um, and so I don't know, and I don't know what.
Jules, we just lost you. Wait, what did you say? I don't know. You just lost signal. Jules, if you can hear me, we lost you. Okay, we lost Jules, but I thought that was some great intel, you guys. What say you? That was some good stuff. All right, let's take a quick break. I'm going to keep it into one stream today. I'm going to put up the break sign. I think we all need a little bit of a break for a few minutes. So let's, it says court's coming back around 12:45. It's 12:30 right now. Let's take a quick 15-minute break so my mods can get something to eat. And, as the court calls it, a comfort break. And then we will come back a little before 12:45. So just hang and we'll be back soon. If I can find the, court is on a break. We're back, and the camera is up in the courthouse. Everyone have a nice little break. That was fun having Jules call us from the courthouse, wasn't it? One difference between the Karen Reed trial and this trial is that the courtroom here is very cold, she told us. Jules told us the courtroom is very cold and she's freezing. Hello, Gringa. I'm late. Any testimony about the dog yet? Nope, not today. Nothing about the dog yet. They did mention it in their opening, though, the defense did. So I'm thinking something's going to come in about the dog abuse. Barbara says if he's a martial artist, aren't his hands considered a weapon? I don't even know if he needs to be considered a MMA fighter or a martial artist for your hands to be considered a weapon. But that's a great point. Thanks, Barbara, for your super chat. We did learn that Eva Benefield, his daughter, is a black belt in jiu-jitsu or taekwondo or jiu-jitsu. I don't remember. So that was interesting. Black Horse, thanks for the 5. Thank you, Melanie, for your coverage and keeping it classy. Your chat is the only one where I feel comfortable participating in. Thank you. I'm glad that you feel comfortable here. Hello, Black Horse. Disabled Rebel, thanks for the 2. Just read steroids increase copper, iron, and zinc levels. That's interesting. Sarah in shock and horror leaves us with a quote. And thank you so much for your very generous 25. I don't think people realize how much strength it takes to pull your own self out of a poisonous situation until someone you love deeply, with someone you love deeply. So if you've done that today or any day, I'm proud of you. Unknown. I'll read that again, uninterrupted and properly. I don't think people realize how much strength it takes to pull your own self out of a poisonous situation with someone you love deeply. So if you've done that today or any day, I'm proud of you. Thank you, Sarah and shock and horror. And welcome to Deborah Bergen, new member. Camera's up, but nothing's really happening yet. I gotta change that background. They don't have the sound up yet either. There we go. Jules also told us, Jules is our courtroom watcher, she wasn't noticing the jury looking at Ashley at all. And that yesterday when Stephanie Murphy testified, they all of a sudden became very engaged and interested. This is just Jules's opinion from sitting in the courtroom. And that it seemed to her, her gut was that they liked that officer. Officer? Was his name? Was he an officer? Was he a deputy? But I don't remember. Gillum, the DV investigator. So I don't know what to make of that. Those were just her own personal observations from inside the courtroom, which I thought are very interesting. It's always interesting to talk to somebody who's sitting there because they can just tell us about their observations. I also was just looking at the court TV. Court TV has a poll up. Guilty, not guilty, or hung jury. And so far, this is just the court TV poll, and you know who's over there in the chat if you've been there. Guilty, 66%, not guilty, 22%, hung jury, 12%. That is the poll that they have taken today. Jules also did tell us that she, in her observations of Ashley, seems very timid. Despite the fact that she's tall, she is very slender. And that her demeanor doesn't seem to change when she's inside the courtroom and outside the courtroom. So it's not like all of a sudden she goes outside the courtroom and she's loud and bombastic. She said that's authentic.
All right, good afternoon, everyone. We're back on the record in State versus Ashley Benefield. We finished the lunch break, and before we bring Deputy Keyless or Detective Keyless back in, we had left off a bench conference with the defendant seeking to admit and then question Detective Keyless on Defendant's Exhibit 3, which I will describe as, and it's been told to me that these are from Ashley Benefield's phone. And the printout is from Cellbrite, which the detective testified is one of the software packages that they use to extract and organize data and then put it in a readable format. I will note that in looking closer at Defendant's Exhibit 3, the report, the Cellbrite report, has a start time of August 29th, 2016, and a last activity of April 19th, 2017, and lists 319 attachments. However, Defendant's Exhibit 3 only encompasses August 29th, 2016 through December 3rd, 2016, and the page numbers are not sequential. That is, it's page numbers 1, 786, 222, I'm sorry, 222, 2,222, 2,224, 2,233, 2,237, 2,240, 2,263, 2,264, and 2,266, although I'm assuming that's just because that's the relevant portions that the defense wants to get into. Certainly state, I'm sure you have these as well, and may.
Well, I guess one of the issues, Judge, is that we aren't being showed anything from the defense until Mr. Taylor's at the podium, and we have to ask. So I don't know what they're using because they've never filed a discovery in this case. The only thing they filed is a defense exhibit list, which had the 391 things on it. I have something called WhatsApp AV texts, but they're not all the same. They're some of the same. And so I don't know what's in that exhibit because we've never seen it more than a few seconds before we had to give it over to Your Honor.
Does anybody know how tall Ashley is? I thought she was 5'9". I think Doug was also 5'9". So if you do know how tall Ashley is and you can confirm, put it in the chat.
I think we're kind of being sandbagged here because this continues to happen. What happened yesterday with Ms. Murphy, those were items never turned over.
Lunch break.
You don't mind.
Deputy Keyless.
You've raised a much more fundamental issue. There was no defendant's exhibit, witness list and exhibit list pursuant to the rule?
No, there's a defendant's witness list that was filed on June 21st. There's then something called a defendant exhibit list, which does not cite any rule. It's not listed as a discovery. It was also filed on June 21st. So there's no there's never been a formal discovery filed in the case. And we didn't receive any of the names of the witnesses or the 391 items we got about a month before trial. And in those items are things that aren't clear of how to even deal with them. And I know that's hard to describe, but there's emails. There's a million IAs that would never be admissible. There's a lot of things.
A million.
IA report, internal affairs report from the sheriff's office, things like this. So I did my best to go.
Oh, who's under internal affairs investigation? That's interesting. They've got internal affairs reports in their exhibit list. The defense does.
Because we're not being shown it until he's standing at the podium with it already marked. I don't know what any of this is, and it feels a little bit like trial by ambush.
Trial by ambush.
Under the rules, much of this should have come to us way earlier than it did. But if Your Honor checks the court file, which I have thoroughly, there's never been a formal discovery filed by the defense, and the initial witness lists were filed in the late June.
That probably would have liked to have addressed that well before trial. Could have also filed a motion to compel after the.
Yeah, coulda.
What is it? The defense has 15 days. So.
Coulda, shoulda, woulda.
They attended a deposition of Sergeant Keyless where we had the specific text messages that the court has seen. They were clearly aware of them. We responded. What we received in our discovery, among other things, was what we refer to as a phone dump, D-U-M-P. Thousands of documents. We have to go through that, searching for what we believe is anything relevant that may impact the trial of the case. Our response was to send that phone dump back and put the state on notice that anything in what they provided to us was fair game, that they should do the same, search it. We treated them no differently, Judge Whyte, than they treated us. It's not realistic, and I understand why we received the phone dump like that. It's not realistic to require them to go through such a massive amount of data and single out specifically what they intend to use, because I know the court well knows this is a fluid process, and as the trial date approaches and it's finally carved in stone and it actually begins to happen, then the attention begins to turn to the nuances of all of the subtleties that comprise a trial of the case. We did the same. We did not know specifically what we needed, but at the deposition, I clearly presented these to Sergeant Quiles, and he acknowledged that they were part of what came out of this extraction.
There's no way for me to fix the volume just now. It's only because the attorneys are not standing in front of mics. So hopefully when the witness gets back, it's going to be fixed, but I can't change the volume now because then later it's going to blow your ears out. So if you can just try to turn the volume up, and it depends on what device you're watching it on. It depends on whether you're in your car, you've got headphones on. So this is, there's not a lot I can do about this except I'll check Law and Crime and see if their volume is better.
Through the Bright Line program.
All right, final thoughts. I'm considering this somewhat of a Richardson hearing. Go ahead.
Judge, I think Your Honor is well familiar with the rules of discovery, but the defense obligation is different than the state's obligation. The state's obligation is to turn over everything in the possession of the state. The defense obligation, as it says directly from the rule, is any tangible papers or objects that the defendant intends to use.
Can you slow down a little, please?
I keep forgetting. Any tangible papers that aren't clear of how to even deal with them. And I know that's hard to describe, but there's emails, there's a million IAs that would never be admissible. There's a lot of things.
A million.
IA report, internal affairs report from the sheriff's office, things like this. So I did my best to go through it, but because we're not being shown it until he's standing at the podium with it already marked, I don't know what any of this is. And it feels a little bit like trial by ambush, which certainly under the rules, much of this should have come to us way earlier than it did. But if Your Honor checks the court file, which I have thoroughly, there's never been a formal discovery filed by the defense. And the only the initial witness lists were filed in the late June.
That probably would have liked to have addressed that well before trial. Could have also filed a motion to compel after the, what is it, the defense has 15 days. So, all right, please.
They attended a deposition of Sergeant Quiles where we had the specific text messages that the court has seen. They were clearly aware of them. We responded. What we received in our discovery, among other things, was what we refer to as a phone dump.
Yeah, we already heard this. Hang on. Let me just switch to court.
Thousands of documents. We have.
Certainly, I think the defense is required to notify the state what portions of that evidence that they intend to use at any.
Is that volume better?
Trial or hearing.
That's better to me.
But I'm not going to find that there was a willful violation of the discovery rules because it sounds like the defense provided. I haven't heard specifically. It may not be in the format that we're looking at, but according to the defense, they provided the dump from Cellbrite.
Well, and also, Judge, here's a copy of Sergeant Keyless's deposition of May 31st of last year. And these exhibits, proposed exhibits, are attached to his deposition.
All right.
Judge, can I just clarify real quick? The defense did not provide us a phone number. We provided it to them. They listed it and said it's in our possession. So they did not provide us a phone
Okay, so she already had it.
And they never specifically stated this document from the phone dump will be used in trial.
All right. I do think the defense, you have that obligation, though, under the rules to identify witnesses and tangible objects, documents, things that you intend to use. It's very specific in that regard. So I'm not going to find a willful violation because this has been in the state's possession. But defense, you need to let the state know what you intend to use at trial or hearing. And that also includes your list of witnesses, which I understand has already been done.
The state gave that discovery to the defense. They already have it. So, exactly.
I don't think I have enough information in front of me to determine whether it's trivial or substantial or willful or inadvertent. Well, the willful or inadvertent, I think I can find because the state had all of this. I'm just going to require defense from here on out. You need to identify the exhibits that you intend to use at trial or hearing. All right, so
We can just request that be done before we're in the middle of examining it.
and copies need to be shown to the state prior to showing them to a witness.
Of course.
All right, so let's get going on what we were talking about. That being Defense Exhibit 3, and we had an objection. So go ahead as the proponent. The objection's already on the record. Go ahead as the proponent.
Yes, court wants to take up now the admissibility as a.
Okay, that's Jules right behind this gentleman here. She's wearing a gray sweater. That is Jules right there. Hi, Jules. She called in during lunch to give us her observations from the courtroom. Now you can put a face with the name.
Relates to specific instances
of Exhibit 3.
Yes. Okay. So we think the predicate has been established by virtue of the 9/11 call and the testimony that was offered by Mr. Sand, especially including the spontaneous, excited utterances of Ms. Benefield that could be heard in the background, that my husband attacked me and I shot him. Now, as the court well knows, I provided Your Honor on May 16th, 2024, with a memorandum, use of discovery depositions as substantive evidence in criminal trial. I also had previously filed on July 10th of 2024, a defense request for clarification of court's amended omnibus order. And without beating it to death a second time, I cited the court to Smith versus State, where the defendant was awarded a new trial because the court's refusal to allow various witnesses other than the defendant to testify about specific acts of violence allegedly committed by the victim. The Florida Supreme Court held that specific act testimony of third parties may be admissible as corroborative evidence if it is first shown that the defendant knew about the very same act of violence. So I know that the court is familiar with that, but in addition, I have for the court the following opinion. The Smith case is a pretty good evaluation of this issue, Judge. It's a first district case, September 4th of 1992 at 606 Southern 2nd, 641. It said as follows. Consequently, if there is the slightest evidence of an overt act by the victim, which may be reasonably regarded as placing the defendant in imminent danger, all doubts as to the admission of self-defense evidence must be resolved in favor of the accused. So I think clearly Mr. Sand and the 9/11 call qualifies, and I'll tell the court specifically why. In the matter, Your Honor, of Henry versus State, which is a Second District Court of Appeal decision found at 290 Southern 2nd, page 73, goes back to February 1974, Your Honor. What was particularly interesting about this case is the second DCA reversed and remanded for a new trial because the trial court refused to allow the defendant to introduce specific acts of violence. And this is what the court said. The necessary predicate for the admissibility of either the dangerous character or individual violent acts of the victim is some evidence of an act on his part which would reasonably suggest the need for self-defense. They cite several cases and then they say the following in that same footnote. That prerequisite was satisfied here by evidence that Barrow, the victim, thrust his hand into his pocket, whether for a car key or, as Henry, the defendant, said he thought for a pistol, immediately before the defendant shot him. I have to say, Judge Whyte, respectfully, if thrusting one's hand into the pocket is enough to satisfy sufficient evidence so that it's resolved in favor of the defendant when it relates to specific act evidence, a 9/11 call capturing an hysterical Ashley Benefield saying and witness repeating, "My husband attacked me and I shot him," clearly beats the pants off of thrusting a hand into a pocket. So I think we've established the predicate, respectfully, Your Honor.
Do you have a copy of that case?
Absolutely.
Could I hear the citation again?
And I might remind the court, in addition to that, Miss Benefield had the scratches on her side and the swollen eye. Here is the Henry case, Judge. Now.
Yeah.
Do you mind?
290 Southern 2nd, 73.
And I have one as well. I don't know if they want to hand it up now. I'll read it.
So I believe they're talking about the portion of the 911 call that had originally been redacted where Ashley says, "My husband attacked me and I shot him." We did hear the neighbor testify that she told him that, but I think that the defense now wants the jury to be able to hear it based on this case law. I think I agree with him. See what the judge does. A little bit behind.
Just reviewed Henry.
Yes.
All right, I've reviewed Henry.
You want me to comment on BRIIAN case that they just provided?
I haven't read it yet. You can if you want, but I'll probably let them go first. All right, go ahead, State.
Judge, to be honest, we are still going through what they're trying to introduce because this is missing pages from the exhibit that they were talking about. So we don't have, I can't even speak to exactly what's in that. So I apologize if I get it wrong, what they're trying to introduce. First, Judge, there has to be an overt act, yes, regardless of how that's proven. I believe once that is proven,
Other acts of violence can come in to show that the defendant's apprehension was valid at the time she had to use self-defense. The only way we know that any of these things added to her apprehension is if she says it did. And the case that I just handed up, the BRIIAN case, is an example of that, where there were prior acts of violence, but because they were so attenuated, they were, I believe, 4 years before, and I will read, it's a highlighted portion on page 2 of the case. With respect to the excluded evidence, however, the trial judge found that the unfair prejudicial effect of the evidence substantially outweighed its probative value, considering the prior incidences' remoteness in time, the lack of connection of intent and the crime charge, and the speculative nature of any real connection whatsoever as far as any apprehension in Britton's mind. I do believe that even if the 911 call substantiates some sort of an overt act, which I still believe the defense has to put that in, but even if it does make an overt act, that these items that the defense is trying to introduce are still not admissible because we have not been informed by the defendant or otherwise that any of these things that the defense is trying to get into went into her apprehension and caused her fear and caused her to react the way she did. Additionally, at least from what I could tell from what I think is in the exhibit, I don't believe there are any acts of violence even spoken about in the exhibit. There's language, there's defendant saying to think of you with anybody else makes me crazy. I don't know that those are acts of violence. All of these cases talk about acts or threats of violence. And I don't find that there are any threats in any of this, or there are certainly no acts that are described in this that have happened. So I would say it doesn't meet that requirement anyway as a prior act of violence. And even if it did, I think we have to have some evidence that this, being so many years ago, played into the defendant's decision to use deadly force. So we would object at this point.
Sir? We expect to call and testify a domestic violence expert. That domestic violence expert is going to educate the jury, that he should educate all of us about how domestic abuse is cumulative. It builds and it creates this overwhelming anxiety. As the court knows, this entire case revolves around a 4-year relationship. This is the beginning of the insight that Ms. Benefield gains that ultimately and very shortly thereafter leads to her leaving Doug Benefield. And the court may recall, because I shared a letter with the court, that Ms. Benefield left Mr. Benefield when she left him, describing and explaining how she feared for her safety and that of her child being with him, that he was controlling, that he did the following acts, from shooting the gun to punching the dog. The domestic violence expert is going to say all of these things remain in an abused person's mind, so that on the day of the incident, September 27, 2020, despite the fact that it was at the end of the 4-year relationship, that is why the reaction of Ms. Benefield was appropriate or was not unreasonable given all of this prior history. And that's also why the case law that I provided, Your Honor, says domestic violence expert testimony should be admissible for exactly that reason. So here's what's happening, Judge Whyte. The state just introduced 363 text messages and played a video. Why did they do that? They did that to show, because it's the central theme of their case, look how well they got along. in the week prior to the shooting, smiley faces, they're having lunch at the restaurant, everybody looks happy. The domestic violence expert's going to confirm what Dr. Broder told us and what Dr. Quintal told us, is that in the face of an abusive relationship, getting along and going along is always the best course of action that these women embrace, especially when a child is involved, because it is the safest manner to keep the beast at bay. I believe those were Dr. Broder's exact words, keep the beast at bay. So here is the beginning, where she looks at these messages and she doesn't quite realize the significance of them. But shortly thereafter, once he starts firing the gun into the ceiling and putting it against his head, punching holes in the drywall, punching the dog unconscious, now it's beginning to dawn on her, oh, the guy that I married is not the guy that I thought he was. And now you begin to enter that mentality of abuse, and you begin to develop a survival instinct for it. So that's why you employ the get along, go along. You do not want to do anything to antagonize the abuser for fear of reprisal. And Dr. Quintal told us exactly that Ms. Benefield's concern, and the court may recall it was the state that asked this question. Dr. Quintal was Ashley Benefield concerned about the release of the Broder report. Remember, Judge, I served it up on the head of a pin. The theory of the state is that Ashley Benefield killed her husband because the Broder report was going to be released 3 days later.
Right.
Question, Dr. Quintal by the state. Was Ms. Benefield concerned about the release of Broder's report? Yes. Why was she concerned? She feared a reprisal from Douglas Benefield when and if he learned what she had to say about it. So this is consistent with that syndrome. I think it should be admissible. I think we've established that in the record, she says she was attacked and she shot him, and she doesn't just say it. The court's ruled it was a spontaneous statement. She's hysterical. Even the cops described her as hysterical. In fact, one said he thought she may have been in shock.
All right, thank you both very much. Let me clarify. I'm pretty sure the ruling that I made regarding the 911 specifically revolved around Mr. Sant's statements. I found that they weren't excited utterances. I found that they were, some people call them present sense impressions. Some people call them spontaneous statements. And therein lay the order. I had specifically, I recall saying that I had not heard about or argument as to the defendant's statements in the background. I remember I said if those were going to be introduced as excited utterances, they would have to be through the witness when he was on the stand. Here nor there was no objection. You could hear certain statements being made in the background of the 911 call. I think both sides are really talking about a macro issue, whereas this issue is much more refined than that. In order to, because I looked as well over lunch to try and find an answer to this particular question, because I think the argument being made by the defense to allow specific incidences of violence or aggression by the victim is new and novel. I think it's fairly unique in arguing that that occurred during the state's case in chief. And I'll start my analysis because I think this is a unique issue. I don't know if it's a issue of first impression here in the state of Florida, but I can say I didn't find a case on it, and neither side has presented a case to answer this question. And so I start my thought process by saying that self-defense is an affirmative defense. So generally speaking, the state must prove its allegations beyond a reasonable doubt. If the defense then wants to assert an affirmative defense, the burden shifts to the defendant to prove, using competent and substantial evidence, that is admissible evidence, by a preponderance of that competent substantial evidence, that she acted in self-defense or acted under duress or necessity or whatever affirmative defense is being asserted. Then the burden shifts back to the state to disprove self-defense beyond a reasonable doubt. And as has been noted by both sides and the court as well throughout, that the case law, and I also start with Smith, which I quoted in a prior order, and this is, again, Smith, 606 Southern 2nd, 641, and this is at 643. Before a defendant may offer either type of character evidence, which is specific act, of course, we know that the defendant has to have knowledge of that, or the reputation, which the defendant doesn't have to have knowledge of. And again, I'm reading from Smith at 643. Before a defendant may offer either type of character evidence, he or she must lay a proper predicate demonstrating some overt act by the victim at or about the time of the incident, which reasonably indicated to the defendant a need for action in self-defense. And then we get into if the defendant lays that predicate and there's the slightest evidence of an overt act by the victim, which may be reasonably regarded as placing the defendant in imminent danger, all doubts as to the admission of self-defense evidence must be resolved in favor of the accused. There's also Warren that we have been discussing. 577.
What if the only way to show an overt act is by the defendant's testimony and she has the right not to testify? I don't like where he's going with this, but let's listen.
Southern 2nd, 682. And in that situation, the evidence was kept out and the trial court was reversed on that. There, the defendant sought to introduce evidence that Taylor, the victim, was a cocaine user whose habit had grown progressively over time. The defendant proffered, so the defendant testified that when the victim was unable to obtain cocaine, he became violent and argumentative, picked fights. The defendant also testified in that proffer that the victim appeared to be in the throes of cocaine withdrawal and that he was afraid of her. And the proffered testimony was excluded. And I use that as an example, again, to show my line of thinking that, yes, the homicide defendant can get into these things, but there must be that burden shifting and the defendant presenting evidence affirmatively, competent substantial evidence to prove by preponderance that she was lawfully justified in using force likely to cause death or great bodily harm or not likely to do so. Finally, there was one other case in Hedges, which is another case I think we've talked about, is 667 Southern 2nd, 420. And this is at 422 and 423. It's first DCA 1996. And it talks about exceptions to character evidence not being admissible, where evidence of the victim's reputation for violence or specific
acts of violence are admissible when the defendant knew of the victim's violent acts or of his violent reputation at the time of the alleged offense. This case is from '96. I think there's other case law now that establishes the defendant doesn't have to know about the reputation for violence, but here and there. That evidence of prior specific acts of violence by the victim is admissible if it is relevant, because it is relevant to reveal the reasonableness of the defendant's apprehension at the time of the incident. However, even Hedges says, before the defendant may offer this type of character evidence, a proper predicate must be laid by evidence of some overt act on the victim's part at or about the time that reasonably indicated a need. So the reason I wanted time over lunch to try and find some cases, if there was any cases that had said that predicate can be laid during the state's case in chief, and I was not able to find it, and I looked at Henry, I was reading Henry that the defense produced, to see if it explained factually how the information came in regarding the hand in the pocket, and it doesn't say. It just says that the trial judge excluded evidence.
I don't either.
And unfortunately, it doesn't give any indication about whether that was during the state's case in chief or the defendant's case in chief.
May I make an inquiry of Your Honor?
I'm sorry?
May I make an inquiry of Your Honor relative to what the...
I guess you can ask, but I'm in the middle of a ruling.
Yeah, wait until you hear the ruling.
Well, I think it may be relevant, helpful for the court's ruling. I think what the court is saying is it's looking for some guidance as to the procedural aspect of whether or not this evidence can be introduced during the state's case as opposed to the defense case.
Correct.
Okay, so.
Right, and that's what I'm making my findings about.
Yeah, and the only thing I would say to the court, directing myself exactly to that, is I don't think any of us would dispute that self-defense is a recognized justification. I don't think any of us would dispute the 9/11 call, he attacked me and I shot him. The only thing I would say to the court is, to the extent Ms. Benefield is presumed innocent, wouldn't the court rather want a case that says it cannot be introduced during the state's case in chief, rather than assuming it can? I think the defense is entitled to the benefit of the doubt. And in the absence of case law that says the defense may not introduce this during the state's case, I think we should be entitled to it.
All right, thank you. So I did think it was an interesting issue. So I did the research. And this may be the case that ultimately, if it gets to the second DCA or the Florida Supreme Court, where we get the answer saying that unobjected to statements or excited utterances by the defendant on a 911 call played during the state's case in chief would be sufficient predicate for that overt act to raise self-defense and allow prior acts into evidence during the defense cross of the state's witnesses during the case in chief. I'm not prepared to make that ruling today. So I'm not saying that the WhatsApp messages are not admissible. I'm just saying that I don't think they're admissible at this point. So that's my ruling.
Thank you.
All right, so they may come in during the defense's case, so.
Just, Judge, for the future, if in fact these WhatsApp messages do come in another way, we would also be asking for the rule of completeness of the rest of what was taken out the that.
Well, that's why I mentioned earlier, because you certainly, there may be other ones that you want to introduce.
Right. So I just to put defense on notice that may be an issue.
So we're going to bring
We're going to bring the witness back in. And you can resume your cross.
Well, it sounds like that evidence may be able to come in later, where she said, he attacked me and I shot him. I guess we're going to have to wait and see. They should have, how many more witnesses after him? One, I think, right? The state, they may rest today. Sirens outside reminds us of the Karen Reed case.
And I would have an objection.
You do?
Yes.
Okay, can you step back out? Sure.
You have an objection to what? He didn't ask anything yet, did he?
Okay, can you...
Suzanne, the remaining aspect of my cross, anticipating there may be some objection to it.
And I would have an objection.
All right, so now they're going to send him out again, and she's got an objection, so.
The phone.
Supposing, because I can't.
Yes, ma'am. The witness is out.
I'm trying to interpret this as fast as I can, but this, then maybe the defense can confirm. I believe these are supposed Google searches or internet searches for certain subjects.
Yes.
That are on
Yes,
this
they're
medical
on
stuff.
the phone,
And
that of which was extracted by this witness.
there are things like, ask Amanda, how do I co-parent with an abuser?
How do I co-parent with an abuser?
Co-parenting versus parallel.
Those are her Google searches. And this guy on the stand right now, Keyless, is the cell phone expert. He's the Celebrite expert. He's the guy who extracted all of this stuff from her phone. And these are her Google searches. They should be allowed in.
Parenting with an abusive ex, the Good Men Project.
Can you give the judge the date of those?
The first one was, I'm sorry.
2020, Your Honor.
The first one was 5/11 of 2020. That was the ask Amanda, how do I co-parent with an abusive, or parent with an abuser. The next one was the same date, and that was co-parenting versus parallel parenting with an abusive ex, the Good Men Project. Same day, 6 tips to help you co-parent with an abusive ex. And then there appears to be what I would assume is one of the Bible verses that was sent.
Yes.
By Doug Benefield, which says, for the wages of sin is death, but the gift of God is eternal life in Jesus Christ our Lord. Romans 6:23.
Yeah, that one was shown by the state. They just moved past it a little quickly.
So, Judge, I have several objections to this. First, what is the relevance of her searching for these?
It's exculpatory.
Things?
It's exculpatory. It goes to her state of mind. And it shows that in May, 4 months before the shooting, she was trying to co-parent with an abusive partner. And you're trying to say that he was not abusive. So it's absolutely relevant.
Second, she cannot just put on information that she was looking for abuser information without taking the stand and saying that she thought he was an abuser. And also, by her entering this on her own behalf, it's hearsay that she's typing in these things as she's searching.
Okay, but you get to use all of her text messages against her that your guy extracted. So like, shield sword, my friends, you can't use it as a shield and a sword. You can't say, well, we're going to use all of her text messages against her and she doesn't have to get up to testify. But we're not going to let defense use the Google searches that our guy that we put on the stand extracted from her phone because she didn't testify. Yeah, it's starting to make me mad too, right? Right, exactly. Then nothing's admissible, right? Okay.
So I would object to any of this.
Are you looking for the truth or are you just looking for a conviction, ma'am, counselor?
Okay. Okay, relevance. Let's see, Your Honor. These are 5 internet searches on the phone that Sergeant Quiles extracted. First of which is on May 11th of 2020. And the subject is domestic parenting with an abuser.
I'm sorry, it's a search or it's an article?
It's a search, an internet search. This is Ashley Benefield, who, according to the state, as the court knows now, killed her husband to stop the release of Dr. Carruthers' report. A few months before the shooting, searching the internet for how to co-parent with an abuser, and then again on 5/11/20, asked Amanda, how do I co-parent with an abuser? On 5/11/20, co-parenting versus parallel parenting with an abusive ex, the Good Men Project, and 6 tips on 5/11/20 to help you co-parent with an abusive ex. So the relevance, I think, is acute. Our whole theory of defense is that Doug Benefield was an abusive spouse. We have been denied the opportunity to introduce any evidence of that at every turn based on 2 rulings by the court. The first being the break. Once the 9/11 tape came in, which said my husband attacked me and I shot him together with the swollen eye and the scratches, as the case law says, I think that may certainly qualify for the slightest evidence.
I just ruled on that.
All right. Then we find ourselves now in the same position as the ruling that the court just made, excluding the text messages of Doug expressing the murderous.
You said I excluded them? I did not exclude them.
You're not allowing me to introduce them.
I said not now,
No,
at this point.
Okay, so that's excluded, at least at this point.
Okay, go ahead, sir. I'm sorry for interrupting. Go ahead.
You're admitted.
So he's right. The judge doesn't need to take this so personally. He did say you can't use them now. We don't know. He didn't say you can't use them now, but I will allow you to use them later. He said you can't use them now and we'll see later. So yeah, technically they are excluded as of right this moment. And Mother of Cats points out if she had searched how to get away with murder, the state would have argued for it to be allowed 100%. The world may be watching this case as well. And is this how we're going to treat survivors and victims of DV in a courtroom that is broadcast worldwide? If you are watching from outside the US, please chime in the chat where you're watching from. I don't know what his ruling is going to be yet, but I'm horrified so far.
Now I find myself in the same position, except now the evidence is much more acute and much more corroborative of an abused woman's fear. Here we have in her quiet, most private moment, what is she doing 5 months before the shooting? She's searching the internet about how she is to get along with an abusive ex-spouse. If that doesn't go to her state of mind about fearing Doug Benefield because he's abusive, I don't know what does. Now, procedurally, I can't provide the court with a case that says you're not allowed to introduce such persuasive evidence in the state's case. Again, I take the position, Your Honor, that the state should produce evidence that says I can't. And if they don't produce that evidence, then I think, at worst, it's within the court's discretion. And I think it would be an abuse of discretion to not allow me to introduce this evidence and the state's whole theory that they just spent an hour and a half with this witness was establishing how well she and Doug Benefield got along in the week prior to the shooting. I told the court, several times now. That's the whole MO of an abused woman, is to get along and go along and act like everything is okay. That's why both Broder and Quintal have told the court and told the jury, yes, Ms. Benefield was different. She acted differently when she was here and she saw me with Doug. At that time, she would always act deferential, but when she was by herself, she let me know, I don't want anything to do with this relationship anymore. So, Your Honor, I think in the interest of justice and fundamental fairness, I should be entitled to ask this witness to identify this information, which came in the same extraction he did for the state for the last hour and a half.
He can authenticate it. He did the extraction. He can authenticate it. Should the defense be now burdened to call him back on their case in chief?
Response?
Judge, the reason this should not come in is the exact same reason that you just ruled on the last issue. There are other reasons if it becomes relevant, if it becomes admissible, but that would be my reason.
Could I please see the exhibit?
Of course. Ma'am?
Going to be an extraction of a list of her Google searches. We're a little bit behind. If you're ahead, please don't put any spoilers in the chat on rulings.
Exhibit.
That Ms. Benefield. And the purpose of offering defense exhibit 4A is to prove that Ms. Benefield actually made those searches.
Yeah.
It's not being offered for the truth of the matter any more than the state's exhibits that Sergeant Quiles went through are being offered for the truth of the matter. It's being offered for the identical reason. This is part of what was on her phone. It shows her state of mind prior to this incident, and it is relevant to the defense. In fact, it's the backbone of the defense.
They can argue that she made those she made those searches intentionally to set it up like she was being abused. They can argue that in their closing, but he's the extractor of this cell phone, and they should come in
Previously, I had made the ruling
actual searches made on her phone.
That the text messages were admissible not for the truth of the matter asserted, and I was not asked to give any sort of limiting instruction, but I believe I had previously either I expressed that or during a ruling or put that in a prior order. The admissibility of those items and documents was established through the state's case. Let me start here. 3 things for admissibility of evidence: authenticity, relevance, and admissibility. So the authenticity for the text that we're talking about, the potential internet searches and so forth, the state provided that case. It came, the testimony is that it came directly from either Ashley Benefield's phone or Doug Benefield's phone. And the case provided by the state, I don't have the site in front of me now, the authenticity was established by the technical services officer explaining when and how he downloaded them. But authenticity doesn't automatically mean admissibility. We still have relevance and admissibility. Relevance, I understand what the defense is saying and how it's relevant to their case. And we've had this discussion on a number of pieces of evidence that the defense is trying to get in. And I understand how they're relevant. I understand the arguments, but I cannot blindly disregard the third prong, which is admissibility. And just because it helps a case or hurts a case doesn't make it admissible. I'm trying to think of, I know you're saying you're not.
It's not offered to prove the truth of the matter asserted. It's offered to show that the search happened, Your Honor.
Not offering it for the truth of the matter asserted, but I can't think of any other reason to put that information, these internet searches, in front of the jury.
The fact that she was
that Ashley
abused.
Benefield made these searches on a certain day.
It doesn't matter
so
what
it's an
day it was.
out-of-court-
It doesn't matter what day it was. It was before the shooting. It was in May, 4 months before the shooting. It doesn't matter what day it was. It wasn't after the shooting. She wasn't trying to make up an excuse after she killed him.
Statement used to prove the truth of the matter asserted. I'm happy to consider case law if you have some that says that I'm wrong.
I'll go find it. I'll go find the case law. And if the case law doesn't exist, it should.
So at this point, I'm going to rule that they're not admissible.
Oh,
I have no further questions of Sergeant Quiles.
I've just lost faith in the Florida judicial
I would
system.
like to make a proffer if I could for the record.
Please.
Of course. Do you want me to call him back in for the proffer? Or are you just going to proffer?
No, yeah, I'm just going to read.
Yeah, no, he should call him back in and make him read them on the stand and make him authenticate them about when they were made, what time they were made, if Celebrite is accurate, and if her phone really did make those searches. Bring him in, Taylor.
It's Exhibit 2, anticipated Exhibit 2. These were text messages that were downloaded by Sergeant Quiles.
Judge, can we just copy that and put that into evidence?
Yeah, can you show a copy to the state?
He did.
Oh.
But if we could just make a copy and enter it.
Oh, we already have an Exhibit 2, the clerk says.
Yeah, it didn't make it. I had marked it as Exhibit 2.
That's the text messages.
The concealed weapons permit?
No, sir.
That's in.
Oh, I'm sorry, Exhibit 3. I had marked it as Exhibit 3, the text messages, and it did not make it in.
Okay, got it. Yes. These are text from Doug Benefield's phone to Ashley Benefield's phone downloaded by the officer.
Correct.
Right? So you want to put it in the record?
Yes, sir.
All right. You don't have to read it. I mean, it's going to be in the record.
Oh, the world wants to hear it, Judge.
So that's 3. Did you also want to do 4A?
Yes, composite.
State, for purposes of the proffer, do you believe that Detective Quiles would testify that he downloaded Defendant's Exhibit 3 and 4A from Ashley Benefield's phone?
I believe he would, Judge. I don't know specifically with the second exhibit.
Bring him in.
Because I haven't investigated that, but I would assume yes.
All right, is that sufficient for your proffer?
Yes, sir.
Do you want Quiles to stay under subpoena?
Yeah, you're going to have to call him back on your case in chief.
Because I want to give him the right instructions.
Yes.
All right, can you have Detective Quiles come back in?
Wow, this is outrageous. She's
I'm
not
so
allowed to
focused on
defend
getting
herself
his
unless
name
she
right.
takes
I
the
keep forgetting
stand.
his title.
Judge, if it makes you feel better, it took us about 2 weeks.
You may not discuss your testimony or the question of sequestration been released from your subpoena. So all the instructions I gave you regarding sequestration of witnesses still apply. You may not discuss your testimony or the questions asked of you with anyone, including the attorneys or other witnesses. You can't discuss with other witnesses what their testimony was or what questions were asked of them. And to the extent that this trial is being out there on the internet, you are not to watch or listen to anything related to it, including news news reports. Do you understand? All right, sir, you're free to go now. If one of the parties calls you, you need to respond. Thank you. Oh, hold on. All right. Look, the clerk needs us to be clear on your proffer. Mr. Taylor, we have Exhibit 3, which is the
text message,
the What's Now apps, WhatsApp messages. All right. That's document 3, but it's got multiple pages.
Yes, sir.
4A is not just 4A. It's 4A, 4B, 4C, and 4D. So we have
the composite.
Composite 4 with A, B, C, and D. And then actually you had 5 was the Bible verse.
Yes.
All right. Well, the Bible verse, that's already in.
Yes.
I'm not denying that at all.
Thank you.
Do you want?
Well, I'd like to have it on there because they showed it, but they showed it very quickly.
Oh.
Defendant's Exhibit 5, which is
Sorry. Yes.
one of the I think this might have been the last one or one of the last ones.
Yeah.
All right, so there's a stipulation to the admission of Defendant's Exhibit 5, so that's in. Thank you, Madam Clerk, for catching that.
Well, it's
right. 5 is in. 3 and 4 are proffers.
When you say, Your Honor, that Exhibit 5 is in.
I agree. Tracy, we are watching her be abused again right now by the system. We are watching this in real time. This should outrage you. This should outrage you. I don't know what's in those WhatsApp messages. Does anybody know what's in the WhatsApp messages that they're talking about and trying to get in?
For purposes of proffer.
No, for evidence.
Yeah, it's not going to do me any good as a single exhibit, Your Honor. I'd rather it be part of the composite. The court's ruled that it's not admissible.
No, I'm ruling 5 is admissible.
Okay.
Because it was shown. State, you showed it.
Right, it was shown.
So this is just a printout of.
Well, okay, but I think he hasn't. Do you want it admitted?
The witness is gone.
So maybe 5 should just be with the composite number 4 and not entered. Just be at the as proper.
All right, so I'm saying I would receive 5 in evidence. There's been a stipulation to it, but I'm not receiving it?
Correct.
Okay. I don't know what its status is then.
Oh, that's the WhatsApp messages, or is him admitting to punching the dog?
All right, so you ready to call your next witness?
Yes.
Ready to bring the jury in?
Yes.
All right, let's bring him in.
I think we are going to use maybe just open the blinds, but.
Give up. There's Jules right there to the right of your screen, with her hair in a pony with the glasses on. If you missed it, Jules called in during lunch to give us her observations of what was going on in the courtroom and of the jury and of her general vibe of the way she thought things were going.
Welcome back, everybody. Did anybody begin deliberations amongst yourselves, talk with anybody outside of the jury about the case, or do any research, or hear anything about anything you talked about? All right. When we were last here, Detective Quiles had finished his testimony, and now we'll let the state call their next witness.
State would call Dr. Vega.
Dr. Vega, I think this is going to be the medical examiner. We're just going to take a quick break for a second because I need to breathe and I need to let some of my anger go for a few minutes. So Before Dr. Vega takes the stand, we're a little bit behind, not too much. Thank you, Deborah, for becoming a new member, and for Becky's Blue-Eyed Paranormal for your super chat. I appreciate you. Becky also says, no one has the right to put their hands on anyone. No one. Thank you, Becky. Jules the Cat, thanks for your Canadian super chat. Look beautiful today, Melanie. I was at the nail salon last night listening to your stream and almost in tears. I feel so sad how Ashley was dismissed by law enforcement and court. Thanks for your coverage. Thanks for watching, Jules. Thanks for your compliment. And we're watching it happen in real time in front of a worldwide audience. Thank you. Thank you, Becky, for another super sticker. You're very generous. Kimmy says she loves that we get to hear the arguments. Thank you. I do too. Kate DeMassey says she's going to have to testify. That's what they're doing here. I feel like they're forcing her hand. And it is the defendant's right to not have to testify. But because of all of these rulings, she may have to get up there and tell her story when some of this evidence could have told the story for her. The Google searches, Googling how to co-parent with an abusive spouse many times. Thanks, Becky, again for another super sticker. Super sticker. Oh, thank you, Julie Moskowitz, for becoming a new member. KJV, thank you for your super sticker. For Fox's sake, thank you for your super chat. Victim, I was abused. Everyone, we need 320 photos, 93 videos, and 74 witnesses. Abuser, I didn't do it. Everyone, okay then, we believe you. Thank you for getting it. Nancy says, I wish they could hear you. I'm sick. Thank you, Nancy. Allison, Faye, thanks for the 5. Isn't this why we have a jury? The judge is making her take the stand. Love your channel. Thank you. I'm a little outraged right now on top. Thank you for being on top of the super sticker. Let's go back to Dr. Vega's testimony, shall we?
Hello, sir. I'm Judge Whyte. I'm presiding over this case. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. It just does adjust up, down, left, and right as you need. Speak in a loud, clear voice. We should hear everything.
I will. Thank you, Your Honor.
Good afternoon, Doctor.
Good afternoon.
Would you please state your full name and spell your last name for the record?
Certainly. My name is Russell Scott Vega, last name spelled V-E-G-A.
And how are you employed?
I'm the Chief Medical Examiner for the 12th District of Florida, and that includes Sarasota County, DeSoto County, and here in Manatee County as well.
And how long have you been a medical examiner?
I finished my training in 1997, so more than 25 years.
And how long have you been the Chief Medical Examiner?
Here, so October 1st will be 21 years.
And you said here, were you a medical examiner somewhere else before?
I was an associate medical examiner in Hillsborough County for 4+ years.
And what kind of education do you obtain to become a medical examiner?
Well, I mean, it's different from person to person a little bit. I can tell you my own personal experience.
Yes, please, yours.
Certainly. So I did my undergraduate studies at Florida State University. I majored in physics and biochemistry. After my undergraduate, I went to medical school at the University of South Florida. I graduated from medical school in 1990. Following that, I did 2 years of training in general surgery and then 4 years of training in anatomic and clinical pathology. Pathology, it's a specialty of medicine that focuses on how to diagnose diseases based on looking at cells, fluids, tissues, biopsies, organs, and by doing autopsies. Finally, after all that, I did a 1-year fellowship in forensic pathology. That's the subspecialty which really focuses on performing autopsies and doing death investigations.
Thank you, sir. And what are your current duties as a Chief Medical Examiner, or at least, yes, as a Chief Medical Examiner?
So as the Chief Medical Examiner, I administer the office here. So I manage the staff, I set policy, do procedures, and I do some of the casework myself. So I do some of the autopsies and death investigations.
So you do still conduct autopsies regularly?
I do.
And do you know how many approximately autopsies you've conducted in your lengthy career?
I don't know exactly. I suspect it is getting close to 4,000.
And of those, can you have any involved gunshot wounds?
Very many of them.
And so that was my next question. The percentage, you think it's a lot?
Yeah, I can't tell you the percentage, but I've examined many hundreds of gunshot wounds.
Thank you, sir. And
No, the mods can't help you to answer your question. I did star your question, Brad. So I actually did star it. You can't expect me to, interrupt the stream when you have a question, but I will now. I do have a question. Can the attorney bring those texts in when he presents the defense case, or can he not show them all? I'm confused. Maybe. The answer by the judge was maybe he can. He'll rule again if and when he feels that the defense can show some other hearsay exception based on whatever happens during the defense's case. So that's the answer to that. So maybe.
I'm gonna draw your attention back to September of 2020. Did you conduct an autopsy on Douglas Benefield?
I did.
And when did you do that?
The autopsy was performed in the morning of September 28th of 2020.
And can you explain how your procedure for conducting an autopsy?
Certainly. And I don't think my procedure is greatly different from other medical examiners or forensic pathologists. But the procedure starts with the examination of the body in its state as it arrives, at our facility where the autopsy is performed. That includes documenting the condition of the body with photographs and diagrams and written notes. Following that, if there's reason for evidence collection, and typically that's going to be in concert with a law enforcement agency, then evidence collection ensues. After the initial part of the examination and the evidence collection, then there is a more detailed examination looking for identifying characteristics, changes that might represent natural disease, and then any injuries that are present. After all of that, then I think what many people might consider the traditional part of the autopsy begins, which is the internal examination, where the body is examined internally for, again, the same kind of changes of injuries and natural diseases.
And is that the process you followed in the autopsy of Mr. Benefield?
It is.
Thank you. And during your autopsy, are photos taken to document injuries found, if any, on the body?
Yes.
And in this case of the autopsy of Mr. Benefield, were pictures taken?
Yes.
Your Honor, may I approach the witness?
Yes.
Dr. VEGA, I'm showing you with the pre-mark that states 86 through.
Can I see the photographs, please?
Yes, they're the same as the ones you just looked at.
The paper crinkling in my ears. Oh, they're approaching. All right, so I'll give them a second. I don't think we're, oh, did they send him out? Because they sent him out. Unless that's somebody else going out. What? Wait. Well, the audio's still off. I guess those are other people going out. No, he's still on the stand. All right. Why are they showing other people leaving? I'm confused.
Well, she's going to put them back in order for me while we do that. During your autopsy, did you determine the height and weight of Mr. Benefield?
I determined the height and the body length, as that's what we measure with the body reclined on the table. I think it's a very close approximation to height. It might not be exactly the same.
Yes, sir. And what was Mr. Benefield's weight at the time of his homicide?
It was 169 pounds.
And the length?
The body length was measured to be 69 inches or 5 foot 9 inches.
Thank you for converting it for me. And during your external exam, as we discussed, those injuries are documented in these photos as well. Is that correct?
Yes.
Okay, and I'm going to now show you Sorry, Judge, just bear with me one second.
Sharon, I think a lot of people in this chat might be triggered. Now, if you were on another chat, they'd be telling you that it's good that all that stuff didn't come in because, you know, she was planning it. I don't even want to know what they're saying over there. Don't even tell me.
Dr. Vega, we're gonna try this one more time. I'm gonna show you 86 through 97. Would you mind taking a look at those photos and telling me if you recognize them?
Kinda. Karen. Karen says, did Ashley need to be killed to prove she was abused? Kind of how it works, right? Where's Nikki McCain, my friends? Where's Nikki McCain? Everyone knew that she was abused for years, even her family. Now she's missing. The DV felony charges against her husband were dismissed because Nikki was a no-show at court. It's in Shasta County, California. I did a show on it. I still hope that Nikki is found, but so far she's been gone for a couple of months. Watch that show if you haven't, because everyone should know about Nikki. Nikki McCain. He's looking at, I guess, the autopsy photos.
And what are they?
These are photos taken at the time of the autopsy of Mr. Benefield back in September of 2020.
And do they fairly and accurately depict some of the injuries and some evidence that was as they were in September of 2020?
Yes.
Thank you, Your Honor. Thank you, Your Honor. At this time, I'd ask to enter states 86 through 97.
No objection.
Received.
Thank you. And generally, when you examine Mr. Benefield's body, I'm going to display them out here in just a moment.
Okay.
Did you find injuries on the outside of his body?
I did, yes.
And where were they? And we'll talk about them in detail, but generally, where were they?
There was an injury to the right side of his chest. There was an injury to his right shoulder, and there was an injury to his right leg.
And did he have any injuries to his face or head?
No. Well, he did have to his head. Yes, I'm sorry, not his face.
And what type of injury was that?
The injury to his head was what we would typically call in medical terminology, we'd call an abraded contusion. That's a swollen and scraped bruise. And it was on the very back of his scalp at what we'd call the occipital protuberance, or the lump at the very back of the head.
And what would that type of injury be consistent with?
Typically, it's from falling backward and striking the head.
And when you were looking at his external injuries, did you have some opinion as to what had caused them, specifically the chest and the leg?
Yes.
Okay. And what did you feel that they were?
They were gunshot wounds.
And did you then conduct an internal exam?
Yes.
And did that internal exam confirm what you felt about that they were gunshot wounds?
Yes.
And I'm going to display behind you states 86. Oh, okay. And I believe this is generally what we call an identification photo. Is that correct?
That is correct.
And is that Mr. Benefield as he was in September of 2020?
Yes.
Thank you.
She can't even look at the photos. They're going to say she's acting. Tell me if you think she's acting. I hope they don't show the photos on TV. I don't think they will.
And then let's first talk about the injuries you said he suffered to the chest. You said that was a gunshot wound?
Yes.
And how many defects in his body were associated with the chest wound?
There was one defect, and that was on the upper right side of the chest.
And is that what we see here in states 87?
It is, although we're also seeing the injury to his right arm area as well. Actually, that's the one that has the marker on it. The chest injury is just above and to the right of that, at least according to the viewpoint of the viewer of this photo.
And for orientation purposes, this is his right side of his body?
It is, and I'll use the laser pointer to indicate this is the arm injury, and that's the chest injury, just to the right side of his right nipple.
And was there, you said there was only one injury. Does that mean this is an entrance wound?
That's correct.
Was there any, and there was no corresponding exit?
That is also correct.
And did you locate a projectile that was associated with this chest wound?
I did.
And where was it?
It was lodged in the tissues of the left side of the back.
I'm going to show you states 88. I believe that's a close-up of the injury we saw on his chest.
It is.
And then can you kind of orient the jury as to what we're looking
There's cousin Tommy in the back with his, looks like a white shirt that has stripes on it.
at in states 89?
Yes, this is the back of Mr. Benefield's body. He has been rolled up onto his left side. So what we're seeing here is his back, the head here. So this is the left shoulder. The right shoulder would be up here. This is the left side of his back, and it's this purple area right here that represents where the projectile was lodged under the skin and the tissue.
And did you remove it?
I did.
I'm going to show you states 90. Is that the removal process for the projectile from Mr. Benefield's body?
It is. In order to visualize it and then remove it, I made an incision in the skin, which you see here. And then just for documentation purposes, I reflected the skin with the tip of the scissors so that we could photograph the projectile in place in the tissue prior to its removal.
And Dr. Vega, I'm sorry, I'm going to go back to states 89. Where you described his body, but there's some skin discoloration. Can you explain to the jury why his skin looks red or darker?
Certainly. That is what we call lividity. Lividity is the settling of blood in the tissues that occurs after death when the heart's no longer pumping, and the major force acting on it is gravity. When somebody's lying on their back after death, which is typically what we see, we are of the usual process of putting somebody on their back in a dignified position after death. And so the blood typically does settle into the back, and we see this purplish coloration here, which is a result of that. There's some here as well. This area here where there isn't any discoloration, except where the bullet is because this is where the table was pressing up against the skin, and that pressure kept the blood from settling in those areas. So most of this purple discoloration is lividity, with the exception of this area right here, which is due to a little bit of bruising associated with the placement of the bullet there.
And Dr. Vega, I'm going to show you what's been marked as states 14. Would you take a look at that item and tell me if you recognize it?
Yes, I do.
And how do you recognize it?
This is the projectile that I recovered from the back that you could see in the photograph you had up previously.
And other than having been repackaged for trial purposes, does it appear to be in the same or substantially the same condition as when you removed it from Mr. Benefield's back?
It does, yes.
Your Honor, at this time, the state would ask to enter states 14.
Objection received.
And Doctor, I'm going to show you states 95. Is this the same projectile that you have there in states 14?
Yes, it is.
And what, if you know, is that red part that's next to the projectile?
This is a small rubber plug that is occasionally found in certain hollow point type projectiles. Not all hollow point projectiles have these rubber plugs, but it's part of the process of creating this hollow point that allows the projectile to expand and deform, as we see in this case here.
Thank you. And so going back to the location of the projectile, based on where the entrance wound was and the where you found the projectile, did you determine a path of travel that projectile took through Mr. Benefield's body?
I did.
And what was the path of travel?
So the path of travel was one of entering the right side of the chest, striking the 5th rib on the right side, the right lung, the 10th vertebral body on the in the middle of the spine, then the left lung, the 10th rib, and then the soft tissues of the back until it stopped where it is. And that path then, if one were standing upright and straight, would be from the right side toward the left, from the front towards the back, and essentially horizontal. In other words, without angling upward or downward. And again, that's relative to a standing upright position.
Yes, sir.
So all of the pretrial media coverage of this said he was shot in the back. That has just been controverted by the testimony of Dr. VEGA, the medical examiner. He was not shot in the back. He was shot in the side of the chest.
And would you mind, would you be so kind as to stand up and kind of point on your body to where the entrance wound would be?
Certainly.
Thanks, sir. And where would the exit wound be?
Well, no exit, but
I'm sorry, the projectile.
the projectile,
Yes, sir.
my mobility is limited, but essentially would be in the back over here, where the tip of my thumb is.
Thank you. And would you just turn back so we can see the entrance again?
Yeah.
Thank you, sir.
Okay, that, my friends, is the front of the chest. That's not even the side of his body. I thought somebody had testified earlier in this trial that it was like through his side. Look at where he's pointing. For those of you who are listening and not watching the video, he is pointing to the right side of his chest in the front.
Projectile,
Yes, sir.
my mobility is limited, but essentially would be in the back over here, where the tip of my thumb is.
Thank you. And would you just turn back so we can see the entrance again?
Yeah.
Thank you, sir.
You're welcome.
And you said that the wound was front to back. Was it, and from how you showed, you said it was essentially horizontal.
Yes,
Was it, it wasn't front to back like it went straight through. Can you describe it?
certainly. I mean, it went through an angled path through the body, and that angle took it from the front toward the back, but at a greater angle from right to left.
Thank you. And you said that it struck his ribs and his lungs and his vertebral.
His vertebral body.
Thank you.
The
So
spine.
his spine.
Yes.
And would that injury have been immediately fatal?
Probably not.
And would,
in fact, wasn't he alive when they came, when the first responders came? Wasn't he still alive? He wasn't pronounced dead until he was at the hospital, something like maybe 2 hours later. It did go through the front. It went through the front of his chest, not even the side, because I thought during the prosecution's opening, they said it was like from one side of his body and came out the other side or something like that. It went through the front of his chest, my friends.
would it have incapacitated, if you can say, incapacitated Mr. Benefield quickly?
I think it would have incapacitated him quickly. Whether or not it was immediate, I don't think one can predict.
Thank you, sir. I'm now going to take you to the arm wound. Was this wound different from the wound we saw in Mr. Benefield's chest?
Yes.
And how so? And this, for the record, states 91.
Yes. What one can maybe not clearly appreciate just from viewing the photo, but was clearly evident at the time of the examination, is that this is only a surface wound. So what you see as the mark on the skin here is the full extent of this injury. So it's an abrasion or a scrape on the skin, but outside of the effect on the skin, nothing deeper was involved with this injury.
Thank you, sir. And then you said, finally, you said he was also shot in the leg. Is that correct?
That's correct.
So I'm going to show you states 92. Can you orient the jury as to what we're looking at on Mr. Benefield's body?
Yes, and this is a little bit of a tough one orientation wise, but the injury is to the back of his leg. So what we're seeing here is the back of the leg, and it's excuse me, the calf area here. This is a perforation of that calf. Yeah, I think that's the best way to describe it, the calf area.
And The chest wound we saw entered and did not exit. Was this wound the same or was it different?
It was different
And how so?
because this injury did indeed have an exit.
And where did you locate the exit?
The exit was on the right side of the knee.
And Dr. Vega, how can you, and I have a picture of that, but before we move on to that, how can you tell the difference between an entrance and an exit wound?
It's not always possible, but typically entrance wounds have more of a well-defined defect in the skin. Frequently, that defect in the skin is paralleled by a defect in the tissues that one can appreciate underneath. Many times, the edge of the skin perforation or the edge of the skin defect will have a ring or at least an arc of abrasion or scraping as the bullet passes through. Exit wounds tend to not have those features. One way that I like to think about this is it's like a very fast moving awl or punch, in that it goes in and it almost drills a hole into the skin. But when it exits, what it does is it tenses up the skin until the skin tears. That's how a bullet exits. So typically, the tear doesn't have the same well-defined drilled appearance that the entrance wound rather does. And in this case, that's exactly what we see.
And I'll show you 93 that correct me if I'm wrong, but that is the exit wound associated with the entrance we just saw.
That's correct.
And I have a close-up. This states 94. And so can you kind of show the jury how you knew this was an exit wound?
Yes. So this injury does not appear to be a round or drilled type of defect, but rather a tear in the skin that occurred when the skin was stretched until its breaking point by the bullet trying to exit.
And were you able to determine the wound path for this injury?
Yes.
And what was it?
So the wound path started at the back of the leg and went through the musculature of the calf. And then I couldn't tell for certain if the path actually went through the bones or if it passed right next to the bones, but because of blast effect, injured them, causing fracture. The amount of tissue damage can make that part difficult to separate out. And that was the case here. After doing that and fracturing the very top part of the leg bones, the tibia and the fibula, it then exited through this exit defect on the lower right side of the knee.
And I hate to ask you, but would you mind stepping down and showing us on your leg where this entered and where it exited?
Certainly.
Thank you. If you're more comfortable, you can.
Oh, so when they say that she shot him in the back, they're talking about the back of his calf. Is that how they're going to justify all the misinformation pre-trial? Let's see.
Easier. Yes, sorry.
Hard to see.
Mr. Taylor, if you need to reposition so you can see, please feel free to do so.
So on me, the entrance was.
We can't see.
If it helps, I can put my finger there.
Okay. And the exit here.
We can't.
So here to here.
Great angle. They're not
And so
showing it
that's-
to us.
You said slightly up or up.
It's upward from the right toward the left, and from back to front. Yes, largely all three of those components.
Thank you. Well, you know what, Dr. Vega, while you're down here, just for clarification, would you show me again the chest wound? Just because
Great point. Amber Dawn, them Johnson says calf, exit out knee. That means she was below him when she shot that. Did he knock her to the ground? Somebody wanted to know which bullet hit came first. I don't know if anybody can testify to that. Was he trying to kick her? Locaria says. Judge, the chat can't see. We just need to take a breath for a second. Farmer says he's pointing to the right side, looking left to say she sucker shot him, but if he would look in the correct direction, you would see everything clearly. Doug was probably standing in a fighting position. Maybe that was a warning shot. Kristen Pino says she had to have been below him. Melanie says he was trying to kick her, wasn't he? Well, according to the text message that his late wife sent him, he kicked her so hard on their honeymoon that she felt afraid for a very long time, perhaps for her entire life. Get a trajectory rod. Yeah, that would be great, wouldn't it? All right, let's keep going.
I think you're easier to see now that I made you get off the stand.
Entrance. Lodged bullet.
Would you just spin one time? Just turn so they can see. Thank you.
When he says
Thank you so much.
entrance, now he's talking about the chest. He's like pointing like almost to his right nipple. I mean, if that makes, I hate that word nipple, but that's where he's pointing. And lodging towards the back in a diagonal fashion, if that makes sense.
Terrific. I appreciate that.
Mr. Taylor, were you able to see both of those demonstrations?
Yes, Judge Whyte, thank you.
Dr. Vega, was there any physical evidence associated with this injury that was recovered from Mr. Benefield's body?
From the leg injury?
Yes, sir.
Yes, there was.
And I'm going to show you States 15. You'll take a look at that and tell me if you recognize it.
Yes, I do.
And how you recognize it.
This is the lead fragment which was recovered from Mr. Benefield's leg just deep to the exit defect.
And how does this differ from the projectile? Like you're saying fragment. What does that mean compared to the projectile?
Well, as we've already discussed, we have an entrance and an exit here. So essentially, the projectile exited the body. Before it did, a small piece of it broke off and remained in the tissues. This is that piece, and that's what I recovered at the autopsy.
Thank you, sir. And other than having been repackaged for trial purposes, does it appear to be in the same or substantially the same condition as when you removed it from Mr. Benefield's body?
It does.
Thank you. Your Honor, the state would ask to enter States 15.
No objection.
Received.
Thank you. And Dr. Vega, I have a photo of States, this is States 97. Is that the same item that is in States 15?
Yes.
Thank you. Did you find any, I'm going to go back to the, well, Dr. Vega, what is stippling?
Stippling is a term we use to describe certain changes that occur in association with gunshot injuries. It refers to the pattern on the skin or any other target of unburned gunpowder fragments that strike that target and create a pattern.
And did you find any stippling associated with the gunshot wound to Mr. Benefield's leg?
I did not.
Did you find any with a wound associated with his chest?
I did not.
And what, if anything, does the absence of stippling tell you? Specifically, we'll talk about the leg first.
The absence it reflects the same principle in either injury. And what it means is that typically when the weapon was discharged, it was far enough away so that the unburned gunpowder fragments, which are ejected with the bullet, had a chance to lose velocity and fall away prior to striking the skin. In general, typically that means that the muzzle of the weapon was more than 3 feet away from the target or the skin in this case. But any more precise determinations require the test firing of a weapon, same weapon or same style of weapon with the same ammunition to try and get more specific information.
And for the chest wound, if he were wearing a shirt when he was shot, would that affect what you would find on his body?
Yes.
Okay, that was why I was asking separately. And so to be clear, you said the muzzle. So would that mean that if it's not necessarily the body of the shooter, but if they had their arm extended or even here, it's the end of the gun from Mr. Benefield's body?
That's right.
And I know you determined a path of travel and we're still talking about the leg injury, for this leg injury, but does it tell you, this path of travel, anything about where the shooter would have been standing?
All it really tells me is the relative position of the weapon to the leg at the time that the weapon was fired.
Yes, sir.
And trying to come up with the relative position of the shooter at the time that the weapon was discharged is much more complicated because both the shooter and the victim, and specifically the victim's leg, can be in multiple different positions and still end up with that required relative position of the gun to the leg and still create this same injury.
And, Your Honor, may I have just one moment?
Yes.
Dr. Vega, if hypothetically Mr. Benefield were falling, would it make sense that his legs would flip up in the air enough for this path of travel? Does that make sense?
What? No, it's a bad question.
If this injury were sustained while he was falling,
Yes.
then the injury would be sustained while his body is changing its position and in motion. But regardless, at the time the weapon was fired, the muzzle of the weapon would still have to be, relatively speaking, below, to the left of, and behind the right leg in order to get this particular angle of path of travel through the leg.
Thank you. And can you tell when you conduct an autopsy, and specifically in Mr. Benefield's, which of these wounds occurred in what order?
I cannot.
And
there's your answer. He can't tell in which order those wounds were inflicted.
Once you completed your autopsy, did you order toxicology testing?
Yes,
And was that done in this case?
it was.
And were there any drugs or alcohol found in Mr. Benefield's body?
No, there were not.
And finally, based on everything that you did during your autopsy, did you determine the cause of death?
I did.
And what was that?
I determined the cause of death to be a gunshot wound to the chest that caused perforation of the lung, or the lungs, both lungs, with hemothoraces. It's a fancy word for bleeding that occurs in the chest.
And I didn't ask you this, but I guess, could you explain, so once this bullet entered Mr. Benefield and started to travel through his lungs, what would have been happening inside his body, or what would happen right after?
The primary things that happen there are that very rapid bleeding starts to occur. The bleeding is rapid because the lungs are very vascular, and so when they're damaged, they bleed very quickly. And also there's no impediment to the bleeding. The cavity around the lung can expand very rapidly to accommodate bleeding. So the bleeding that happens as a result of a gunshot wound to the lung is very rapid. In addition to the bleeding, when the lung gets a hole in it, it no longer holds its shape and its anatomical arrangements, and it collapses to some extent. That collapse is made worse by the accumulating blood pressing on the lung as well. So the combination of physiological effects of bleeding and lung collapse are the primary things that are occurring in the body at the time that, or immediately following the bullet passing through the lung.
Thank you. And did you determine the manner of death in this case?
I did.
And what was that?
I determined the manner of death to be homicide.
Your Honor, may I have just one moment?
Yes.
Not undetermined, like in the Karen Reed case. We know it's a homicide. Homicide is simply defined as the taking of a life by another.
I don't have anything else, Dr. Vega. Thank you. The defense may.
Oh, you think? You think they may?
And of course, the question is, do you need this?
I do not.
Yes, sir.
Afternoon, Dr. Vega.
Let's take a pause before cross to everyone. Hit the like button. It helps the algorithm. It helps the stream get out there. And it's just a nice thing to do. YouTube likes it. You might have to close out the chat if you're on your phone to hit the like, but it definitely, absolutely 100% helps. There's 4,000 people watching right now. And there's only 2,900 likes. Let's get it up a little closer to 4,000, hey? How about one for the good girl, huh? Thank you. No spoilers, please, if you're watching 3 streams at once. Thank you.
Good afternoon.
Haven't seen you for a while. How's that new facility that you're in?
Very nice. Thank you.
Just a few questions, if I may. I think you told us that the deceased was 169 pounds and stood 5 feet 9 inches tall.
Correct. Yes.
Muscular build.
I don't think I use that terminology. I think I just talked about the weight and the body length.
I want to ask you mentioned about hollow points. You know, the public perception about hollow points is that they are more lethal. The fact is it not true that the hollow point is designed to expand when it goes through tissue?
Yes, that's right.
The theory being it's to stop a bullet from exiting and harming someone else.
That's certainly part of the philosophy or utility of having a hollow point projectile.
And when you tell us that the wound was probably not fatal, within a reasonable degree of medical science, and I think you made it pretty clear, you really can't say one way or another that upon being shot like that, he would have dropped immediately, that he may have continued for a couple of seconds.
Yes, that's right.
The stippling issue about gunpowder, it's from a distance of approximately, you told us, 3 feet.
Roughly, yes.
Okay, that's, so when you exceed more than 3 feet, you would not expect to find stippling.
That's correct.
Okay, and you didn't find any stippling on his shirt?
I didn't examine his shirt.
Okay, so if somebody were backing away while they were firing and they got beyond that 3 foot range, there may not be any stippling.
That's correct.
All right. You said that the wound to the scalp was indicative of, you traditionally see it, of somebody falling backwards and hitting a hard surface like a tile floor.
Yes.
I want to ask you just a couple other questions. Are all homicides crimes?
Good question.
Objection, Judge, beyond his expertise.
How loud if the witness has the knowledge to answer?
In my experience, homicide, as determined by a medical examiner, has a certain medical legal significance, which does not necessarily imply criminality.
That's right.
Okay.
It's the killing
in
of one
simple-
person by another. Definition of homicide, the killing of one person by another.
Language, it could be excusable,
Objection, calls for legal.
I'll sustain.
justifiable. I think if it's within its
Good for the
knowledge.
jury to hear it.
No, I'm going to sustain because I've asked for a legal conclusion as opposed to a medical conclusion.
All right. You mentioned, Dr. Vega, that you could not determine the order of the shots.
That's correct.
Okay, there is no medical method of being able to say which shot came first, which shot came second.
In certain cases, the physiological findings may help you with that, but in this case, no.
Would it be a fair statement for me to say that for the chest shot, the weapon would have had to have been pointing at his chest from the front?
Yes.
There you go.
Let me just check, Your Honor. I think that might
Yes, sir.
conclude. Last question with respect to the leg. You've told us that the gun would had to have been lower than the leg to get that upward trajectory.
Yes, although I would say that, lower is a relative term.
Yeah.
And legs can be put into various different positions. And if we're going to say lower, then it needs to be clear that lower means with respect to the leg in an upright position. And if the leg were horizontal, for example, then we might be talking about a position which is above the leg, but pointing up towards the head of the body, for example.
Okay, so let's try to be clear here. If Mr. Benefield fell backwards and his legs went up in the air, might that injury be consistent with that?
Given that scenario, it's possible.
Mm-hmm.
I believe that's all I have, Your Honor. Thank you, Dr. Bay.
State, any redirect?
Yes.
My heart
Dr.
breaks for her.
VEGA, I don't want it to be unclear. The gun would have, for the chest wound, the gun would have had to have been in front of Mr. Benefield's body. That's what you said.
Yes.
But it didn't enter his chest. It entered, or the front of him. It entered through the side.
Yes, so the weapon did have to be in front of him, but even more so, it had to be to his right side.
And
he pointed to where it entered on his chest, and he pointed to like his nipple area. So the bullet did not go into his side. It went into his chest. She's confusing it now. He's going to have to clean this up.
based on your training and experience, is it typical that if somebody were to fall backwards, that their legs would go above their heads when falling?
Objection.
Without the intervention of something to fall over, an ottoman, a chair, or something like that, it seems unlikely.
And if Mr. Benefield were running or his legs were up in the back, could the angle have also been accomplished?
Yes.
Thank you, doctor. I don't have anything else.
That's all.
All right, can the witness be released?
Yes, sir.
Yes.
Sir, you're released from your subpoena. You're free to go.
Thank you, Your Honor.
Oh, Judge, while we're switching, could the deputy pass 14 and 15? Would you mind?
Because you're too lazy to walk up there and get it from the witness? Now you want the deputy to do your work for you, really?
Oh, pass, you mean,
Yes.
to the jury?
Sorry,
I wasn't
publish.
quite sure what you meant.
Sorry,
Publish.
I meant pass through the jury. Yes, sir.
All right. Members of the jury, as with yesterday, we're going to pass these around. These will go back with you during your deliberations.
Okay, we're a little bit behind. As you know, we stop, we rewind, we talk, we take breaths, we commentate. That's what we do here. Everybody breathe. Namaste. Before we start the next witness, let's take a few questions. Elijah, thanks for tuning in from Canada. Can we get Jules to go out and fetch Judge Carroll in the Take Care of Maya trial? This judge needs to be subbed out. We love Judge Hunter Carroll. He had his moments. He was feisty sometimes, but I thought he was very fair too. I liked him too, Elijah. Thanks for coming back since we followed the Maya trial together. Sarah, be creative. Thanks for your 5. The human spirit is stronger than any government or institution, than any government, or institution. Oh, so are we supposed to repeat that? It's the prayer? Pray for her spirit. The human spirit is stronger than any government or institution, Fela Kuti. Pray for her spirit. Thank you, Sarah. Be creative. Max Bang. Thanks, Max, for tuning in and chiming in. My fellow survivors, I wish I could hug all of you. Take good care of yourselves. There is a sunrise beyond the past. You have a purpose. Oh, you're so sweet. Thanks for your 5. I love how you support each other in this community. It's really a whole bunch of nice people. 65,000 of you. There could be more of you if you hit the subscribe button, because I'm in an unofficial competition with Vinny Politan. I'm at 65,000.4. I don't know what he's at. I got to check. He doesn't know about the competition, so I'd like to surpass him in YouTube subscribers because he has 1 million on Facebook. Annie Banani, thank you for your $20 super sticker. You are so kind and generous. Sarah, be creative. Thanks for becoming a member. Hemisphere, going back to the Google searches, said if she was planning this, it would have been in her Google searches. Right. You know whose Google searches are going to work against him? Brian Walsh. Google searched such things such as how to dispose of a 110-pound woman's body. What kind of chemicals should I use to disintegrate human flesh? I mean, not exactly those things, but very similar to that. The Brian Walsh case also happens to be pending in Norfolk County, Massachusetts. Same as the Karen Reed case, right? I believe it's in Norfolk County, unless it's a neighboring county. But yeah, they would. Grace, thank you for your 20. Born and raised in Florida, my father, a personal injury attorney, was extremely abusive. Called the cops at 12 years old, dealt with DCF and supervised visitations, pursuing law to do victim advocacy, then put all this trauma to good use. Oh, God bless you, Grace. And congratulations on your choosing to pursue a law degree. Go for it, girl. You can do anything. She also says, I could never watch a trial like this without the incredible support of other survivors and your intentional commentary, Melanie. Thank you so much for fostering this space. Thank you, Grace, for appreciating it and for sharing your story with us. So many of you have shared stories that you've never shared with anybody. Welsh Girl, thank you for your super sticker. Kat says, thanks for all you do to build a classy community. Thank you, Kat. Lori Marie became a new member. Elizabeth became a new member. Kev C with so far the comment of the afternoon, smash that like button, because we didn't know what smash meant. I think now we might. All right, here we go. I believe this is the last witness of the day. Everyone take a deep breath and go.
It does adjust up, down, left, right as you need. And if you just speak in a loud, clear voice, it should pick up everything.
Yes, sir. Thank you.
Good afternoon.
Good afternoon.
Could you state your full name?
Hold on 1 second.
Oh, I'm sorry.
Go ahead. You all finish up. So we're going to wait a second.
Yeah, I apologize, Judge.
I don't want anybody to feel rushed. But like I said, everything will go back with you all during the deliberations.
Thank you.
We're still looking at the
Sorry,
autopsy photos.
Thank you, Judge. Please state your full name and spell your last name for the record.
My name is Daniel Hausdorf. Last name is spelled Hausdorf.
And how are you employed?
At the Florida Department of Law Enforcement, also known as FDLE.
And how long have you been with FDLE?
It'll be 11 years in September.
And what is your title and position?
I am a crime laboratory analyst in the firearm section.
And how long have you been in that position?
I've been in that position out of training since August of 2018.
And what are your official duties as a crime lab analyst in the firearms division?
My main duties include microscopic comparisons of fired ammunition components, such as cartridge cases and bullets. I also perform firearm function testing, which means I test fire the firearms as well as check the safeties. I perform distance determination, serial number restoration, and imaging cartridge cases into our database.
And when you say cartridge, well, we're going to get there. I'm sorry. What kind of training did you receive to become a firearms analyst?
I have a bachelor's degree in biomedical science from the University of South Florida. I was hired at FDLE in September of 2013 as a forensic technologist in the firearms section. That had 6 months of training, and I was in that position for about 3.5 years. I then was promoted to analyst and completed the 18-month training program to hold that position, and have been out of training since August 2018.
Thank you. And do your daily duties include the analysis of firearms?
Yes, ma'am.
And have you previously testified as an expert in the field of firearm analysis?
Yes, I have.
Thank you. And can we just talk about ammunition first to kind of get the basics? What do you call a complete item of ammunition?
A cartridge.
And someone might refer to that as a bullet, but an intact live round.
Yes, ma'am.
Okay, so you use the word cartridge.
Yes, ma'am.
And what are the components of a cartridge?
A cartridge is comprised of 4 parts. There's the cartridge case, which is the body of the cartridge. There's also the primer, the gunpowder, and the bullet.
And the bullet might also be referred to as?
A projectile.
Thank you. And does your analysis also regularly involve the analysis of semi-automatic firearms?
Yes, ma'am.
And can you tell me what a semi-automatic firearm is?
A semi-automatic firearm is a handgun that is going to fire one shot every time you pull the trigger, and the gases for firing is automatically going to cycle the firearm, extracting and ejecting a cartridge case and automatically loading another cartridge.
And so the cartridge case leaves the firearm every time?
Yes, ma'am.
And that's opposed to a revolver, is that right?
That's correct.
And I want to draw your attention to FDLE case 311227, the case you're here about today. Did you have the opportunity to examine evidence submitted to your lab under that case number?
Yes, ma'am.
And when you receive evidence into your lab, what's the normal procedure?
The normal procedure is the agency will submit the evidence to our lab where it's given the unique FDLE case number, and then each item has a unique FDLE item number. It's given a case tracking form, which I receive from my supervisor when I'm assigned the case, and that has all the details of the case, and everything is tracked in our computer system called LIMS. It's the Laboratory Information Management System that just keeps all the information about the case and the evidence, where the custody of all the evidence is being held at that time, and things like that.
And when did you conduct your examination of the items in this case?
I started working this case on March 9th of 2021.
And I want to first show you states number 13. It's already in evidence. It's open. Would you take a look at that and tell me if you recognize it as an item you received in your lab?
Yes, ma'am.
And what is it?
It's the Springfield Armory 45 auto pistol that I received.
And how do you know that it's the same firearm that you received in your lab?
It has the FDLE case number, item number, and my initials in my handwriting on both the pistol and the magazine.
Thank you, sir. And what type of analysis did you perform on this firearm?
So whenever I receive a firearm, I'm going to perform a function test on the firearm to make sure that it does fire, in fact, and also check the safeties on the firearm. In this case, there are 3 safeties on this firearm. There's a trigger safety, a grip safety, and a firing pin block. All are designed to make sure there's no accidental firing.
And was this firearm found to be in proper functioning order?
Yes, ma'am.
If Your Honor and the deputies don't mind, is it okay if he removes it to display it to the jury so I can ask him some questions?
It's empty.
I was going to say there's gloves here if you need them.
It's okay, sir.
Again, Mr. Taylor, if you need to reposition so you can see exactly what's going on, please feel free to do so.
Mr. HAUSDORF,
Yes, ma'am.
would you mind just standing up so the jury can see and telling us the parts of the gun that you just talked about?
Yes, ma'am. So this is the top portion of the firearm called the slide. There's the trigger, where the trigger safety is right in front of the trigger here. There's the grip safety in the back, which is depressed by normal operation of the firearm. There's the fire pin block, which is housed in the slide that is deactivated when the trigger is pulled. And the way that this firearm works is there's ammunition loaded in the detachable box magazine. It's inserted in the grip of the firearm. At that point, I would release the slide and load 1 round into the chamber of the firearm. I would pull the trigger, which is going to cause the firing pin to release, striking that primer on the cartridge, causing a spark to go through the flash hole, and then like the gunpowder, which is going to cause those rapidly expanding gases to propel the bullet down and out of the firearm. But it's also going to cause the slide to move rearward. The fire cartridge case is going to extract and eject out the side. As the slide moves back, it's going to recock the firearm, and then it will go back forward again, pulling another cartridge from the magazine and into the chamber of the firearm, ready to fire again.
Thank you, sir.
I'm sorry, Mom. Can we put it for a moment?
Of course.
What did I miss? No, I was watching. I was just needed to get off camera for a minute. It's exhausting being on camera for 8 hours a day. We're up to 6 right now.
Mr. Hausdorf, if we heard testimony that when this firearm was found, the slide was not totally seated, does that make sense to you? Am I saying the right words?
Are you basically saying that it wasn't in battery, that it wasn't all the way forward?
Yes, in battery, that's what he said.
Okay.
And that there was a live round still in the shape.
I'll allow it to set up the scenario.
And that the deputy testified there was a live round that was still in the chamber.
Okay.
Is that something you're familiar with occurring in firearms?
It's a possibility. If the extractor is really tight, if the spring is very tight on that, it's possible that it would not go around the extracting groove on the cartridge. If that happens, it could get stuck back just slightly. I mean, a quick jar to the back of the firearm could knock it over that. But normal operation of the firearm, it should cycle properly. And since I test fired it 3 times, I didn't have that issue when I was firing.
And if it were not seated and that live round was not in a completely normal position, would that prevent the gun from firing?
Yes, ma'am. It won't fire when it's out of battery.
Thank you. I'm now going to show you states 4 through 7, which I believe are your items 3 through. You take a look at states 4 through 7 and tell me if you recognize them as items you previously examined. I messed up.
Yes, ma'am.
Thank you. And how do you know these are items you previously examined?
They all are marked with the FDLE case number, item number, and my initials in my handwriting.
And what are these items?
These are the fire cartridge cases that I received in this case.
And what is the caliber of these casings?
They're 45 auto plus P, and the plus P just stands for higher ammunition pressure.
And what does that mean, higher ammunition pressure?
It means they're loaded to have higher velocity.
And velocity is the speed in which they travel?
Yes, ma'am.
And how do you know the caliber of these casings?
It's written on the head of the cartridge, which is right back here.
And is there a name for that end of the cartridge?
That's the head.
Thank you. And what type of examination or testing did you conduct on these cartridge cases in states 4 through 7?
So these cartridge cases, I performed an examination that I was trying to compare these cartridge cases to the test fires that I created from this firearm to determine if they were fired in this particular firearm.
And how do you accomplish that?
So when I test fire the firearm in our indoor laboratory range, I use laboratory ammunition that's similar to the evidence that I received in this case. So I test fired 3 Hornady rounds that were 45 auto, which is the same brand that I received in this case. After I get done test firing it, I take the cartridge cases and the fired bullets that I received back to my office where I compare them under a comparison microscope. It's 2 microscopes joined by an optical bridge that allows me to view 2 objects at the same time under the same magnification. So what I'll do is first look at my test to test, and I determine what's the repeating pattern that's coming from the firearm itself that's being transitioned to the cartridge cases and bullets during the firing process.
Can I stop you there just so
Yes,
we can
ma'am.
talk about that part?
Yes.
We're really going. And so you said you first look at test to test, and can you explain slowly
Yes,
what you're looking for to compare those, to see your test and what you're looking for to determine that?
I'm looking for the reproducible pattern that's coming from the firearm. So what happens is when the cartridge case is fired, or the cartridge is fired, the cartridge case will expand back and make impressions from inside the chamber of the firearm, as well as this end of the firearm, which is known as the breech face. And this is where the firing pin comes through and strikes the primer. All that pressure is going to push the cartridge case back against those areas, and all the microscopic imperfections within the firearm are being transferred to these cartridge cases during firing. The reason is the firearm is the harder object, the cartridge case is the softer object. The same thing is happening with the bullet. The bullet is going to expand, also known as obturating. It's going to seal all the gases in the barrel, and there's rifling inside the barrel, known as the lands and grooves. It's going to seal all those gases. The impressions are going to be transferred from the barrel to the bullet.
And when you looked at your test fires, you said there were 3?
Yes, ma'am.
Did they all have consistent patterns on them?
Yes, they do.
And so once you determine that they in fact received consistent patterns, what's the next step?
The next step is to take the one that has the best representation of that firearm. It's essentially, if you think about it, you're making like an ink stamp on the ground. It's the same stamp, but depending on the pressure, the angle, it's not going to look exactly the same. So I'll pick the one that has the best representation of everything from the firearm.
Hi, Scarlett. Everyone say hi to Scarlett. Brown-eyed girl's 4-year-old. She keeps saying hi, Melanie. And I said, Scarlett, she can't hear. Hi, Scarlett. Hi. I can hear you.
And when I do that, I'll place one of those test fires on the right side of my scope, and I'll take one of the unknown cartridge cases on the left side of my scope. And when I look at them on the oculars, I overlay the images on top of one another, and I can see the patterns repeating between one another.
And once you compared your test fires to the cartridge cases in states 4 through 7, did you make a determination about their relationship to this firearm?
Yes, ma'am. All 4 of these were in fact fired in this firearm.
Thank you. I want to now show you states 8, 9, 10. And 14. Would you like to take a look at these items?
Yes. Thank you.
And tell me if there are items that you've previously seen in your lab.
Yes, ma'am.
And how do you know?
All right, we need a break from this. Wednesday, Ophelia, thank you for the 10. Says, can we please stop armchair diagnosing personality disorders? Some of us are in treatment because of childhood trauma, and the biggest threat we pose is to ourselves. Stigma contributes to very sad statistics. Thank you. Thank you. Wednesday. It's a beautiful name, Wednesday, Ophelia. Thanks. The Leaf Blower Society has decided to convene outside my window. Hopefully they won't be long.
They all have my markings on the base of the bullet with the FDLE item number, case number, and my initials in my handwriting.
And how are these items different from the cartridge cases we just talked about?
These are the bullets that are fired from the firearm.
And are you able to determine the caliber of fired bullets?
Yes, ma'am.
And how do you do that?
So what I'll do is a couple different ways. I'll measure the base of the bullets as well as the weight. And if I have both of those, that'll already give me my answer like that. And in this case, all 4 of these projectiles were intact. So I was able to tell the caliber just based off of that.
And what was the caliber you determined these bullets to be?
They're in 45 caliber class.
And that's the same caliber as the casings and the firearm, is that correct?
That's correct.
And what type, other than the weighing the measurements, what type of examination or testing did you conduct on these projectiles or bullets?
So I did the same thing as the cartridge cases. I examined the test fires from this firearm to the bullets here, determining if they were or were not fired from this particular firearm.
And once you did that comparison, were you able to, did you determine?
Yes, ma'am.
Okay, thank you, sorry. And I got distracted. And what was your finding?
That all 4 of these bullets were fired from this firearm.
No, I think the first time you said fired in and then you said fired from.
The reason I just say in is that cartridge cases are technically in the firearm, and I say from because the bullets leave.
And so there's really no difference other than it's technical.
Yes, ma'am.
Thank you, sir. Finally, I want to turn your attention to states 15, which is a fragment. Will you take a look at that and tell me if it is also something you previously examined?
Yes, ma'am.
And how do you know that is something you previously examined?
On this one here, it was too small for me to mark on the evidence itself, but on the container, I have the FDLE case number, item number, and my initials in my handwriting.
And were you able to conduct any analysis of that item?
On this one, my only analysis was that it was no value from microscopic comparison because it was too small and there was no individual characteristics or rifling seen.
So you can't make any determination. Could you make any determinations in comparison to the firearm or any of the other evidence?
No, ma'am.
Thank you. Does your work at FDLE also involve the chemical analysis of some clothing or other items?
Yes, ma'am.
And can you kind of describe what that entails?
So what that entails is what we're trying to accomplish is if there was a max distance to the discharge of the firearm to a garment that we receive. In this case, I received 1 t-shirt, and what I will do is I will visually, microscopically, and chemically test the t-shirt to see if there's any presence of gunshot residue or any vaporous lead from the firing process. So what happens when a gun goes off is there's a cloud of smoke that comes out of the gun. That's the vaporous lead that's caused from the primer material. What that is it will create basically a sooting around the hole, and it's indicative of a close shot. There's also gunpowder particles that can get left behind on the t-shirt as well. And some of those you can't see visually or microscopically, so we have to do chemical comparisons. In this case, I didn't see anything visually or microscopically, And I also did chemical testing to test for those burned gunpowder particles as well as that vaporous lead. And I was unable to determine anything.
You got ahead of me.
I'm sorry.
But it's okay. This is states too. Is this an item
Yes.
you previously analyzed in your lab?
Yes, ma'am.
I just want to slow you down a little bit and back up. So when you analyze this, you're looking for microscopic particles of
Gunpowder.
gunpowder. Thank you. And when you examined this shirt, did you find any of that?
No, ma'am.
And did you make any other observations, that indicated to you that this shirt was involved in a shooting at all?
Just besides the hole, no, ma'am.
Thank you. And what might explain the lack of gunshot powder on this shirt?
There's a multitude of reasons. Some of the common ones are going to be, it could be poor evidence handling. It could have maybe shaken off some of the gunpowder particles. It could be an intervening object. If there's something in between at the time of discharge, obviously those gunpowder particles or residues cannot make it to the actual t-shirt. It could be that there was either blood or debris that could have inhibited the chemical processing or masked any of the gunpowder residue that was on there. And then finally, it could be too far away to actually produce onto the shirt itself.
And what distance might you expect to find stippling on a shirt if those other factors were not involved?
It's various, but with a pistol of this nature, the gunpowder particles will typically fall off around 5 to 6 feet, and the vaporous lead will fall off around about 2 to 3 feet.
Thank you, sir. Judge, may I have just a moment?
Yes.
I don't have anything else for this witness, the defense may. Thank you, sir.
Thank you.
Cross.
Very briefly, so Mr. Hausdorf, your testimony here today is basically that the ammunition was fired from that gun in this case.
Yes, sir.
And you found no evidence of stippling or gunpowder residue.
That's correct.
And there's all kinds of reasons why that might be.
Yes, sir.
Thanks very much.
You're very welcome.
That's it. That's all he testified to.
No, sir. Thank you.
Can this witness be released?
Yes.
Mr. Taylor?
Yes, sir.
Sir, you're released from your subpoena. You're free to go.
Thank you, Judge.
Thank you. State.
Your Honor, at this time, the state rests.
State rests.
Members of the jury, the state is rested, so there's a couple of legal things we need to speak about. So I'm actually perfect time for your afternoon break. I'm going to give you 15 minutes. So remember, please don't discuss the case.
Okay, we can FF through this and we will probably hear a motion to dismiss from the defense as in every case.
So the state is rested. Obviously, we have a number of things we got to do. First and foremost, the JOA. I'm just surmising that it's going to be a lengthy JOA argument. So we got to get through that. Now, depending on what the ruling is on that, we also, if I do deny it, I want to talk with Ms. Benefield about my colloquy regarding testifying or not testifying. It won't be to get answers at this point. It'll just be the colloquy that I go through. I'm looking back through my notes. We've still got the issue of
JOA is a motion for a judgment of acquittal, which is the same as what I just said, which is like a motion to dismiss or for a directed verdict. So let's hear.
Vicky Mechanic, trial sub, and Richardson hearing. We've got the issue of Daubert and what's his name? Bliss? The expert.
Ferris.
Ferris, Ron.
I don't know where I got Bliss.
He's a police
You
officer.
smushed them together.
Okay. We've got that. And I have another Richardson issue. It just says 391 emails. Okay, Richardson emails. And then we also have the issue of Faith Brown.
Faith Brown is
And
Ashley's attorney.
She wasn't listed, but you want to call her to authenticate those emails, and I would assume put her own
Impeach.
her own explanation for them.
Yes.
Which would be inconsistent with the testimony Ms. Murphy gave.
Yeah. And there's one other matter.
Oh, all right.
In an effort to protect Ms. Benefield, because we've yet to deal with this, I issued another subpoena to the JA yesterday. So I've already heard from Ms. Floyd, who has filed, the court probably hasn't caught up with it yet. She's filed another motion to quash, but she's also filed for sanctions. So the court may want to deal with that.
Okay. Well, I guess we'll eventually just kind of wait and see if her presence is obviated by
Yes, sir.
by Ms. Brown's testimony. I don't want to make assumptions.
I understand.
So, I was going to kind of give you all the option. If you want to, I can give you the break that I'm giving them. You all can talk about, do we want to do some more work tonight? How late do we want to stay? Do we want to get all the way through this? Would it be better that we took care of some of this in the morning? Because I don't know when is Mr. Ferris going to be available?
I would anticipate when we decide to call them, they'll be available.
Okay.
Yeah.
All right.
I think we could do the JA, Your Honor, and the other stuff. We could do the JA, and maybe if you want to do the discovery now, I certainly wouldn't mind breaking a little early. I would guess that would be fine with them also.
Can I stop you? When you say JA, I think judicial assistant.
JOA.
JOA. Okay. I just want to clarify.
Sorry.
Thank you.
JOA, judgment of acquittal. They're going to make a motion to dismiss the case on the weight of the evidence, against the weight of the evidence. No jury could possibly find her guilty. They're going to make that argument. That's what he's talking about.
Well, yeah, I think let's at least get that done this evening.
Yes, okay. That was gonna be, I was trying to figure out if you meant JOA or JA.
Yes, I'm sorry.
So now,
That's the reason why breaking early probably.
right. So let me give you all a break.
Thank you.
Absolutely. When the jury comes back, I'll let them know that we have some work to do on our part. We're not leaving early. We've got stuff to do. And then we can hit the ground running tomorrow morning. Just so you know, because it's as soon as I said tomorrow morning, it was in my head. We could still start at 9. I'm open to that. But I will have a hearing at 8:30 because I've got motion for release of uncharged defendant, a 33-day motion. I'll have to hear first thing if it hasn't been obviated by the filing of the information or a null pros. I don't know yet.
And that's scheduled for 8:30?
I set it for 8:30 tomorrow. I asked for it to be set for 8:30. So you all take your break, and then I'll see you back here in about 12 minutes.
Thank you.
All right, let's see. We can FF to the break, through the break. Look at that. They're actually highlighting their comments on Law and Crime. I've never seen them do that before. Is that something new? Maybe because I rarely watch there unless I'm with you. And usually I go to Court TV because it doesn't have all this scrolly stuff to distract us. All right, looks like we're on real time, and it looks like they're still on break. Look at us catching up to real time at 3:14 p.m. here on the East Coast of the U.S. I have it up. Don't worry, you won't miss a thing. You won't miss a thing. Thank you, Shy Gal 8, for becoming a member. And Shy Gal 8 for throwing in a 10. Thank you, Melanie. This is a tough one, but you handle it like a true badass. Love it. And yes, kindness is everything. Is it really that hard? This is what I tell people when they start getting nasty in the chat. And we had to say goodbye to Dan this morning because he was in there just stirring the pot and causing trouble. Be nice or leave. Thank you, Shy Gal. Thank you for appreciating it. There's so many mean places you can go on YouTube and the internet that they should all just go flock there. Thank KS for becoming a member. And Caveman, thank you for chiming in. Case tracking and chain of custody number. Wow. Free Karen Reed. I can't read. KBC, thanks for the 5. I'm 2 hours behind, but I found the TikTok video of Eva's interview. Can I post the link in the chat? No, you can't post links in the chat. He emailed it to you. Great coverage. Thank you, KBC. I don't know if I'm going to play that or not. Is it actually of her interview or is it of her TikToks? I mean, is it just like pictures of her TikTok? Because we already saw that. Oh, I see. It looks like an interview. Let me just take a quick look at this because I don't know if I can play it or not. Oh, all right. We might play that. It's 5 minutes. Whose TikTok is this? I guess Core TV broadcast it because it's got Core TV on the that's not good. If you guys are behind, first thing this morning, they had an issue because Eva Benefield, who is Doug Benefield's daughter, was interviewed yesterday in the hallway by a reporter. And then Eva was called to the stand about the interview that she gave and the TikToks that she had posted to TikTok since the start of the trial. The judge told her not to do it again. But he didn't ban her from the courtroom. And I think he decided that he would reserve his decision on whether she could be recalled by the state. Gail Grace, thank you so much for the 20. Came into trial suspecting guilt. Prosecution has presented nothing but support for the defense. How in the world did this get charged? How can the judge not dismiss due to insufficient evidence? They rarely do. They like to leave it up to a jury. But this judge said, if I deny it, not when I deny it. If I deny it, careful choice of words, I don't know. There's evidence that she did shoot him. I think now the burden's going to shift to the defense that it was self-defense. Carol Ann, thanks so much for becoming a member. Munchell said, Madam Melanie, what are your thoughts so far? Possible outcome or what you wish would happen? I appreciate your thoughts as we have seen to be insightful. I need to see the defense case. And I need to see if there's anything else. But I think that there's so many people in the chat who are survivors of DV, and they've been watching this trial with me from the beginning. Everyone here seems to feel that she is indeed a survivor and that you don't need bruises to be a victim or a survivor of DV. They wouldn't let her Google searches in yet. They may let them in, but apparently months before the shooting in May of 2020, she was searching things such as how to co-parent with an abusive co-parent and other such searches that they were not allowed to get in at this time. So evidence points to me, my gut tells me that she is being authentic. I look at her demeanor in the courtroom and it doesn't look to me like she's faking. It doesn't look to me like she's acting. I think I may be in the minority. I know I'm in the minority of creators covering this trial. I know what goes on in other chats. I know how many people out there think she's guilty, guilty, guilty. But I hear from all of you every day on this trial that have been through it. And you've been through it. I trust your opinions as well. Mistrial, am I too optimistic in thinking the judge may allow more in as part of the defense case? Maybe just a stickler about cross. Yeah, maybe. He may let more in. The defense case in chief. Here we go. We're going back. Take a look.
So,
Yes, sir.
it's never easy, Your Honor. We have a witness issue. Faith Brown is available now, but she is not available tomorrow. She will not be a long witness. One which the court would entertain. However Your Honor wants to do it, while we have the jury here, I can call her. Or case law even says the Supreme Court case of State v. Smith, the court could call her as a court witness. And when she's done, then we could do the JOA or we could do it reverse.
I'm sorry, did you say she's here?
She may be outside now. She was on her way over.
I would at least like a few minutes to speak to her based on the fact that I didn't
She's not
know
with
about
the
her.
witness.
Yeah, of course, I'd absolutely give you that option. So that may, and certainly based upon the case law, certain witnesses and facts and evidence are going to have to be presented before, not Bliss, Ferris.
I just don't know how we can accomplish that when the evidence that they're attempting to seek also, I think, was never provided to the state. That's the other subject of your
Yes, it
Richardson
is
hearing.
actually.
She's being called as an impeachment witness because you called Stephanie Murphy to the stand.
Is those emails from the sealed hearing that we've now had access to, I think had to have been obtained by the defense from Ms. Faith, whatever.
Faith Brown.
Faith Brown, and because the state's never gotten this until yesterday.
Okay, well.
What was the date, September 30th of 20?
Now, Judge, those emails came from the state.
You're gonna have to show me where, because
I don't know.
Ooh, she's getting
We
testy.
don't need the back and forth. I'm trying to figure out.
I don't know how we have access to this.
Listen, this is for me, who typically is just, let's start the trial, let's go, let's get this thing done, not delaying it for the jury any more than we have to. So this is really outside the box for me. With all of the things that need to be done, what do you think about we make tomorrow a work day? I let the jury go, and then we come back Monday and hit the ground running with the defense case in chief. Tomorrow's a work day for us.
I think that would be outstanding out here.
My first one of the trial.
Yeah, he's psyched.
No,
And he's
that
like,
really would work.
I don't have to start my case until Monday. Maybe tomorrow we can just argue and talk about our motions and do things like that. And I can just start my case on Monday. He's like, yeah, I'll do it. Right on.
Out pretty well, because I got witnesses like planes stacked, and my head is spinning over it. So, yeah, that would.
And just so you know, State, this is also what I'm contemplating is the fact that whether or not I find any kind of Richardson violation for the emails or whatever the other one was, I can't remember what the other one was, then you have the entire weekend to go through everything. And we kind of hit reset, and then defense, you can come forward with your obligations. If it's a witness you expect to call, a document, a tangible object you intend to use at a hearing or trial, specifically identifying it, and hopefully that'll obviate those issues. Again, it's a little bit different for me, but
he never does that.
And Judge, I would be fine with that. My only concern is that I thought some of the alternates had conflicts next week, and I don't remember, and maybe it was actual seated jurors, I can't remember.
No.
There were conflicts that started next week.
But I don't know
I'm
if
not
it
sure what they were.
started Monday or Wednesday or.
I think the juror that, the gentleman we had last today, he has a conference starting Monday out of town. Not that we would be done tomorrow anyways, but.
Judge, I can only tell you that for my purposes, I believe I could have pretty much, even though I had some problems, I think if we hit the ground running Monday morning, I think I can move this thing pretty good.
right. But does that mean finish Monday or finish Tuesday?
Oh, definitely
Define finish.
Definitely don't finish Monday.
All right. So defense case done Monday. And
Then
then
we
you,
close Tuesday.
and then you,
That'd be the,
I think that might be optimistic. I think Wednesday probably is more realistic.
just
right, so
saying.
finish defense case Monday, but then we have jury instructions.
Right.
Oh,
He doesn't-
can't. I apologize.
He's not going to
sir.
be done Monday. Right.
So you expect to finish Tuesday?
I hope to finish Tuesday. I didn't mislead the court when I said I had a number of witnesses. I will do my best to end it on Tuesday, but it's going to be challenging.
That's interesting too, because all the pretrial information said that they were reporting that the defense was only going to call one witness and it was going to be Ashley's mother. He's got a lot of witnesses. In fact, he's got one in the hallway right now waiting to come in, but they're not going to take her today because he said he couldn't be there tomorrow.
Yes, I mean, you're correct in identifying that some of the jurors expressed that they had time restraints, but however, both sides chose to keep them.
Well, I think what would Wednesday on the calendar be?
Next Wednesday is the 31st.
I think we still should be okay. I know for me, I had some scheduling issues at or around the 1st. So
right,
we can try to finish the case up Tuesday, if not early Wednesday.
Judge, I just think if we're talking about the defense not even being done on Tuesday, I don't want to take a whole day with nothing. I mean, but I recognize that I don't make the final decision, but that would be my opinion, is to not go a full day.
So let the jury come in late tomorrow. Let the jury come in after lunch, do an afternoon of testimony.
Without doing any trial tomorrow, but.
All right. Do you have some witnesses, defense, that you could call tomorrow afternoon?
Just one.
Yes.
All right. So what we could do is we could do some work this evening. Again, depending on what my ruling is on the JOA, we come back tomorrow morning. Oh, and I checked, the information is filed, so I do not have the hearing at 8:30. But we can start first thing tomorrow morning with these hearings that we need to get through. Go to lunch, and I tell the jury to be back here at like 1 o'clock. And then we start the defense's case in chief around 1. And go as far as we can. Okay?
Yeah.
You're nodding your heads, but
I like that idea. It works for me.
Sorry.
All right, so if you could, let's bring the jury back out. I'm going to release them for the evening and ask them to be back at the jury assembly room tomorrow about 12:45 with a goal of having them up here around 1 o'clock.
So, I'm sorry, Judge. I'm wondering, where does that leave me with Faith Brown?
On Monday.
Well, if she's not available tomorrow.
She's not. She's available Monday. No, she's out the whole week. Tuesday.
I'd say maybe call her Monday.
Yeah, that'd be fine. I just want to make sure she's available.
Sure.
Yeah.
Right, okay. Is she under subpoena?
No.
Judge, I just feel like the state doesn't have the option to say our witnesses are not available. I mean, if they're traveling or the next morning or whatever, but to delay an entire day because they didn't make arrangements with their witness, who they haven't listed.
Okay, their witness is in the hallway right now, ma'am. So like he just said, counselor, he's willing to let her come in right now and testify, but you're going to oppose her testimony, even though she's coming in to impeach your witness, Stephanie Murphy, that nobody in this chat really had a warm and fuzzy feeling about. And that's why they're calling this witness, who's an attorney, who probably has a very busy schedule. So if you just want to consent to her testimony being today, since it's only 3:30, perhaps why don't you just stipulate to letting her testify, and then she can come in right now. Okay? Can't have your cake and eat it too, babe.
Outrageous.
No, hold on.
Outrageous.
This is me, because I want to get these, I got a bunch of hearings that I got to get done, including colloquy with the defendant. If Faith Brown isn't available tomorrow, then we can just call her Monday, and that'll give you a chance to get a deposition done. Did he step out to ask? What's he asking?
Want me to bring her in?
Trying to find out her
I just
availability.
need to know, is that the plan?
Yeah.
So, because I want to let the jury go, tell them to be here tomorrow at 12:45.
He's out there asking her now. And if there's no chance that we can put her on today, then.
No, I agree with the state. She hasn't even been listed. So I certainly will allow you to call her, because I understand the reason why you need her. But I think the state, again, hearkening back to that due process concept, they have a right to speak with her and take her deposition.
Okay.
Oh, you guys are paying attention. She's not available Monday. I know everyone. I'd love some carrot cake. I would love some carrot. I love carrot cake too.
Can you give me a moment?
Of course.
I can't recall one, Nikki, where the judge has granted like a motion to dismiss or directed verdict, or what they're calling a JOA, a judgment of acquittal. Ashley is tall, unless her lawyer is not that tall, but I think she's 5'9". I don't know why I think that. Did I read it in the Vanity Fair article? Maybe. Look at us on real time. Screech owl. That is probably, a screech owl sound is probably one of the worst sounds out there. Sounds like if you've ever heard a screech owl, it sounds like a woman screaming or a baby screaming. It's a horrible. I used to have a screech owl that was right in my yard somewhere. It was too close. Every time that thing would make a sound, it would freak me out. Says, please don't hate me, but does anyone think these prosecutors automatically like Ashley? I think you're going to say automatically I think you meant to automatically dislike Ashley because she's tall and thin and beautiful. And I'm not going to hate you for that, because I am one of the first people to say that the hate comes from other women, mostly other women, in a lot of these cases that we cover. And I am trying to figure it out too. And a lot of people in the chat are like, because they're jealous. And it's like, so gross. But I don't think I think that that's a realistic thing to say. They dislike her for sure. I mean, we saw it in Karen Reed too. The attacks that were coming from women on the internet who call themselves professionals, who appear on these mainstream media court TV channels as like talking head type experts. The hatred, the vitriol, the nastiness spewing from them and their posts on that cesspool of Twitter about Karen Reed's skirts being too short for court and how it's disrespectful to the court. And I played earlier this morning the piece from Julie Grant and her jury consultant expert, who said that, Ashley's braids were disrespectful to court, that hairstyle was disrespectful to the court, and that she liked her other look better when a couple of weeks ago when she was wearing a fancy suit and had makeup on, and she's trying to make herself look unattractive on purpose, and she should go back to her other look. Like, why is it even being talked about? Nixie says it's self-hate, self-judgment that evolved in their brains. Yeah, projection. And Scott McGinnis says, glad a woman made that comment, because if I do, I'm a sexist man. We don't know if Screech Owl's a man or a woman, interestingly enough, Scott. You're one of the few brave enough out there to go by your real name. You and me. So, the trolls know where to find us and who to tag in their vitriolic posts. But yeah, the braids comment was wild. We're in real time, so I'm just going to mute this until if and when They start talking again. Yep, Kev says if her hair was down, then she'd be trying to hide her face. You cannot win. Screech Owl is a woman. Thank you, Screech Owl. I didn't know. How can I tell? You have a gender neutral name. It is ridiculous. I believe it. It's ridiculous. I am Titanium says, I have never heard of disrespectful braids before. They really had to scrape to get to that. Yeah, somebody, can you guys make me laugh today? We haven't laughed enough today. Give me some snarky comments, but not mean ones, just snarky ones, just something to make me laugh. We need to laugh some more. Cat's Pajamas says, Melanie, I call it the great unveiling. And we are seeing the true nature of people. That is really, really depressing and sad and scary all at once. All at once. Right. Braids are disrespectful, but an abusive husband's okay. Said Lucy Fair. WTAF. I don't curse on this channel, and it's only because my viewers have come to like it that way, and because they listen to me with their kids in the room, and because their 95-year-old moms want to watch true crime without language. And somebody actually started an entire thread on Reddit that assumed that because I said I don't use foul language on my channel, that I was in some way taking shots at Emily D. Baker, which couldn't be anything. There could be nothing further from the truth. I love Emily. I love what she does. She's a pioneer in the LawTube community. So just because I don't want to use foul language is not a diss against Emily. I couldn't believe it. Like, really, they're starting an entire Reddit thread about it. It's wild. It's wild. I love Emily. We're both Dave Matthews fans. How could I not love Emily? Like, give me a break. Karen, thanks for being a new member from Canada, says, I think the gentleman that left may have been the pastors. They generally don't look at photos of the deceased autopsy, something to do with the desecration of the person. Thank you. And when Jules called in during lunch, she did tell us that there were 3 pastors in the gallery that were supporting Ashley, that were there for Ashley. Sebastian says there's many forms of abuse. And also, Grizzly True Crime Chat is so anti-Ashley. I don't get it. I don't get it. Right, Gringa. Both are extremely intelligent lawyers. Well, thank you for the compliment. Each with their own style. There's room for all of it. And that's what I say. I'm like, people who watch LawTube are going to watch everyone, and they'll go to everyone for their reactions and their opinions. I don't find it to be a competition. That's not how I am.
We're going to do up motions this afternoon.
And if you know me, you know that I'm a woman who likes to lift up other women. Okay? Oh my goodness. All right. She's already complaining, this other lawyer. I'm still waiting for something to make me laugh.
I'm happy to report, Your Honor, she will be available tomorrow at 9 o'clock. She's got a little window, so we're good.
So we're going to do up motions this afternoon.
Yeah.
Thank you, Judge.
Yep. And hopefully she's available for you to speak with her. Do you want to step out and make those arrangements now?
Yes.
But while you're doing that, can one of you stay?
Yes,
and I'm going to tell the jury 12:45 tomorrow. Well, no, wait a minute.
Right, now we have to have them here in the morning.
Now I need them here in the morning.
Yeah.
Okay. All right.
All right, we are guilty, Teresa. Teresa says, then juries love attractive men. We are guilty of listen, by the time we got to the Crash Daddies and the Karen Reed case, it was like 65 witnesses in and 10 weeks of testimony. And there's a hilarious video. Is it Aussie Insider who did that video of the judge's reactions to one of the experts on the stand? You guys call it Crash Daddies. That makes me laugh. Thank you. Thank you.
Did that come up during your conversations?
Thank you. Are you ready?
But I'm sure she'll talk to them, Judge.
Go ahead.
Okay, you need a witness because who knows what they're going to say to her. Thank you. RB, ready? It is. It's like the Baskin Robbins of the internet, says Janelle. I love the channel variety on LawTube. It's like the Baskin Robbins of the internet. All right, they're gonna have to call the jury in and excuse them. It was Aussie Insider, right, that did that video? All right, I can't listen to the papers. The papers. Gotta get the papers. What was that from? You gotta get the papers. You gotta sign the papers. Ashley needs some crash daddies. That is, I know. We're not being disrespectful. Look, we can all say it's a compliment. I think it's a compliment to call them the crash daddies. I'm just saying. That's my opinion, and I'm sticking to it. Some victims of DV can't use their real names on a public forum. Oh no, I am not, Pilgrim Shadow, in any way saying that you should at all. I'm just saying thank you for your 5. I'm just saying that those of us who do use our real names on the internet, and maybe if I had known about the craziness and the trolls that are out there that will stop at nothing to try and destroy people, I might not have I might do it differently. But it's too late for me now. But I totally agree with you. And Allison, thank you for becoming a new member. Heavy rain out of nowhere in Rhode Island. That's interesting. Look at Elena. Elena going over to the Court TV chat and causing trouble. Just lit up the Court TV chat about that comment with the braids. Ridiculous. Crash Daddy's wife thought it was funny. Oh yeah, and then somebody doxed her, right? Didn't somebody dox one of those experts' wives and put a picture up from Facebook of her family on like Twitter or something and said she's in a Free Karen Read face group, and they shamed her, Laura. It's horrible.
Other side, and was not told that because she wasn't expecting to be witness, that she could not observe the proceedings. So she has watched some of the proceedings. Once I contacted her, told me that we needed her, we told her to stop, and of course she's conformed to that. I don't know if that presents an issue, but I want to disclose that to the court, and Ms. Brown wanted me to as well.
Okay. You don't have to say anything now. I'm just, okay. You're on notice.
Oh, I didn't mean to.
We're just waiting for her, Ms. O'Donnell, to come back in and confirm that we can get, you guys can speak with her tonight or tomorrow. Yeah.
Really? They need to do a whole deposition of her? All she's going to do is come in and put to rest everything Stephanie Murphy had to. I keep wanting to say Wendy Murphy, but it's
depose her in the morning, one or the other.
Depose her in the morning. You're going to spend the money. You're going to spend the state's money doing a deposition of a rebuttal sort of impeachment witness. Really, is it really necessary to spend the state's money on that? My goodness. Laura says, yep, because she said hi to Rita and friends. Yep. Shame on people who shame people. That was a good comment. Too bad it flew by, and I can't see it. But yeah, shame on people who shame people, 100%. There it is. Devin said that. Yes, we don't allow that name to be spoken on the channel. Robin, please refer to her as JC, the one who is still looking for the Hamburglar. That Pink Panther video was so funny. Is this chat actually loud? I don't know. Is it? Mm-hmm. They sure did. Wait, somebody said that Mike said something funny. We gotta go find it now. Ring the bell of shame on shamers.
No, it's fine. Don't worry about it. Yes, bring him in.
Bring in the jury. Sorry, Catman. Ain't no time to hate. Thank you. Thank you, John Little. Live. By shaming the shamers, you are becoming the shamer. I think the shamers should be called out on their shaming, because shame on shamers. Yeah, Vesper, where you been, Vesper? This is the first time I've seen you comment all day, Vesper Q. A long day, you guys. We're up to 7 hours almost. Right, Elf. Elf knows.
All right, y'all can have a seat. Welcome back, everybody. I know what you're thinking, that was longer than 15 minutes. But, okay, so there are some things that we need to do on our end. And the reason I gave you that break was to have a conversation with the attorneys and kind of make a list of everything that we need to do before we can move on to the next step. So what I'm going to do is we're going to stay this evening and keep working, but I'm going to let you all go for the evening. So remember, please don't discuss amongst yourselves anything about the case or begin deliberations. Don't talk with anybody outside of the jury about the case. And please don't do any research on people, places, things, or legal topics you've heard anything about. Tomorrow, if I could have you downstairs in the jury assembly room at 8:45, and we're going to have a goal to start up here about 9 o'clock. Figure if we stay late, and then some things tomorrow morning, we should be ready to get going then, okay?
Yes, sir. Okay, thank you.
The Taylor Swift, who says the haters are gonna hate, 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 hate. Look at Big X Daddy X Slim says I'm a man who was raised to be a protector to the women in my life, and I'm glad this channel exists so all the strong and brave victims of DV or survivors can tell their stories. I love it. I love all the very cool men like Big X Daddy Slim that join us and contribute and are so empathetic. Have empathy, kindness.
All right,
Okay.
the state having rested defense, your JOA.
Will be the motion to dismiss by the defense. And we're back on real time.
I have several bases upon which Ashley Benefield at this time, Your Honor, moves for a judgment of acquittal. To begin with, as the court knows, the information charges second-degree murder and requires proof that Ms. Benefield acted with a depraved mind. Furthermore, the evidence that exists at this point has raised a significant self-defense claim. And it's our position that, number one, the state has utterly failed to offer any evidence whatsoever to establish the essential element of a depraved mind. And number two, the state has failed to offer any evidence to overcome the self-defense claim that was raised as a result of the 9/11 call, wherein my client is heard to exclaim, "He attacked me and I shot him," together with the scratches and the bruise to the left side of her face. So let me expand on that a little bit. For purposes of a depraved mind, we need ill will or hatred. No credible evidence has been forthcoming in any shape, form, or fashion that Ashley Benefield acted with ill will or hatred towards Doug Benefield. What has been established is that Ashley Benefield feared Doug Benefield and that Ashley Benefield wanted to be done with that relationship, but there has been no evidence at all that Ashley Benefield hated him, acted out of ill will spite, or malice. The record is devoid of any evidence
Right, he's right.
establishing that. There's also no demonstration, Your Honor, of indifference to human life, the alternative element. In fact, what there is evidence that in response to this terrible event, Ms. Benefield immediately fled next door to call 911. And 911, of course, is what you do to summon help. And there has been nothing indicated otherwise that Ms. Benefield displayed indifference to human life. In particular, Your Honor, John Sant put the self-defense issue in play. He testified that Ms. Benefield said, "He attacked me and I shot him." The state has failed to negate in any capacity whatsoever, even when viewed in the light most favorable to the prosecution, that there has been proof established beyond a reasonable doubt that Ms. Benefield's use of force was not justified. All we have is he attacked me and I shot him. There's been nothing to undermine that. The state claimed that the release of the Broder report was the linchpin, and I think that that's pretty much been voided entirely by Dr. Broder's own testimony, yet alone Dr. Quintal's. And they have utterly failed to prove beyond a reasonable doubt that the use of force was not justifiable. Under those circumstances, at this point, Judge Whyte, no reasonable jury could convict Ashley Benefield. And if they are properly instructed on the law of self-defense and the state's burden to disprove it, they could conclude that the state has failed to meet its burden. The self-defense context, Judge Whyte, is crucial because it directly contradicts the notion of a depraved mind, and that Ms. Benefield was acting pursuant to that as opposed to acting in self-defense. She acted out of a legitimate fear for her safety. Then I have two other bases. Again, the court should remember that the state's theory, very specifically advanced in the opening statement, was that 3 days following the shooting was the denouement, the release of Dr. Broder's report, and therein was the reason for the shooting. Their alternative theory was that she killed him to keep him away from Emerson, their child together. What evidence has been produced to establish that? We heard from Dr. Broder nothing whatsoever contained in his report that was in the slightest manner detrimental to Ms. Benefield. Quite the contrary, Dr. Broder told us he concluded that Ashley had no impetuous tendencies, was not prone to anger.
Yep. But she would fear retribution.
Then there was Dr. Quintal, who said that, yes, she was concerned about the release of Broder's report, but only because she was afraid it would create reprisal from Doug Benefield if he found out what she said about him.
Retribution.
And of course, then there's the whole issue about the email where Broder's release of that report was not scheduled for the 30th. The only evidence that we've seen that supports their alternative theory, the state's alternative theory that she killed her husband to keep him away from their child, is this. 5 reports of abuse of Emerson were filed with DCF. Of those 5, 2 were from independent sources.
I thought 3 were.
Where is there anything in that other than sheer speculation, trying to roll an inference and an innuendo into a fact, where is there anything possible that justifies the fact that 5 abuse reports were filed, 2 of which were by independent third parties? How do you go from that to killing Doug Benefield to keep him away from the child? This is their case. They have the burden to produce that. They haven't done it, Your Honor. And we think a judgment of acquittal is appropriate. Thank you.
Thank you, sir.
I mean, okay. The burden. So here's something interesting that I wasn't sure about in Florida, but when you claim self-defense, the state has the burden to disprove self-defense. So I ask you, did the state disprove self-defense? Did the state show you any vitriolic, hateful text messages from Ashley to Doug, like, oh, I'm going to kill you? Get the F away from me. She never even used profanity. Did they show you anything to disprove self-defense? In fact, we heard the doctors testify, the therapists that they were going to testify, that there were 5 complaints of abuse against their daughter. 2 of them, I thought it was 3 of them. He says 2 of them were from independent third parties. We saw a lot of messages of a woman who in my mind was trying to placate him. We heard one of the therapists testify that she did not want to get back together with him. What did they show when the burden shifts to them to prove that it's not self-defense? She shot him and she ran to the neighbor to have the neighbor call 911. Everything that we've seen, all the evidence that they presented, in my opinion, paints Ashley as a kind person, a good mother, and someone who was afraid of Doug, including his creepy cousin who testified, by the way. He was even on her side when she got restraining orders. She had restraining orders and said nobody would enforce them. And that horrible DV investigator who got up on the stand, who looked like, I don't know, Proctor or one of them, and was complaining about how many times she was calling him and annoying him to get him to try and enforce the order of protection against Doug that she had in South Carolina. Their entire case, in my opinion, points to self-defense, and they did nothing to disprove it. All right, let's see what I'm sure he's not going to grant it, but I want to see what the prosecution has to say for themselves.
And Judge, just at the onset, I disagree with a lot of the defense's recitation of the facts as they've come out. I believe a lot of what he said, witnesses said, were not accurate. I don't believe that a lot of the witnesses said exactly in the manner that he just said things that he said.
We were there. We heard it, ma'am.
Judge, clearly,
no, the jury's
the
not there.
state has shown that this defense.
The jury is not there, and we just heard everything he said. And in fact, I think he underestimated. I think there were 3 complaints from independent sources, not 2, with regard to the child abuse. We listened to it. Did he say anything inaccurate? Because I know you guys listen really closely. His argument wasn't that long. It was a couple minutes long.
Defendant killed Doug Benefield. She shot him 4 times. He died as a result of that.
She didn't shoot him 4 times. There were 2 bullets. 2 were in the wall. But go on with your bad self. Who's misstating facts now, ma'am?
No dispute. No one is disputing that she did not kill him. So the only issue would be the depraved mind regardless of human life. And the defense did mention ill will, hatred, spite, or ill will and hatred, but there is also spite or evil intent. And that is disjunctive, so it's or. And ill will is a very low threshold, to be honest. And the state has shown extensive evidence of motive, of the fact that this woman did not want to share custody of her child with this victim, to the point where she would make allegations against him of sexually abusing his 1-year-old daughter and physically.
None of that came into evidence because the jury doesn't know who made those complaints.
Abusing his 1-year-old daughter. And none of these were sustained. And she moved on and on and on and on. And she made comments like, I'll do whatever I have to do to keep my baby a-hole. I'm running out of time. And she's frustrated that nobody's helping her.
She said that to the DV investigator, not to Doug, ma'am.
Whatever I have to do. She's making all of these comments at the same time that she's making all of these false complaints, and the state does call them false complaints, of abuse to her child. Also, I think defense counsel has made a much bigger deal about Dr. Broder's report coming out than I think the state actually ever did. The state said that this was the same exact judge that she had not had luck with before. And implied that she didn't want to be in front of this same judge again. And in addition, Dr. Broder's report was coming out, and that was going to be a problem as well. So I think there are several reasons. But when you talk about the actual evidence itself of the shooting, she shot 4 times. And the entrance wound of the fatal wound is not front. It is side to side. So he was turned away from her.
Are you kidding?
And then it's the state's argument that he was.
Wait a second. Did we all not watch the medical examiner together? Didn't he point to his nipple and say, this is where the bullet went in? It was not side to side. Is she seriously going to sit here and discredit her own medical examiner? Didn't we all watch? Maybe there were warning shots fired. She
was moving his leg to run when he was shot as he's running away.
That's not what anybody said. There is nobody that testified that he was running away. In fact, the medical examiner said it could have been when his legs were up in the air. So nobody said he was running away. She's putting stuff in her argument that's not even in evidence. So hopefully he has a nipple on the side of his body. Oh, I knew somebody could make me laugh today. No, it's not closing. They're arguing a motion to dismiss, or what they call a JOA in Florida, judgment of acquittal. After the close of the state's case, she's opposing defense's motion, who said the state did not disprove self-defense.
Then just leaves him there to die and runs away.
They call 911 at the neighbor's house.
And Judge, I think all of these things together, in the light most favorable to the state, I don't think the defense has put on any evidence of self-defense. The defense has attempted to put in a lot of evidence, and things were objected to and sustained by Your Honor. So a lot of the things that defense just argued have not come in as evidence. So in the light most favorable to the state, we would ask you to deny the JOA.
Thank you. Mr. Taylor, would you like to place any rebuttal on the record?
Please do.
Very briefly. Thank you.
Or not briefly?
Yep, no, briefly.
He's like, yeah. He's like, take as much time as you need. Take as much time as you need. I don't know. I don't want to get my hopes up on this.
Here's what we have according to the state. We have a woman who is going through a divorce, who has no prior history of criminality or arrest, who, according to Broder, has no impetuous fits of anger, who has done everything according to the requirements of the law, filing the report after report, not doing anything but
staying in compliance is what a citizen is supposed to do. And she goes from that to killing Douglas Benefield on a naked theory. There's no evidence in support for a predicate to establish that theory. There's an inference. You have to take an incredible leap of faith to go from somebody who has no prior history and is living with a gentleman who's committed this kind of conduct, and you go from there to killing him. She didn't shoot him 4 times. He wasn't running away. It's going to be a pretty good trick. As the court knows, the trajectory of the leg bullet was up. So how high do you want him to lift his leg as he's running away? Because she would have to be laying on the floor and shooting up to be able to get that bullet to go into his calf and out his knee. That's a real trick. I would suggest to the court, we have raised the legitimate issue of self-defense by virtue of that 9/11 call. They have failed and failed miserably to rebut it. And I thought it was very, very clear. Dr. Vega, I asked him, would this be an accurate statement, Dr. Vega, that the pistol was facing Douglas Benefield when he was shot? Dr. Vega said, yes, that would be an accurate statement. No matter how much she wants to twist it, and I hope she stays with it because I think the jurors will punish her. The bullet may have gone in the side, but Dr. Vega said he was facing the pistol. She was firing from in front of him. That's uncontradicted. Thank you.
All right, thank you both very much. I'm not aware of any recent changes in the standard by which I'm to make my ruling on a judgment of acquittal. I think I heard the defense argue that no reasonable jury could find the defendant guilty beyond a reasonable doubt. I know certainly the appellate courts talk about looking at cases in that light, and I believe that's the standard at the close of all evidence. But my understanding of a judgment of acquittal motion is I am to look at the facts in the light most favorable to the state, including any reasonable inferences therefrom, and decide whether the state has established a prima facie case. Am I mistaken?
No.
No.
Okay, all right, I just want to make sure. So, I think it is a very interesting and unique argument that the defense raised, and they very well could be right that the issue of self-defense can be established during the state's case in chief by a preponderance of the evidence. I don't find support in the law for that. And I think that my findings from earlier are bolstered when you consider at the judgment of acquittal, I'm not looking at any evidence that the defense has produced or any inferences on the defense evidence. I'm looking solely at the evidence presented by the state. I have to construe all facts and in the light most favorable to the state. Any reasonable inferences that can be drawn from those facts have to be inferred in favor of the state. And I'm only looking to see if they've established a prima facie case for the charge or charges alleged in the information. So as I look at the information that we all agreed is the operative pleading in this case from November 16th of 2020, the state has made a prima facie case. I think based upon the facts that have been established, again, looking at them in the light most favorable to the state, including the reasonable inferences, I do find that the state has established the elements of murder in the second degree prima facie. There's a prima facie case for the elements. So I will deny the judgment of acquittal.
Boo. Boo.
You're going to see Miss Brown. I'm assuming you want to talk to her first and look through these emails before we address the Richardson, but that's just an assumption.
There have been some developments with the Richardson, you're talking about the Richardson issue based on the emails.
The 391 emails.
It's 390.
Was it, I might be mixing apples and oranges. Something was 390 and something was.
A Richardson hearing is a discovery violation hearing. We called them in, weren't they Rule 17 motions or something such as like that in Massachusetts? But it's just basically a discovery violation hearing.
316 and
I think there's two issues. I think the first issue was this document that we got that you unsealed had a part missing. And so I could not identify this as something that we gave to the defense. Mr. O'Keefe and I have talked and he showed me the part that was missing. And based on that part missing, I will go back now and try to find it. So
what is it, a header or something?
Yes, it was the top of an
The auto-generated header?
Yes.
All right.
And he was saying that it came from a Google search warrant. I said, I would not have gotten Stephanie Murphy's emails from a Google search warrant. Well, apparently this was in Ashley Benefield's Google account. But the heading forwarding it to her was not on this. That being said, I can no longer represent that we do not have this. However, the defense listed it as number 391. Is that what the number is?
277.
277 on their exhibit list. And it listed the entire Google search warrant return data. And I recognize that there's not a lot we can do now with what I'm holding in my hand, but I just want to reiterate that the defense is supposed to give us what they intend to enter. So saying to me that the Google search warrant return, which had hundreds and hundreds of documents, that is not complying with the rules of discovery. The rules of discovery are that you give me copies or at least clue me into where it is and what exact pages are intended to be entered. And that's the rules of discovery. So I don't know that there's a whole lot we can do to solve this now, and anything that there would be to solve, I can hopefully do that in the future before we have any more testimony about these. But that I can just tell you that that's sort of some of the difficulty that the state's experiencing, is that we're looking at some of this for the first time because we haven't been put on notice of it.
So are you asking or alleging a Richardson violation? Because it's per se reversible error if I don't conduct a Richardson hearing.
I would ask you to go ahead and conduct a Richardson hearing, Judge, and then just to be safe.
Do you want to do it now?
Yes.
All right. So the issue is a discovery violation by the defense, and I just need you to outline it specifically for me. Are you saying that they did not turn over evidence they should have, or is this based upon the alleged failure to specifically identify documents and other tangible objects that they intended to use at trial, or is it something else?
It is the second, Judge. It is that a list of 365 items, and they are all folders, computer folders with attachments and different pages, is not the notice that is required by the defense when they are required to give the state notice of what they intend to enter into evidence. So while the file umbrella may have been listed on this exhibit list, the state was not put on notice or told which pages would be used as an exhibit. So that would be done.
She's just saying it's not specific enough. She had everything, but she doesn't, she wants it to be, it wasn't specific She found the paperwork, but it wasn't specifically identified which thing, which exhibit, which page he wanted to use in evidence.
Substance of firearm.
Did these emails come from the state? Were they recovered by law enforcement?
Yes.
And so you listed them in your discovery and provided them to the defense?
Yeah, and Judge, I have not been able to verify that. This is the first time.
Yeah, so don't say yes if you haven't verified
But
something.
I am saying yes because the defense has shown me the page that I was missing that puts the puzzle together and shows that it probably was, as they are saying, that it came back to us in a search warrant amongst thousands of documents.
Okay.
So
you have it. So what's the prejudice?
That, I would take that as true based on that representation that I can probably go back now and trace it and see that it's probably part of the thousands of documents. So that would not be the basis of my
turned it over to them.
My allegation. The basis would be not complying with the specific notice requirement of what exact documents you intend to use at a trial.
All right, do you want to be heard?
I think what keeps bouncing around in my head is I understand and I appreciate that even though there's hundreds of thousands of pages, we are supposed to extract and list specifically what we intend to use. But what keeps bouncing around in my head is I never expected a witness that the state called come in and perjure themselves. And now, we would have been fine if Stephanie Murphy had just told the truth. And now we're in this position where the emails clearly demonstrate beyond any shadow of a doubt that the testimony was wrong. So I think the court should factor that into the position we find ourselves, because I understand and I appreciate technically it's a violation. I would suggest the court certainly wasn't willful. But let's assume the state gets their way. We live with perjured testimony, that can't be right either. So we have to find the happy medium here somehow, understanding and appreciating that we were on guard for this development months ago, and that was why we issued the subpoena to the JA. But I will tell the court candidly, I never actually expected to see it again on the witness stand in front of the jury.
Thank you, sir. Rebuttal?
Yes, Judge. I think that is, I'm trying to find the right word. On July 16th, Your Honor held an ex parte hearing, as you know, that you unsealed yesterday. At that hearing on July 16th, Mr. Taylor said on page 4, I have an envelope to seal this if necessary. I have Ms. Murphy's stand your ground testimony that I will pass to the court.
You might need to slow down a little bit.
That I will pass to the court, which I marked, where she says exactly that the hearing on the release of Dr. Broder's report was scheduled for the 30th. The shooting took place on the 20th. He goes on to continue talking. That was the point. These are the very emails he provided Your Honor during that hearing. So it's clear that he anticipated from this unsealed transcript and the documents that Ms. Murphy was going to testify the exact same way she testified at the stand your ground. So to now say he had no idea that she would do this, which the state finds offensive, he keeps calling it further testimony, but that he had no idea this was going to be the testimony is confusing. I can't think of the right word. Because it's clear from your hearing that he did, and Your Honor asked him, were these turned over? You had extensive conversations about these emails, whether they were provided, those kind of things. So it's clear that in the state of the defense, 6 days before trial, they knew this was an issue, and they knew that it was going to become an issue. So to now say that they did not know is confusing to the state. So the state feels like this wasn't intentional. They had a hearing with Your Honor that they asked for it to be private, And although they said it was about Vicky Mechanic, they're the same emails. It's the same email chain. And so the state feels that it was an intentional violation. Thank you.
All right, thank you both very much. Richardson is very specific, and fortunately for experience purposes, I've had to do quite a few of them. Unfortunately, I still continue to do them because they're discovery violations. It is one of the most basic fundamental ideas in Florida criminal law, and anybody who's done any practice in federal court or other states knows the length, breadth, and extent of how open our discovery rules are. This is not supposed to be a surprise or a gotcha state. With that said, I am not aware of case law holding a Richardson violation for a failure under the defendant's obligation under 3.220 to specify those documents or tangible things that they intend to use at a hearing or a trial. It's much more along the lines of never disclosed or hiding. So with that said, I don't think ultimately the Richardson framework or rubric fits this situation. I think the findings I think I'm going to make and need to be made are, I don't think there was a willful violation to the extent of the defense hiding the ball or hiding information or withholding information. If I understand correctly, there was a search warrant of the defendant's email, which the state had, and whether the state had a chance to go through it or not, they turned it over to the defense. The defense apparently combed through it and found information that it wanted to use. So I don't find a willful violation there. Is it trivial or substantial? Quite frankly, that remains to be seen, the weight that a jury is going to give to this. Do I think that the email string could be interpreted by Ms. Murphy and Ms. Brown as meaning different things? Could it be received by the jury to be substantial in their decision-making? Possibly. But in the grand scheme of things, I don't find that it was a substantial violation. I find, and I think that this is an appropriate finding, that it wasn't in full compliance with the rules, and I will, as part of my ruling, direct the defense, especially as you embark on the presentation of your portion of the case, that you do comply with Rule 3.220 and your obligations. There should be no doubt now where your obligations are and what they are and what you need to do, and you must comply with that. You must identify witnesses and list them that you intend to call at a trial or hearing, and also identify those documents or tangible things that you intend to introduce. More so than these 12,000 or whatever the number was documents, we could pull something out of there. I think the obligation is different, and I agree with that interpretation of the rules.
So
the final
they turn it over now.
Analysis
Specify
is
now?
the prejudice, and it's not the prejudice we typically think of. The answer is, how would the other side's trial preparation have been different? Certainly, I can imagine the state may have made different arguments. They may have prepped witnesses differently, but at the end of the day, this was in the state's possession from whenever they had it from the search warrant. So I just don't find that there is any prejudice. So that's my findings on the Richardson hearing.
Chalk one up for the
regarding
defense.
the emails.
Chalk one up for the defense.
I had down that I was supposed to do another Richardson hearing, was that the only one?
It was about Faith Brown because she was not listed.
Ah, yes, okay. What have you heard on that?
Can we just have a minute? We were just
Of course.
discussing it.
All right. Here's what those emails say. The defense is alleging that Stephanie Brown, the attorney for Doug Benefield, got on the stand, and you watched her testimony. She was wearing the pink dress. It was a little weird. Her testimony with regard to her being maybe having boundary issues with her client, Doug Benefield. But she got up on the stand, and the state's whole theory, the whole motive that the state is telling the jury that the reason that Ashley killed Doug is because this report of Dr. Broder, this report was going to be released 3 days later on the 30th. And that because of the release of this report, Ashley was afraid or it was going to say disparaging things about Doug. And so she killed him before he could see it. That's their theory, right? So Stephanie Murphy, his attorney, gets up on the stand and she testifies that this is why those reports absolutely were going to be released on the 30th. And then she was questioned by Taylor. And you're saying that is what you believe her motive to be for killing Doug. Absolutely, 100%, without question. Remember, she was very emphatic about that. And then Taylor tried to get some emails and to get her to look at these emails to say, but wait a second, the judicial assistant for Judge Moreland, who was the judge in the domestic case, is saying that that was not going to happen on the 30th, that the only thing that was going to happen on the 30th was with regard to the order of protection. And he tried to impeach Stephanie Murphy, but she would not have any of it. So then what had happened was the next day, Taylor comes in and he says, well, now I want to call in rebuttal to Stephanie Murphy because I think she perjured herself on the stand. I want to call, I forget her name. I forget if her last name is Faith or her first name is Faith, but Ashley's attorney, because Ashley's attorney is going to come in and say, no way, that thing was not going to be released on the 30th. In fact, here are these emails that the state turned over to us that we now want to introduce. And yeah, we didn't specify that we wanted to introduce specifically these emails. However, they turned them over to us and they had them the whole time. What had happened was, that's exactly what, you know what I'm doing. What had happened was, I just went to pay the bill, but then I didn't. And so I get very excited about this. And so those emails apparently are going to show that that was not going to happen. That blows the state's theory of motive out of the water. And in fact, Taylor said he also subpoenaed the judicial assistant of Judge Moreland to come in and testify. And that subpoena was quashed by Judge Taylor prior to the trial, saying, no, you can't call the judicial assistant because that's just going to open up a whole can of worms. But now they just finally won a ruling to say that these emails can come in because the state had them the whole time. Now I think he's going to hear argument about why this woman, Faith, last name, first name, I can't remember, but the attorney of Ashley in the domestic case should not be allowed to come in and testify because she wasn't on the witness list. But Taylor said, but I didn't know I was going to need to call her until Stephanie Murphy, Esquire, perjured herself. Got it? Okay. Hope that made sense. Thanks.
Judge, we've decided not to ask for a Richardson hearing on Ms. Brown. The state's concern was that along with these emails, that it feels a lot like sandbagging to the state or trial by ambush, as I think your judge, as your honor called it. And that was our concern. But in the light most favorable in our mind to the defense, we'll assume that they realized once that Ms. Mechanic couldn't be called, then they listed they were planning to call Ms. Brown. I don't know, because I'm not sure when they thought Ms. Mechanic could be called.
Now that you've had it, and you don't have to respond, now that you've seen my order that has been unsealed, yes, I would think that the way I wrote it would clearly explain that my thought process of who's available to authenticate that email string and where Ms. Mechanic would fit on that hierarchy.
Yes, sir.
And I think that Mr. Taylor is moving along consistent with my order.
Yes, sir.
Although I will say this, while Ms. Murphy testified extensively about the email and the substance of the email, you never authenticated it with her. You never laid the predicate. And I was waiting and waiting and waiting. So
Interesting.
I think she's available to authenticate it, and I think Ms. Brown is available to authenticate it. Sounds like it's going to be Ms. Brown. Sounds like you have the opportunity to depose her this evening.
That's a big win.
Quite frankly, Ms. Brown may have different thoughts on the interpretation of that email, and you'll have the opportunity to depose her before she testifies.
Thank you.
Okay, so to be clear, Richardson withdrawn as to the listing on calling of Ms. Brown.
That's good. That's a good thing. So Faith Brown is the attorney for Ashley. She's going to come in. She's going to testify about those emails. She's going to say that report was not going to be released on the 30th. Vicki Mechanic is the judicial assistant, who I don't think they're going to need now. If they can call Ms. Brown.
Hold off on Mechanic subpoena for now. The argument about it.
Yes.
Okay.
I think so.
They may not
I'm just
need
going
her.
to put that on the back burner for now.
I suspect that's going to be resolved.
Right. It's going to be resolved because Faith Brown is going to testify about those
We still have
emails.
a few minutes. I would like to, at a minimum,
come on, we're done here.
Read my colloquy to Ms. Benefield regarding defendant testifying. I typically will do this in a trial. I'll do it early on, but I know we're a couple days into it. So at least the defendant will know the issues that I will bring up.
Does the court's colloquy include recitation of the penalty?
I don't think so. Let me look real quick.
I like how he
If it
rules from the
does,
bench
Your
too.
Honor, I would ask that you
skip that
respectfully.
Fair enough. No, let me look. I don't think it does. All right, Ms. Benefield, listen closely. This is what you're going to hear me say. It might be tomorrow, and then I'll tell you the questions I'll be asking.
Okay, X, I think maybe you got lost, X. Maybe you're in the wrong place. X says Ashley set her husband up and killed him 3 days before an important custody hearing. She made him believe they were getting back together. Guilty. X, tell me you haven't watched any of this trial without telling me you haven't watched any of this trial. Because there was no important custody hearing taking place in 3 days. In fact, that hearing was with regard to the domestic violence order of protection. And what the state's position was, that it was not a custody hearing either, is that Dr. Broder's report was going to be released on that day, and that has just been disproven as well. So X, I think you might have more fun over in the law and crime chat and or some other chats that we've heard about. X, time to go back to X. Bye-bye. Ta-ta. Scott, would you like to give X his or her boarding pass? Thank you so much. Peace.
It might be Monday. I don't know. One of the most important and fundamental constitutional rights you have is the right to remain silent and not testify in this case. You cannot be compelled to testify. That is, the state cannot call you as a witness. It's your decision and yours alone whether to testify or not. You should speak with your attorney about your options and the positives and negatives and benefits and risks with testifying in your own defense. For example, your testimony may provide facts that would prove certain affirmative defenses or allow your attorney to make certain arguments in your defense. But if you testify, the prosecutor will have the opportunity to cross-examine you, just as your attorney has had the opportunity to cross-examine the state's witnesses. For example, on cross-examination, the state would have the opportunity to impeach your trial testimony with prior inconsistent statements that you may have made in the past, or any of the other ways that are allowed by Florida statutes to impeach. I would normally then go into prior convictions, but those don't apply in this case, so I'm going to skip that whole section. It's important to listen to the advice of your attorney about whether to testify or not in this case, but as I said a moment ago, the decision is entirely yours and yours alone to make. So your attorney may advise you that you should testify, and you can say no. Or your attorney may advise you that you should not testify, but you can. If you choose to testify, I will instruct the jury to consider and weigh your testimony and credibility as it would every other witness in this case. If you choose not to testify, I will instruct the jury that they are not permitted to consider the exercise of your right to remain silent as any evidence of guilt or let it influence their verdict in any manner whatsoever. And then the questions will be along the lines of, have you had, not that I won't want to know anything at all that you've talked about with your attorney, but just confirming you've had time to consult with your attorney and make this decision. What is your decision? Confirming just sort of like a plea that you're not under the influence of any alcohol or drugs. You understand what you're doing. You're not being forced, threatened, or coerced to to take this case to trial.
Judge, I have to tell you honestly, no disrespect intended. I think it's intrusive into the attorney-client relationship. I have, as a professional, discussed this matter with my client. My client trusts that I have her best interests at heart. And I think that this unintentionally potentially drives a wedge between my relationship with my client.
Do you have case law about that? There's cases out there that talk about the colloquy with the defendant regarding testifying or not testifying.
I don't have a problem with you advising Ms. Benefield that she has the right to not testify and the equivalent right to testify if she wants. I even don't have a problem with you saying if she chose to testify, then her credibility gets put in evidence like anybody else. I start getting uncomfortable when it goes beyond that. I begin to feel that it is an unintentional intimidation of a woman who has made a choice or is in the process of making a choice after consultation with her attorney. And this is just piling the pressure on the client. I'm sorry, Your Honor. I find it uncomfortable.
Got a good point.
You wouldn't be heard for that. I mean, it's my
I
decision.
would like to be heard. I have heard this colloquy dozens and dozens and dozens of times. And the fact that the defense acts like this is somehow wrong or intimidating.
Listen to the way she sounds as prosecutor. She sounds like a bully to me. I think this defense attorney got up and said, listen, Judge, I've had a discussion with my client. She's in the process of deciding whether or not she wants to testify. But she's a very fragile person. She's a victim. She's a survivor. And if you start going too hard on her, you're going to make her rethink her thing. Maybe, she's fragile. She's in a fragile state right now. It sounds like normal procedure, but I think he's saying you don't need to go so hard on her. But let's hear this prosecutor, who I think sounds like a bully. You can tell me if I'm being too hard on her. See what she's got to say.
Is offensive. And it is not about what Mr. Taylor is comfortable with. It's about what the court is comfortable with at this point. And what is important is that we find out what is in the mind of Ms. Benefield when she makes the decision. That is not for Mr. Taylor to speak. That is for Ms. Benefield. So she needs to know everything that the court is going to do in its colloquy, as we do with every defendant in this position, just like everyone else.
All right. I guess when we get there, I'm going to tell you what I say. And if you instruct your client not to answer, that'll be fine. I think I've shown that I don't get too upset when people disagree with me. So if you say, hey, don't answer that, okay.
Oh, so he's going to ask her questions and she needs to verbally answer. Okay. This is interesting. Let's see where he goes.
But I'm going to have it on the record because in the future, if anybody says, oh, I didn't know, I thought I couldn't testify. My lawyer told me no. I mean, the plethora of cases that are out there, I think the case law supports a colloquy with the defendant regarding the right to testify and the right to remain silent. So I'll ask, make sure that nobody's threatened you, forced you, or coerced you to make this decision. That nobody's promised you anything, any benefit or a particular outcome to make this decision, that you've made this decision freely and voluntarily. That is, it's your decision and your decision alone. If your choice is to testify, I'm just going to ask you if you've had adequate time to prepare with your lawyer for that testimony, and then I will make my findings. So that's what I do. So I'm glad I brought it up. That way you're aware of it. And if you decide not to answer any of those, that'll certainly be your prerogative. So we'll have that, like I said, we'll have that. I want to let you know about it, and then we'll have that conversation either tomorrow or.
Mad 962, they're doing it now because it's, generally it's done before the defense starts their case and before she would have to testify or be called to testify or have the choice to testify. And that's why they're doing it now. They wouldn't do it before the prosecution starts their case because that would not be the time when she would have the opportunity or choice to testify.
Next week. All right, anything else? That was everything on my list.
I have one matter about an ex-party brief discussion I had with the court, and I supplied the court with some case law to support my position, and I'm hoping that the court will, now that the defense case is starting, I'm hoping that the court will give me some response.
All right, well, I think whenever you had approached me about this case that you gave me the other day, ex parte, without going into the details, my answer was, I think that the state has every right to be heard on this request. So I will leave it to you. Do you want to talk about it?
Fair enough. Can you give me a moment?
Of course, absolutely.
A little bit behind.
Judge Whyte, we're good. Request withdrawn.
Okay. All right. Anything else we can talk about today? No?
What time are we starting tomorrow? 9, she just went back.
Where's my list going? Let's shoot for 8:45, just in case there's any last minute stuff. And then with the goal of starting at 9.
And is the plan then to have testimony all day?
Yeah, I think so. Right? We're gonna have them lined up one after another, ready to go?
Didn't they already tell the jury not to come back until like 12:45? Uh-oh, isn't that going to be a problem? I thought they told the jury not to come back until 12:45 tomorrow.
Okay.
Okay, now I'm confused.
All right, we'll be there off the record until tomorrow morning.
Thank you, Judge.
All right, 8:45? I thought he said come back at 12:45 because we're going to do hearings in the morning. Well, I hope they all get there in time because I was thinking, okay, good, I'll take the morning off. We'll discuss the rulings when in the afternoon, but I don't know. I'm going to have to go back and watch. They changed it? Okay, all right, they changed it. 8:45. Oh, look at me thinking I'm going to get a morning off. Who the hell do I think I am? Becky's Blue-Eyed Paranormal. He didn't have money. Of course he wanted her. She had money. Did she have money? You talking about Ashley? Thanks, Becky. For super chat again. Gail Grace, thank you for the $10. Appreciate you so much. Blessed Mom from Texas, thank you. I'll send Cash App. Oh, thank you. I'm getting really outraged at prosecutors not wanting justice, but wanting a conviction. I am outraged. And then Blessed Mom from Texas is amazing. Sends another 10. Chat. I'm the queen of caps, but they are not allowed in chat. Before you get upset, almost all chats do not allow. Love to all. Let's all get along. Like, hit the thumbs up, sub up. It's free. Hit the bell. Stay classy. Thank you. Wendy, thank you so much for the 10. If the state has the same information through deposition or email that the defense has, they would have known Murphy was potentially going to perjure herself. In fact, they're the ones who turned it over to the defense. They had it all. I mean, what are they saying? That's too voluminous. They didn't want to go through it. They prepped Murphy. It is the Wild West out there. Thank you. Thank you. Oh, thanks, I Am Titanium, for giving me a 20 for coffee tomorrow morning. Thank you. Thank you. Thank you. And also thank you to Suzanne, who says through Cash App, sends a 20 and says for the best mods in chat. Thank you, Suzanne, so very much for your very kind donation. Stephanie, thank you for your Venmo. And Maria says, thanks for a great community. Thanks for the Venmo. And Anne says, your legal advice is spot on. I'm not giving legal advice, Anne. I'm just giving legal commentary, but thank you so much as well for the Venmo. And you guys are pretty awesome. I'm sure somebody sent me some coffees too. So let's just see. Mo, thank you for the matcha latte. And Donna, thank you for buying me 3 matcha lattes. You are all so very kind and generous. Wow, what a day. Thank you so much, Stephanie. That's a very generous Venmo that you said. She says, great work on the trial. Thank you. It is, there was a lot today. I mean, how do we even recap the day? Can we recap the day? I don't think we need to recap the day because you all were here for it. You were here for it. You lived it with me. I would be really, really happy. Thanks, Scott Messerschmidt, one of my amazing moderators. If you'd all hit like to push the video out, it helps that algorithm. Helps the algorithm in the old YouTube-ish type world. They like all those YouTubey things. Thank you to my moderators for keeping the chat classy today. I know this has been a very, very long day. And to my channel members, viewers, replay viewers, love you all so very much. You want me to recap? 8:45 tomorrow. I mean, we started off the day with Eva Benefield having to get on the stand to explain herself about giving a interview to a reporter yesterday, and also to the reporter who I feels like I can't believe this was this morning already, that there was a reporter who contacted the court by attorney letter and said, I saw a juror in a deli yesterday, and there were some people talking about the trial, and he overheard the conversation, and the trial was on the TV. So the judge called in every single juror and questioned them about it. And one of the gentlemen said, yes, he said, that was me. But I left right away. I felt uncomfortable, and I got my food and I left. Olivia wanted to know if I thought that Ashley was going to testify. I don't know. I still think at this point it's going to be a game time decision. Saw that the chat was split on that, about whether or not Ashley would need to testify. It's going to be a game time decision, I think, for her. And I don't know. I feel like based on what we heard from Jules today at the lunch break, the jury may really need to hear from her, and she may need to tell her story. I feel like she's fighting for her life, because if this goes south and she doesn't testify, she may always say, I should have testified. Why didn't I testify? I don't know. It's so hard. A lot of people think she should. A lot of people think she should not. I don't think they've proven their case. I mean, if there was ever a time where the motion should have been granted for the motion to dismiss after the state rested their case, I mean, that could have been the one, especially since the burden shifts the prosecution to prove that it was not self-defense. We saw a lot of weird text messages back and forth between Ashley and Doug. Doug was a fan of sending Ashley a lot of biblical verses every morning at 6:45 that a lot of people thought were controlling and made them feel uncomfortable. So that was the first witness that we saw. BRIIAN QUILES, he was the cell phone expert who used Celebrite to extract the data from Ashley's cell phone. But all of the text messages, there was nothing nasty. Ashley never sent a nasty word to Doug in any of those text messages or WhatsApp messages that we saw. And then when the defense wanted to cross-examine that witness on the Google searches that Ashley made, they were shut down. And I thought they made a great argument, but those Google searches were about Ashley Googling things like how to co-parent with an abusive partner. And she Googled a bunch of things a couple of months before the shooting that we think may have gone to her state of mind, or the state of the relationship, or fear, or a lot of things. He would not let them in. The judge would not let them in during the prosecution's case in chief, but said he would decide on it later during the defense's case in chief. Things like, how do I co-parent with an abusive ex? I guess I didn't write them all down. But in any event, those were not allowed in. Then the next witness we heard from was Dr. VEGA, the chief medical examiner, who told us that Doug was shot in the right nipple area, the front of his chest. That bullet lodged in the back of his back. It didn't come out. The other one went through the back of his calf and out towards the knee. So that was very interesting testimony, which we thought was mischaracterized pre-trial, where everyone was reporting that he was shot in the back. And we now know that that is not true. We also know he was 5'9" and 169 pounds at autopsy, We then heard from Daniel Hausdorf, who was with the Florida Department of Law Enforcement. He was the crime lab analyst who spoke about the firearm and the bullets. And we knew that, she shot him with that gun and those were the bullets. And he, clarified all of that or gave credence to all of that. And then the state rested. And then we heard the motion to dismiss, which I thought was an excellent argument, excellent legal basis, but alas, that was also denied. So tomorrow, the defense is going to start their case at 9 a.m. So we'll see you at 8:45. Initially, they told the jury to come back in the afternoon, but guess that was changed. So tomorrow, the defense is going to start their case. The defense thinks they will maybe be done in 2 days. This is one of the fastest trials ever in a murder case, a felony murder case. This is crazy, second-degree murder. Dr. Quintal was done yesterday. Yeah, he did not testify again after the judge sent the jury out. I think they just dismissed him. I think it was over after that, right? Thank you, Corn Pope, for asking that. But they never did call him back in. Defense will start their case tomorrow. It will take maybe 2 days. So the jury, then they may have closings on Tuesday. This case may be over by Wednesday of next week or Tuesday of next week. Cousin Tommy, Lauren says, I just went back and watched the end of Cousin Tommy's testimony. He was released from his subpoena. Yeah, we figured that out earlier this morning. We were wondering why he was on court TV last night and also the same night that he testified, because he's still out there spinning a narrative. And some of us think that he may have had some ulterior motive in his messages to Ashley. And that is where we are ending for today. We're going to wrap. It's been 8 hours. Please hit the like button, share this stream out. Let's help the algorithm. Let's let everyone who is a survivor know that this is a safe chat and a safe place to share your stories and to talk about things that have happened to you, because I think this chat has a better understanding of what perhaps Ashley went through than most other chats out there. I'm not talking necessarily about the creators, but about the chats, because I've seen them. Peace, my friends. Remember, be cool, be kind, be classy. It is not hard, really. It is so not hard, I promise. Have a great night. I'll see you in the morning.